Good morning. Welcome, everybody. Welcome back to the inquiry. I particularly want to welcome you back today to the beginning of the end, because that's our intention. So today is about that. For this process that we've gone through. But months later with that. But we welcome all of you honorable members, those of you here in 146, present members on the virtual platform. I also want to welcome as our leaders, whose role is critical for the exercise that we'll be doing today. It's exactly their role that we assigned to assist with. We want to welcome members of the media who are with us, members of the entire support staff. This last but not least, as we're doing a different process. Hope that everybody can hear on the virtual platform. Honorable Heron, your hand is up.
Yes, sorry, Chair, but the sound quality is very bad from there.
Okay. I will have to start again. I'll give me a few minutes so that we can fix it. Thank you for bringing that up. I'm still also this morning to check whether it's better before we do it and start. So,
Recording stopped.
Chairperson. Chairperson.
Honorable Hermans and Honorable Heron, can you hear me? Is sound better?
Yes, Chairperson, it's better, but I think the camera must be adjusted because
the
it
sound
looks like you're
better?
going to slide off the screen.
We can't hear
Chairperson,
you now.
okay, because I'm speaking.
You see, either you are far from the mic. Let's check. Honorable Heron.
Chairperson, I can hear you and I could hear Honorable Hermans very clearly.
Honorable Heron is much better. We have to fix something there, Honorable Hermans. Let me check another member. Honorable Dana.
Chairperson, I can hear you much better now. Thank you. And good
Okay.
morning.
Thank you. Honorable Majosi.
Chairperson,
I can hear you, Chair, loud and clear.
Thank you. It looks like
Recording in progress. And I can see it on my ask the system to fix that.
that sounds like Honorable Heron.
The sound quality is gone again. I think as soon as it said recording in progress, the sound quality changed.
Okay. IT, please. I know we have not been doing this for a while now, but there's no reason why we can't get it right. So we just need to quickly start.
Chair, please ask IT to adjust the angle of the camera because I don't think it looks good out there to the rest of South Africa with the screen being at an angle.
Okay. Camera, I don't know which camera. Is this the one? Where must it be? I'm here, yeah. Okay. Thank you, Honorable Hermans. We are fixing those as well.
Recording stopped.
Ask explain the Honorable Hermans. Let's look better.
Chair, it seems like you are going to have to be sitting at the angle today. It's still like that. It looks like you're going to slide off the screen.
Is the sound better?
The sound is better, yes.
Recording in progress.
Now that the recording is in progress, is the sound okay, Honorable Heron?
It is better. Thank you, Chair.
Thank you. Just starting to the time, hopefully by the end everything will be sorted out.
Recording stopped.
Chairperson. Chair.
Honorable Saule.
Chair, thank you. I think there's something we can live with. From where I'm looking, we can live with that.
It means we are small and there's no problem. Thank you. I'm just waiting for the secretary to understand. Thank you. Okay. And still work on it throughout as you start, so. It's something more important than the move. We can fix that. I don't know what happened why you lost it. We never had this before.
Sorry, Chair. Sorry, Chair, the sound has got worse and the picture's got worse.
Thank you for keeping us updated on where I was just trying to start, but when you say the sound it's gotten worse, then it's going to be difficult to figure. Yeah.
Recording in progress.
Honorable Hermans,
I think I think we must live with the picture, Chair, as Honorable Crowley has said, but the sound seems to be better.
well, let's do that. You can't make the chairperson look good if it doesn't look good. That's what I want to achieve the picture.
And the sound is worse now. I think you must actually take a break and sort out with IT.
Okay, that's a suggestion. 5 minutes for um, just to let's see. Thank you. So unbelievable.
Recording stopped.
Sepo, aye.
And with Ephraim,
Do you hear me loud and clear?
I can hear you. I don't know if you can hear me.
I hear you loud and clear. Now I'm trying to figure out when they say this, when there's the complaint of audio. I'm not understanding what
The
what-
members
because
were mentioning that every time we record the meeting and it says recording started, sound seems to just drop.
Are you able to mimic that? Are you able to start your recording?
Let me record now and let's see.
Recording in
Thank you.
progress.
Say something now.
I'm talking to you. Can you hear me loud and clear?
I can hear you. Can you hear me?
I can hear you loud and clear.
Chair, I think you can check with the members.
We're back. Honorable Heron, is both the sound and look better?
Yes, sir. Thank you.
Thank you, Honorable Heron. Honorable Hermans.
Yes, I think we can live with it. It's still not perfect, but it's fine. I don't know what's going on today.
Doesn't sound like a confident voice, but it's okay. Thank you. Okay. We will start now. Again, welcome to everybody. Good morning to honorable members, both here at M46 on the virtual platform. Want to welcome you, as I indicated, we are welcoming you today to the beginning of the end of our process. The media present with us. I also want to acknowledge and welcome the evidence leaders who have been specially invited to be present in today's session to assist the members in our exercise on item 2. Want to welcome the entire support staff of the inquiry. And lastly, but not least, to also welcome members of the public in their various platforms, YouTube or 408, whichever is available. It's the 28th of July, 2023. As we agreed on our revamped program, we have set aside this day to the day that the members get into deliberations and do their draft report as mandated by the National Assembly. We have 2 items on the agenda. One being the item on the recusal application and response. And the second item, which is the main item, which speaks to the entire mandate of this committee, is the issue of the draft report. And that can be dealt with later, but let me start in saying just upfront, appreciate everybody's work and patience as we go through this work. I just want to get straight to the first item, where you would have received a recusal application for the removal of the chair as a chair and from the committee. You are aware that in our meeting in June, I would have indicated which you also agreed to that we will welcome that if there will be any recusal application, and we indicated that we would prefer that it be in writing and would respond in writing. I therefore have received and I indicated in my response from the day when it was mooted, from the day when it was initially raised, it would have been about 5 weeks, the time when I actually received the recusal application. I had my mind, went through it, asked for further information, including recordings, and got a response that there's nothing more than what would have been sent to me. And that as such would have delayed to get a response from the initial date of the 21st. Having waited for those recordings and further responses, finally responded on the 23rd. Today, that response to the recusal application is going to be taken as read and as presented. I don't need to repeat that as a chair on the issues that were directed at me. I found the recusal application without any merit, and have therefore declined to recuse myself, as you know by now. It is now the opportunity of the committee to comment on that and take a decision whether the committee decides to remove or not to remove the chair. And the chair of this committee would have been elected by members. And so before we proceed to any other matter, I am now going to invite members who wish to offer comments on this matter. Perhaps for a limited time, then we'll take it from there. Thank you very much. Are there any members who want to raise anything or make any comments in relation to both the recusal application and the response to that recusal application? Thank you. I note Honorable Kabude, followed by Honorable Ngola. Are there any members on the platform who wish to contribute? Honorable Manami Smith. Any other member wants to speak on the matter? I see no further hands on the virtual platform. We will proceed in that manner, and then I have a last hand here. By Honorable Manini. Those were the okay. Thank you. Honorable Zahut.
Thank you very much, Honorable Chairperson. Good morning to you, the evidence leaders and my colleagues both in this committee room and also on the virtual platform, and everyone else who brings us with your presence in this meeting. Honorable Chairperson, let me start by saying that as a committee, we reject this application with the details that represents. The issues that are raised in the application do not belong to this committee. And we have said many times that whoever have anything, evidence or anything, they must take that to the relevant authorities or to the relevant institution. As this committee, we assist them with the responsibility to deal with the inquiry into the figures of the head of the chapter 9 office. So we cannot be dragged into something that doesn't belong to this committee. So I want also to say that we support the responses that you have given we support your responses to this application and say that we cannot waste more time and deal with something that belongs to this committee. I submit to Honorable Chair.
Thank you, Honorable Kagode. Honorable Mwana.
Thank you very much, Chairperson. I wish to confirm that we have received with the application for the recusal in the public protector and the response to that particular application. We have acquainted ourselves with the contents of the application together with the response to such. Which I think it is important to note that what is said to be an evidence that is linking you to a perceived soliciting of a bribe or extortion and everything else is quite ambiguous for the committee to make a link of your participation or your alleged participation into what is perceived to be a soliciting of bribe and some sort. Because as when you analyze and see what is being submitted in terms of the recusal application as reasons for your recusal, is that they still until today we've been waiting. That links you to having communicated and solicited a bribe from Mr. Makosan. And two, there's an allegation that a particular member of the committee was instructed by you to go and do those things. But until today, there is nothing that proves that you have indeed issued instruction that someone must go to a particular Mr. Makosan and solicit something. So from where we are seated, we are saying there is no merit, there is no tangible evidence that actually links you to what is said to the public as a okay, sorry, the deputy chief is giving me a note that it's Mr. Kosan, not Makosan. I apologize. I sincerely apologize. So there is no tangible evidence that links you in that ambiguous submission of what is said to be the evidence of a bribe being solicited. Beyond that, I think it is important to note and say here that we won't allow the committee to be deflected on calling people to address the committee on things that have got nothing to do with this committee. Anyone who wishes to address issues in relation to an alleged bribe, extortion, and the sort must go to the relevant institutions and address them. We are not here to deal with issues of such kind. we are here as mandated by the National Assembly to deal with issues relating to the fitness of the public protector to hold office. So we won't allow anyone to come here and address us. So we're proceeding with the business of this committee without having to be deflected into issues. Was the next day will be called to address issues of electricity in Kylie Child's committee. And we won't be able to do that because we would have deflected from what the National Assembly has given us to do. Lastly, Chair, I hope and I wish that this closes the chapter that we want to go outside and validate our opinions using the passing of Honorable Tina Joemat-Pettersson. It's un-African, it's inhuman, it's cruel, it's barbaric. That we want to validate our opinions and our views using the untimely passing of a member of parliament without giving regard to how the family might be feeling about that. They are still in the morning faith and we're busy parading outside trying to make our opinions valid and on point using an untimely passing of our own code. So I think it seals it. It must not happen again. We are closing the chapter. Thank you very much.
Thank you, Honorable Olamola. Honorable Jane.
Thank you, Chairperson, and good morning, colleagues. Chair, one would want to actually welcome and acknowledge.
I go with you. Just a volume, please.
Chairperson, I'm not sure why you can't hear me.
Now we can hear you properly.
Okay, all right. Thank you, Chairperson. I was saying that one would want to acknowledge and appreciate your work in terms of responding to the allegations and your recusal. And I would want to support what has been said by two members who spoke before me to say that this matter of allegation doesn't belong to this committee. Let the matter be handled by law enforcers as previously advised by Honorable Maneli to say that if there are issues of this nature, they need to be referred to law enforcement agencies so that they can be taken care of. So one would want to agree that we want to reject this particular recusal because this is not the first time that we've been dealing with it. I thank you, Chairperson.
Thank you, Honorable Mananiso. Honorable Maneli.
Thank you, Honorable Chair. Chair, I think because points have been taken already, it is just to emphasize the point of thanking you for responding. Yeah, because initially it was like you did not want to respond. So we must thank you for responding, and from where we are, it then closes the issue. For anybody who wants access to be heard on the matter, there are structures to go to, but not this committee. And I think in the way you've responded, Chair, you've demonstrated that you've been fair in the way you've handled the issues. Vice Honorable Ngola has indicated that we may be expected sometimes to look at some problems in Khayelitsha which are not in the purview of this committee. We should also thank you, Chair, that you took steps even on matters that really did not have to be dealt with by this committee, whether it was about non-payment, whether it was about getting additional funding. We knew that that belonged elsewhere. But those initiatives were informed by the fact that we wanted this inquiry, its work not to be hampered, and that it can do its work within reasonable time, as expected by the National Assembly. So I want to thank you for that and indicate that we still remain confident that you are in the correct position
to complete the task that has been started by the committee under the stewardship as the chairperson elected by this committee to chair us. So we reject that has been put, including any other additional request to have access to the committee and listen to a point that has nothing to do with the work of this committee. So we think it ends there, Chair, so that we can get to the real business of the committee. Thank you, Chair.
Thank you, Honorable Negi. Now recognize Honorable Joseph.
Thank you, Chairperson. Can I please keep my video off? I'm experiencing load shedding.
Yes, please go ahead.
Yeah. Okay, thank you, Chair. Good morning, all honorable members. Firstly, let me just say we reject the application for you to recuse yourself. And I think we have raised this before, Chairperson, that these are other delaying tactics that we must not finish with this inquiry, and it must not have a report up until a certain time. I mean, we can all see that now. And it can be that when the proceedings must take place, there's no money to pay the legal counsels. But when letters of application are written, there is something, because you must apply and then you are charged. But then with regards to anything that was written in the application, we reject it. Chairperson, we believe that we must continue as this committee as we're mandated. We're given a mandate, one mandate only, and let us continue on that and focus on that only and let go of other things. If there's any letter of application, can we defer it to the relevant structures and tell them that no, this must go elsewhere, it can't come to this committee, because here we are going to deal with one thing only. I think I agree with every member that has spoken before. We are on the same path. We reject the application. Thanks, Chairperson.
Thank you, Honorable Majosi. Now recognize Honorable Enquiry.
Thank you, Chair, and good morning to honorable members. Chair, is two things for me. Like honorable members are indicating that this matter has been before the committee. It's not the first time, and you have indicated that there's not even anything new on the submission. One, Chair, I agree with the honorable members that this does not belong to this committee. Two, it's not within our competency as members who has been delegated or appointed by the Speaker for Parliament to carry out, to come here and remove each other. It's not within our competency, Chair. And I would agree with members that let's move on, reject this one, and continue with the work of the committee. Thanks.
Thank you, Honorable Sabe. That would have been the last member that will stand up on this issue by way of comments and contributions. I don't see any other hands, and I would therefore take it that members are now indicating that they find no need for this matter to be entertained in this meeting and by the committee. And you also are saying you have no reason why you must remove me if I get properly. And therefore the decision is that, as you have raised, that if there's a grievance, that grievance must be sent to the correct address. That section 194 is not that address. And you shouldn't be dragged into those issues we must focus on our mandate. You do find it peculiar that as Jones is indicating that sometimes there's willingness to get into the applications, but when it comes to requiring issues, there is no response to those issues. So I think it's fair that I summarize it in that way, that you reject in totality this, and you are advising that if there's going to be any other matter that's been raised here, it must be channeled to where it belongs. That I must not waste your time as a chairperson by bringing to you issues that don't belong in this space. That's the conclusion on that matter, honorable members. I therefore want us to close that matter and therefore proceed to, as I indicated, to the main item of today's meeting, and equally the main item of the inquiry. We have been set up as the Committee of the National Assembly in terms of Section 194, following the adoption of the rules, the report of the independent panel that found that there was prima facie evidence that Ms. Enquiry committed misconduct and that she is incompetent. This committee in its very first meeting indicated that its task is that of doing the investigation, that it was never going to be rubber stamping the report of the independent panel, because if we did so, we would have long finished. Our work would not have taken us so long and up to this point. We are here today on the 28th of July 2023 as a day when we need to be looking at the draft report that we must prepare to take to the National Assembly. Preceding this has been a number of processes as part of our schedule. Having received that independent panel report, the motion itself, we would have drawn out a program that invited 24 witnesses, 18 identified by this committee and 6 by the public protector, who spent hours and days being led in evidence in chief, being cross-examined, and members having asked each of those witnesses questions, all of the 24 witnesses, including the legal team of the public protector. Following that, we then received a very comprehensive response and a sworn statement by the public protector in both part A and B. And we should have done that with having had the opportunity to have listened to witnesses and witnesses being cross-examined, and would have spent 6 days at A of Ms. Enquiry orally amplifying what would have been in part A, even though we did not have an opportunity for her to orally amplify part B, but we have that evidence as the committee. Following that, based on the decision of this committee to abbreviate the process, given the challenges and the offering that it has, and for the chair to have issued new amended directives, we would have outlined a process where members ask further questions, as well as evidence leaders that were put to the public protector, and timelines and dates would have been given, would have indicated to her and given her choices with dates as to whether she would want to do this orally or in writing. Once all questions were collated by the Secretariat and sent to her by the 25th of June, the expectation was around the 6th of July to have responded to all of those questions. The suspended public protector elected not to challenge or respond to those questions. And therefore, the questions posed to her by evidence leaders and members remain unchallenged, even though she had an opportunity to put the other side or respond to some of those. We would have then proceeded to the next task, which was in our program and schedule, where we asked the evidence leaders to do the summation of the evidence of the entirety of the work that we've done. That they have produced and everybody else has received that. Not just members of the public have that. And that summation, true to their role as evidence leaders, remains a neutral summation, which is not indicating whether this should be like this or like that, simply because it is going to be members. It's members who must make the call about what we've been asked to do. We have the summation. Members have gone through that, spent time on it. Today is set aside for us to deal with the draft report. And so let me say upfront, in case members of the media or members of the public or anybody else would have expected that we would present a well-prepared draft report, that would not be the task of evidence leaders or legal advisors. The actual drafting of that report is the duty of the members, which we have called this meeting for members to do exactly that. And I will be giving a guide and leading the members on that important exercise. So if you thought that we're going to say, here is the draft report, it's not going to happen. The draft report is going to be in place after the members have done their work today. I've said this before, that we don't work in dark, smoke-filled rooms where we produce reports. This is a transparent process. This is a parliamentary process. Every step of the way, you're going to follow, you're going to understand why this argument is made, why. If today was saying we sustain the prima facie or not sustain the prima facie evidence of the independent panel, members will be saying that themselves. So this is where we're going to get to now. And perhaps as a start, we thought it would be important that we refresh all of us just about the key steps in the process of where we started, where we are, and remind ourselves about some of the key important concepts in this process, the motion itself, and everything else. And for that, I'm going to be asking the legal advisor to assist us in that reminder. After that, as the chair will come in, lead the members. In the manner we're going to do this, we're going to have to take that motion, those charges as they were agreed to, and we're going to go through this charge by charge, and with members having to pronounce, contribute on all of those, and we're going to be recording every contribution, whether it's something that we agree on, whether it's a dissenting view or minority. All of that are going to be part of the report that we're going to produce. And so without just before I call on Mr. Brian, Mr. Honorable Nyonso, can you mute?
Man, Chair, there's a problem. I'm technologically backward here.
Okay. I'll ask the IT to mute you.
Please, Chair, I've been trying. I see.
I know that this is our intervener back mute and then your indicator. IT, please mute Honorable Nyonso. He's got some challenges there. You are being muted, but not because you did anything wrong. Just to allow you to figure out that gadget of yours. Is he muted? Thank you very much. So when we mute, people must not think that it's a bad thing to do. So we are now muting Honorable Nyonso. Thank you very much. Let me therefore proceed and ask Mr. Brian to just give you context and take you through. This is the journey of child. She will not be raising anything new that you don't know, but it's really meant to refresh ourselves. As we're going to get to the next task, what's the next task that I'm going to lead you through? I want you to be patient. It's going to be a very tedious process. It is necessary that we do that. Those of you who have done in committees issues of legislation where we do things clause by clause, this is not a fancy type of work, nice to do, but it's critical where you look at everything as you do that. But before we get to that, I'm going to ask Ms. Brian to just refresh us and give us a context and remind us about certain things. Thank you. Over to you, Ms. Brian.
Thank you, Chairperson. Good morning to yourself and the members and everybody else that's present this morning. Chairperson, in preparing for the meeting, I thought it might be wise to share my own notes, and this has now been done in the form of an aid memoir that has been circulated to members, and hopefully can serve as a reference guide as members proceed with deliberations today. The purpose, Chair, is not to give legal advice on the veracity of the charges or to deal with any evidence related to the charges itself. That is something that members will deal with themselves in reaching their conclusions. I've also, Chair, in this document, tried to highlight some issues not necessarily related to the substance of the charges themselves that Advocate Enquiry has raised, and that I think it's important that the committee considers for purposes of drafting the report. Chair, by way of background, I'm not going to go into too much detail because, as you said, members would be quite familiar. But in terms of the rules, the purpose of this inquiry was to establish the veracity of the charges and to report to the NA, and to ensure that the inquiry that is conducted by this committee is conducted in a manner that is reasonable, procedurally fair, and within a reasonable time frame. And of course, importantly, to afford the holder of the public office the right to be heard in his or her own defense and to be assisted by a legal practitioner. The committee, as it knows, must now report its findings and recommendations, including the reasons for that, to the NA for consideration and debate. And that debate will be scheduled with due urgency given the program of the NA. And of course, as we know, there needs to be, in the event that this committee recommends a removal, that would need to be supported by a two-thirds majority. Chair, the motion that was submitted on 21 February 2020 consists of 4 main charges and various sub-charges. So it can get a little bit confusing, but we have prepared questions to assist members. So the first one, charge 1, is misconduct in the South African Reserve Bank matter. And that one consists of 9 sub-charges. It has to do with the PP's.
Are you able to show that?
To show the report?
That's all.
Oh, people can put up the AMY, that's fine. And she has no need for the Chair. But it has been circulated to members. The first charge, so I'm not reading from the motion itself. The first charge is the one of misconduct, and that has to do with the South African Reserve Bank matter, as I indicated, and the investigation and the litigation proceedings relating to the review of that report. And Chair, members will know that we've interchangeably referred to that report as the CX report, the lifeboat matter, the SARB report. So you might see in evidence, we would have seen it in the summation, that it gets referred to differently, but it all has to do with the same matter. Charge 2 was the Theatre Dairy matter, and that had 5 sub-charges, and that had to do with report 31 of 2017. Charge 3 was a charge of incompetence, and it alleges incompetence in relation to both the theatre and SARB matters. So whereas charge 1 and charge 2 were limited to misconduct in respect of those 2 matters, charge 3 now raises incompetence in respect of the investigation, the report, and the litigation in those matters. In the SARB matter, there were 9 sub-charges, and in the theatre matter, a further 6 sub-charges. This charge 3, Chair, also deals with the Financial Sector Conduct Authority matter, which is also interchangeably referred to as the Chile matter, and it has 2 sub-charges therein. So this one is dealt with a little bit differently, and members will see that when we go through the questions later. Charge 4 was a broad charge, Chair. It was misconduct and or incompetence. So it was a mixed charge, and it contained 2 sub-charges, paragraph 10 and paragraph 11. The first sub-charge in paragraph 10 is what members would know as the HR issue, which I think the PP has also referred to as the HR issue. And that relates to the alleged intimidation, harassment, and or victimization, either directly or indirectly through the CEO, Mr. Mshlangu, of staff. And in particular then, there were 7 staff members that were named. So Kikana, Mr. Samuels, Mr. Madiba, for example. And that's all listed from 10.1 to 10.7. So there would need to be findings made in respect of each of those persons, and then the question generally as to whether there was victimization, harassment or intimidation of staff, and if so, whether that was by the people or via Mr. Mshlangu. The second sub-charge under number 4 relates to misconduct and or incompetence more generally. And briefly, the first part is management of internal capacity and resources in the PPSA, the prevention of frivolous and wasteful and unauthorized expenditure and legal costs. And members will recall there was quite a debate in the committee as what the meaning of legal cost is, and whether it included legal fees or if it was limited to costs awarded by a court. But obviously that's already included in the summation. Part 3, failure to conduct investigations independently and impartially. And then part 4, deliberately avoiding making findings against or directing legal action against certain public officials, while on the other hand, deliberately reaching conclusions of unlawful conduct and imposing far-reaching legal action in respect of other officials. In support of charge 4, Chair, all of the evidence in the theatre and SARB matters were included as part of the motion. So everything that would have come under charge 1 and charge 2, all of the, in the main, all of the court records. In addition, in support of charge 4, Honorable Mazzoni also submitted evidence in respect of the CR17 matter and the SARS unit matter, which also has interchangeably been referred to as the Doe unit matter. And then also in the GEMS matter. That matter revolved around a complaint by a member of the public against the government employee medical scheme and litigation pursuant thereto. There was no report issued in the GEMS matter. Chair, as we know, the Speaker ruled that the motion was compliant with the NA rules, and thereafter establishing independent panel comprised of Justice Nkabinde, Advocate Nsebeza, and Advocate Deval here at the Cape Bar. Their role, Chair, was to determine whether there was prima facie evidence that Advocate Nkabinde had committed misconduct and or is incompetent as alleged in the motion. The IP submitted a detailed report which forms part of the record, and they found that there was prima facie evidence of incompetence and misconduct in respect of both SARB and theatre matters as contained in charge 1 and 2, incompetence in respect of SARB, theatre, and the Financial Sector Conduct Authority matter in charge 3, incompetence in respect of CR17 SARS unit and the GEMS matter as contained in charge 4, and then misconduct in respect of the Financial Sector Conduct Authority, CR17, theatre, dairy, and the SARS unit matter again in charge 4. However, Chair, the IP did not make findings of prima facie evidence in respect of every single subcharge. But as I've indicated, each charge had various subcharges. In particular, Chair, it's important to note that they found there was no prima facie evidence in support of the so-called HR matters in paragraph 10 of charge 4. Their findings are all summarized in Annexure A of the independent panel report. So if members want to quickly reference where they found that there was prima facie conduct, that can easily be found in Annexure A. That report served before the NA Chair, and as we know, the NA proceeded to refer that report to this committee, or rather the motion, then the report. Chair, the committee, you'll recall, adopted a terms of reference, and we set out, amongst other things, the background to the task, the format of proceedings, including the way in which evidence will be received, matters relating to public participation, transparency of proceedings, and the resources that will be available. There was emphasis on the fact that it's a constitutional process, that is inquisitorial in nature. And we also provided for the appointment of external evidence leaders to assist the committee by presenting evidence and putting questions to Advocate Nkabinde and other witnesses. The purpose of using evidence leaders, Chair, was to empower members and the committee to perform their functions, and the evidence leaders to not play a prosecutorial role in this matter. The TLR further provided that Advocate Nkabinde's audio rights would be cemented by giving her the right to make opening and closing arguments, to cross-examine witnesses, and to raise any matter related to the process, subject to the reasonable time frames as imposed by the Chair. Chairperson, the PT has indeed been provided with an opportunity to make an opening argument, which was done by Advocate Nkoko on day 1. She was invited to do a closing argument either orally or in writing, but as members would be aware from the correspondence that has been tabled, she's indicated that by her attorneys that counsel has not been briefed on the merits of the matter, and therefore these deadlines have not been met and those requests were not responded to. In addition, the terms of reference also provided that Advocate Nkabinde will be afforded the right to comment on the committee's draft report before it's adopted. So once the draft report is tabled, Chair, the report will need to be adopted by the committee as a draft report, then sent to the people for comments, after which the committee can consider those further comments before it adopts a final report for tabling in the NN. The scope of the inquiry, Chair, this has been a contentious issue rather, in that the IP did not find, as I indicated, that there was prima facie evidence in respect of every single subcharge. But what members must bear in mind is that the IP, and I've already advised on this, Chair, was not entitled to hold oral hearings, and its assessment was limited to the written and recorded information that was placed before it. And it could not and did not conduct an independent investigation that could lead to a determinative conclusion on whether or not there has been misconduct or incompetence. The IP therefore did not have the power and could not conclude that only some charges should be investigated for determination by the committee, or that some charges should be excluded from consideration. If there were to have been such an instruction, it ought to have come from the National Assembly at the time when it referred the motion, but the Assembly referred the motion in its entirety to this committee. And in fact, Chair, the independent panel noted in its report that it stresses from the outside that it's not tasked to conduct a Section 194 inquiry for the removal from office of the people. That task is for this committee. Here, the committee is therefore duty bound to consider all of the charges and to make findings in respect of all of the charges as contained in the motion, and not just the charges where the independent panel found that there was prima facie evidence. I have listed it there for easy reference for members, but this is basically what is contained in Annex A of the report. Chair, I'm going to move on to the constitutional provisions, particularly with public protector, just to give members a quick reminder. As we know, Section 181 establishes the public protector as a state institution strengthening constitutional democracy in the Republic. They are colloquially referred to as Chapter 9 institutions, and these institutions are governed by the following important constitutional principles. One, they are independent and subject only to the Constitution and the law. They must be impartial and must exercise their powers and perform their functions without fear, favor, or prejudice. Other organs of state, through legislative and other measures, must assist and protect these institutions to ensure the independence, impartiality, dignity, and effectiveness of these institutions. And importantly, no person or organ of state may interfere with the functioning of these institutions. These institutions report to the NA on their activities and the performance of their functions. And of course, we know that the Office of the Public Protector also reports to the Justice Portfolio Committee in terms of the oversight responsibility. The functions of the Public Protector in particular are captured in Section 182 of the Constitution. The Public Protector has the power to investigate any conduct in state affairs or in the public administration in any sphere of government that is alleged and suspected to be improper or to result in any impropriety or prejudice, to report on that conduct and to take appropriate remedial action. Chairperson, as members will know, that remedial action that the Public Protector may take is now binding following a ruling from the Constitutional Court in that respect. The Public Protector has additional powers and functions as prescribed by legislation. The Public Protector may not investigate court decisions. The Public Protector must be accessible to all persons and communities, and any report issued by the committee must be open to the public unless exceptional circumstances to be determined in terms of national legislation require that the report be kept confidential. Members are aware that the term is a fixed term of office of 7 years, and currently this term comes to an end in mid-October. Section 193 of the Constitution deals with the appointment of office bearers, and the Public Protector in particular must be a South African citizen, and importantly must be a fit and proper person to hold that particular office. So the removal deals with this issue of whether the person is fit and proper, and the person who has committed misconduct and has otherwise proven to be incompetent, then would follow that they are not fit and proper to hold office. Section 194 of the Constitution deals with removal, and it states that the Public Protector may only be removed on the ground of misconduct, incapacity, or incompetence. A finding to that effect by a committee of the National Assembly, and that will of course be this committee, and the adoption by the Assembly of the resolution calling for that person's removal from office. Members will recall that Advocate Mpofu did argue in his opening address that this committee is not that removal committee, but if I recall correctly, I think I had advised at the time. The Constitution did not define misconduct, incapacity, or incompetence. And in fact, that was one of the reasons that it was then necessary for the NA to issue the removal rules. The removal rules define incompetence and misconduct. Misconduct is defined as the intentional or gross negligent failure to meet the standard of behavior or conduct expected of a holder of public office. And Chair, this is important because whilst the constitutional definition merely referred to misconduct, the rules have taken it further and said it must be gross misconduct, as it were. So the threshold in terms of the rules for removal is in fact slightly higher. It would therefore be necessary for members when establishing whether there is misconduct to ask these important questions. What was the standard of conduct or behavior expected of a person in the position of the public protector? Did Advocate Mfwebani meet that standard? And if not, was her failure intentional or grossly negligent? In other words, it's possible not to meet a standard, but there can still be a finding that the failure wasn't intentional or grossly negligent as required by the law. Chairperson, the issue of intention is obviously subjective, and it's concerned with what that individual in question would have personally understood would happen in circumstances. And in law, intention can take one of three forms. The first is what we refer to as dolus directus, and this is where the individual deliberately aims at causing the consequence in question. So the example cited here is when X fires a gun at Y with the intention of the bullet harming Y. So in other words, I now know that the result of this will be that the person will be injured. When the individual aims at causing a particular consequence, but knows that another consequence would be inevitable. For example, X fires a gun at a cardboard cutout with the intention of putting a bullet hole through the cutout, but they know that somebody is standing behind the cutout, and that person is obviously then going to be injured. And that would be called dolus indirectus. And the third type of intention is where the individual aims at causing a particular consequence, foresees the possibility that another consequence could result, but reconciles himself to that possibility and proceeds anyway. So in layman's term, the person takes the risk as it were. So using the same example, X fires a gun at the metal pole with the aim of hitting the pole. He foresees the possibility that the bullet could ricochet and hit Y, but he reconciles himself to the possibility that Y could get shot and fires the bullet anyway. That's dolus eventualis. The test for negligence, Chair, is something that must be assessed objectively, not based on what a particular individual thought or understood, but based on what a reasonable person would have understood and done. The public protector would only have been negligent if a reasonable person in her position would have foreseen the possibility of certain consequences arising. The same person would have taken reasonable steps to guard against the consequences, and the public protector has failed to take those steps. Again, the threshold being high. Gross negligence occurs where there is an entire failure to give consideration to the consequences of one's action. In other words, an attitude of reckless disregard of such consequences. In terms of incompetence, the inner rules do not provide an exhaustive definition of incompetence. The rules rather define incompetence as including a demonstrated and sustained lack of knowledge to carry out an ability or skill to perform his or her duties effectively and efficiently. Sustained, of course, Chair, is something that we need to be considered within the context. There's not a number that can be put to the meaning of the word sustained, other than to say it would have to have been obviously more than one incident. The fact that an action may have been incompetent, or even two actions may have amounted to incompetence, doesn't necessarily make the person incompetent, which is why the rules talk of a demonstrated and sustained lack. In respect of incompetence, again, the committee would have to consider what Advocate Mfwebani's duties were and whether she displayed a lack of knowledge to carry out those duties effectively and efficiently. And whether she displayed a lack of ability or skill to perform those duties effectively and efficiently. And was the lack of knowledge and ability and skill demonstrated and sustained? So we're not looking for one-off examples. The test and threshold for removal. The definitions of misconduct and incompetence in the rules must be understood purposefully. There are threshold requirements for determining whether a Chapter 9 office bearer who has constitutionally infringed independence and fulfills the vital function of ensuring accountability in the public sphere should be removed from office. So people in these positions cannot be removed willy-nilly. The test and the threshold is high. It's a serious matter. Accordingly, to ensure the proper functioning and protection of Chapter 9 institutions, a high standard should be adopted by the committee. Incompetence or misconduct should not lightly be accepted as having been established. The committee is exercising the public power in that it's making a finding and recommendation to the NA on whether there are grounds justifying the removal of the PP, and therefore this exercise of power must be rational and not arbitrary. Rationality can be understood as a rational relationship between the measures adopted and a legitimate governmental purpose, with cause for an objective inquiry. So, Chair, whilst there's been criticism of the fact that the inquiry is political, members will recall that when I did, or perhaps they won't, but when I did my very first presentation to the committee, I indicated that as much as it's a constitutional process, it's also a political process. That is the nature of Parliament, that you are sitting in a multi-party committee. But unlike in a situation where a committee or members of Parliament are deciding on a policy matter, over here, members need to show that a decision that they've reached is a rational decision. It's not a matter of preference, whether a member feels the PP should be removed, or whether the member has any personal feelings on that issue. The member must be able to have established, or the committee must have been able to establish on the facts report and on the evidence that it's considered that there are rational reasons that support a finding of misconduct or incompetence. Chair, the question is how does the member or the committee consider or make a rational finding? And the rationality entails a consideration on the one hand of the evidence that's been before the committee, vis-a-vis the standards of conduct expected of public protector, because of course you need to measure what the evidence tells us against what a person in the position of the public protector ought to have done, a reasonable person in that position. And for that purpose, Chair, the committee will recall that 2 witnesses were called, and I'm not going to call them expert witnesses because the committee knows that there was some debate as to whether they were experts or not, but be that as it may, there were 2 witnesses that spoke about the roles and responsibilities and the protection that should be afforded to a person in the position of public protector, and that was Mr. Hassan Ibrahim and Ms. Zulu Sikoni, the Ombudsman of Zambia. Now, Mr. Ibrahim proposed 47 obligations that a public protector must comply with in the discharge of their office. And this was done with reference, members will report on his testimony on the applicable legal framework, including the constitutional provisions, the PPA Act, the case law, and so on. And in terms of those 47 steps, and it's important that members apply this when considering the evidence, is that a person in the position of public protector must respect the supremacy of the Constitution and the rule of law. They must strengthen constitutional democracy, focus on ensuring the discharge of public functions that is accountable, responsive, and open, respect the separation of powers and the legitimate sphere of operation of each branch of government, and in so doing, respect the decisions of the executive, legislature, and judiciary, be independent and impartial, and perform functions without fear, favor, or prejudice, be dignified and effective, be dedicated and conscientious, discharge functions diligently and without delay, exercise only those powers that are conferred by law, not assume the powers or functions of any other public functionary, or encroach on its integrity, be accessible, sorry, I've lost my space. Adhere to a high standard of professional ethics, ensure the efficient economic and effective use of resources, ensure that services are provided fairly and without bias, foster transparency, be accessible, cultivate good human resource management, and be capable of managing an office that comprises hundreds of personnel and numerous departments and units, exercise appropriate and effective control over the Deputy Public Protector and the staff of the PPSA, delegate powers to the Deputy Public Protector to exercise, be capable of undertaking and managing numerous investigations and of understanding and applying the Constitution and the laws that regulate the public administration and affairs of the state, maintain an office that is accessible to members of the public, discharge functions ethically and effectively, monitor the performance of the executive, which includes investigating alleged maladministration, abuse of power, discourtesy, undue delay, improper dishonest conduct, improper enrichment, improper or unlawful prejudice, work to ensure that the public administration carries out its tasks without corruption or prejudice, be the last defense for the public against bureaucratic oppression, corruption, and malfeasance, investigate complaints from members of the public in respect of state affairs of public administration, report on the conduct complained of and take appropriate remedial action, decline to investigate conduct that occurred more than 2 years prior to the complaint unless there are special circumstances that distinguish the complaint, and that would be in terms of the act governing the PP. Consider a range of options in addressing a complaint, including mediation and negotiation, advising the complainant regarding appropriate remedies, and reporting an offence or particular conduct to appropriate authorities. In determining appropriate remedial action, not to order an organ of state to do something that is outside of its powers, to make clear rather than vague determinations, to be objectively fit and proper to render the constitutional functions of office, to be appropriately experienced in the law, the administration of justice, public administration, and or the legislature, be a person of stature and beyond reproach, be suitably qualified, be scrupulously honest and have absolute personal integrity, disclose all material facts and evidence and behave with utmost good faith when litigating, not exploit loopholes to show disregard for the law or mislead in any way or make charges without supporting evidence, ensure that all statements of the law are accurate and not misconstrue the law, be a good constitutional citizen, be willing and capable of taking on sensitive investigations that might antagonize the powerful, observe the requirements of procedural fairness and confidentiality during investigations, and allow potentially affected persons a proper opportunity to make meaningful representations, conduct investigations with an open and inquiring mind, and follow wherever the evidence leads, discover the truth and continue digging until the true picture emerges, not extend investigation beyond the affairs of the state into private parties, not expand an investigation without lawful justification, be cognizant of the serious consequences that can flow from an investigation, inspire confidence in the integrity and completeness of investigations, and account to the intent. So it's quite a mouthful, Chair, and perhaps useful for those members that are involved in the appointment of the new PP. Could perhaps serve as a reference guide for them. During cross-examination, Chair, Mr. Ibrahim's expertise and the relevance of his experience were called into question, and I mentioned this earlier. However, the principles established above, rather the principles were not established as incorrect or inapplicable. Mr. Ibrahim did, however, concede that a public protector has the power to limit or extend the scope of an investigation, provided that there are reasonable and justifiable grounds for doing so. And those questions would have been in response to the fact that part of the motion alleged that the PP narrowed the scope of investigations, for example, in the Theatre Dairy matter, or widened in others. Ms. Zulu-Sakoni's evidence, Chair, covered the principles and standards that an ombudsman should adhere to or uphold, because she obviously spoke more generally and not in relation to South Africa necessarily. And she also spoke at great length about the protections that an ombudsman should be afforded and observations in this regard. Chair, her evidence should be read together, especially with the Oliver Tambo Declaration and the Venice Principles, which she spoke to in some detail about. But some of the things that she said, Chair, was, and this has been extracted, Chair, from both the evidence in chief and the cross-examination. To determine whether public protector has committed misconduct or has shown incompetence, regard must be had for the office standards and duties, including notions of what it means to be fit and proper. A public protector who does not play by the rules could be subject to impeachment. The public protector should adhere to natural justice and procedural fairness. These principles do not just extend to the ombudsman, but when the ombudsman is investigating, but also extends to the relationship that the ombudsman would have with members of staff. The public protector's office should be the example of par excellence. We should ensure that we are leading by example for other institutions, is what she said. The public protector's office must exhibit the highest tenets of integrity, professionalism, transparency, accountability, the cause of justice, the rule of law, and the Constitution. The public protector must act in a manner that shows she's independent so that people perceive her independence. In this regard, it is a non-negotiable for a public protector, I should say, not to be independent and impartial. The public protector must take responsibility for every report her office issues. The public protector has a special responsibility to tell the truth to courts and to file affidavits through. The public protector's reports should be honest and the evidence referred to in those reports should be complete. The reports should reflect an understanding of the law, and the public protector should have the legal acumen of a judge. A public protector should not do anything to give the impression to the public that she has colluded or behaved improperly with a member of the executive branch of government. While a public protector must have a high standard of ethics, transparency, and lawfulness, she's also a human being, and there may be lapses here and there, and that is the reason why the decision of an ombudsman can be subjected to judicial review. And this, Chair, goes again to what I mentioned earlier about incompetence, is that incompetence is not merely the making of a mistake once or twice, it's sustained and demonstrated. Where the public protector's decision is successfully taken on judicial review, it's the duty of the ombudsman to interrogate that judgment and ensure that they do not repeat the sort of errors that were caused in that particular report. Ms. Sakoni referred to this as a cleansing process and a quality control process. And she made it clear that she would not expect a public protector to repeat the same mistakes once that error had been established in the court. Furthermore, she testified that it was not good for an ombuds's reputation to have judgments coming out continuously on the same issue, especially on the same matter, the same error, the same mistake. A court holding an ombudsman's decision to have been wrong is a way of ensuring excellence in the work of the ombudsman. However, an ombudsman who is aware of the principles and ethics of their job will take note of what the court is saying and implement it in their work to ensure that the error does not happen again. The office of the ombudsman should be above reproach. The members will see it's very much similar to what Mr. Ibrahim had testified on. Then Ms. Sakoni also spent a lot of time emphasizing the protections that an ombudsman should be afforded. Again, with reference to the Venice Principles and the Oliver Tambo Declaration. Chair, I thought it's important that I take the committee through these so that you understand some of the challenges that a ombudsman or a person in the position of public protector would face, and also understand the protections that should be afforded to them. The principle all emphasize the need to protect the independence of the ombudsman. As the ombudsman investigates the very office which created it, funds it, and which is supposed to pay the salaries of the members of staff and the ombudsman themselves. So we know that as far as Chapter 9 institutions are independent, in the same regard, they also rely on government for their funding. To this extent, the OR Tambo Declaration states the independence and autonomy of these institutions must be guaranteed by the Constitution, and indeed our Constitution does do so. The Venice principles refer to functional autonomy of the ombudsman, meaning that they should not be charged concerning their constitutional, legislative, or administrative functions. The ombudsman must be afforded the highest level of administrative and legal support to ensure that there is procedural fairness when any issue to deal with the institution is under the purview of any of the arms of government. She noted that the office of the ombudsman is inherently vulnerable because it investigates very powerful people. So, for example, the president and ministers in our case. The office of the ombudsman should be accountable to Parliament because through the systems of checks and balances of the separation of powers, one wants to ensure that the ombudsman reports to a body which it does not investigate. In South Africa, Chair, the PP does account to Parliament, but the PP may also investigate members of the executive who are also members of Parliament. The Venice principles stress that the protection and promotion of human rights and fundamental freedoms should also be extended to the ombudsman, the deputies and their staff. The judiciary protects the ombudsman in that where reports are tabled before the judiciary, they provide excellent scrutiny and independent scrutiny. Procedural fairness requires that when a body is dealing with adverse court judgments against an ombudsman, there must be equal attention given by that body that is hearing the matter to favorable judgment. Prior to being suspended, an ombudsman should be made aware of the charges that are against them and be given a fair hearing. The legislature should assist an office who is accountable to them and accord the appropriate protections if they are available. Functional autonomy requires that investigations carried out, that investigations are carried out by the PP. There should not be any interference in that investigation by any arm of government or from any person. And this also is codified in our constitution. As stated in the OR Tambo Declaration, at minimum, the office of the ombudsman must be equated to that of a judge. And she spoke of her personal experience, saying that the classical model, and she just to remind members, because it was a long time ago, the classical model is where the remedial action or the recommendations of the ombudsman are not binding. So that's different to South Africa, where the Constitutional Court has found that it is binding. And Mr. Coney was of the view that that would have been a better and stronger model. Of course, that isn't the case for us. And if there has to be concern or issues raised in that regard, it won't be in connection necessarily with the charges, but it's important to consider it in relation to the fact that later on, she goes on to say that this is one of the reasons that there would have been an increase in litigation. Principle 11 of the Venice Principle states that the ombudsman shall be removed from office only according to an exhaustive list of clear and reasonable conditions established by law. And these essential criteria of incapacity and inability, misbehavior, or misconduct must be narrowly interpreted. And in fact, that's exactly what Parliament's done in Italy, because as I said, they made the threshold even higher. And as I've indicated to members, removal is not a matter to be taken lightly, and therefore members must ensure and be certain that the evidence supports removal if such a recommendation is to be made. Whether an incumbent who has a short amount of time in office left should be charged would depend on the gravity of the charges that have been placed against that particular ombudsman. And an ombudsman performs officially in their office and is not carrying out a personal duty. Accordingly, she was of the view that it compromises the independence and integrity of the office for the officer to be asked to take personal responsibility for actions that were carried out in an official capacity. And this had to do with the fact that the incumbent PP has had personal cost orders made against her by our court. Adverse cost orders should be borne by the respondent institution and not the public protector personally. And if criminal charges arise out of the same set of circumstances where a personal cost order has been granted, she said that it sounded to her like that may amount to victimization. She reminded the committee that an ombudsman is a single person who is constituted as a corporate soul and is being asked to shoulder the responsibility of an entire organization. And so personal costs in her view were a form of judicial harassment and were unacceptable. On the time limits for submitting complaints to the Office of the Public Protector, she said that this should not be read very narrowly, and this has to do with that 2-year time frame in the Act, because an ombudsman should have a lot of discretion. And she cited an example saying, for poor people who come from rural areas, they may not know that they can actually appeal. They may not have the money to actually reach the Office of the Ombudsman, and they may take more than 2 years to bring complaints. She said unlawful or retaliatory suspension is a form of administrative or judicial harassment. And the binding decision model makes the ombudsman amenable to review of their decisions by a court of law. And that would be because when decisions are binding, people would be more inclined to want to take that on review. The courts, she said, also seem to feel threatened by the judicial powers of the ombudsman, and there's always a temptation by any one of the 3 arms of government to trim down the powers of the ombudsman. And she said this is evidenced by matters in our own country and here in South Africa. And once the powers of ombudsman seem to overlap or to be shared by any one of the 3 branches, inevitably the institution of the ombudsman may have to be reined in by the arm which feels challenged. She said it's very important that during the course of investigation, an ombudsman has the complete cooperation of the respondent institutions, being the executive. The ombudsman is the only institution which the poor man can call upon. If a process in a particular country involved the refusal to call essential witnesses or relevant witnesses that are specifically mentioned in charges, thereby denying the accused person an opportunity to clear their names, she said this would not be in conformity with the fundamental principles of natural justice. And the person's right, firstly, to be properly represented, secondly, to properly defend themselves, should be respected and upheld in any constitutional democracy. And then lastly, that it's an unintended consequence, as I mentioned earlier, that the binding model litigation costs would shoot up because people would be more likely to challenge decisions. However, with reference to our own office, members might recall that Ms. Sacconi said that she had gone through the experience of one of her reports being taken on review. She said that she must confess that we have actually raised our standards very high, because whatever evidence we get, we interrogate each and every piece of evidence thoroughly, because we know that when the report comes out, there is a possibility that it might be taken to court. So that's actually made us a little bit more cautious. It takes us a little bit longer now to issue a report because we have to really do our due diligence and really interrogate our cases so thoroughly. Chair, the next section of the aid memoir deals with intimidation, harassment, and victimization, referred to in paragraph 10 of charge 4. And I'm not going to read that charge out, but the reason that I've included it here is that these terms were not defined in the motions. I just thought it might be useful to give a brief explanation of what these concepts are. Harassment is defined, the dictionary definition is intimidation, bullying, threatening, or coercive behavior, including manner of speech, usually by a superior towards a subordinate, and sometimes by colleagues in an organization. In South Africa, it's dealt with in the Promotion of Equality and Prevention of Unfair Discrimination Act, which describes harassment as unwanted conduct in the workplace, which is persistent or serious and means, humiliates, or creates a hostile or intimidating environment, or is calculated to induce submission by actual or threatened adverse consequences. The Code of Good Practice on the prevention and elimination of harassment in the workplace, which is issued in terms of the Employment Equity Act, aims to eliminate all forms of harassment in the workplace. And that code recognizes various forms of harassment that may amount to unfair discrimination. So whereas previously only sexual harassment was dealt with in terms of the code now deals with harassment on many grounds. And I think I've got it in a footnote. Harassment is generally understood in terms of the code to be unwanted or unwelcome conduct which impairs dignity, creates a hostile, intimidating work environment for one or more employees, or is calculated to or has the effect of inducing submission by actual or threatened adverse consequences. and is related to one or more of the grounds in respect of which discrimination is prohibited, and the grounds of discrimination are captured in the footnote. Example of harassment according to the code include physical and sexual abuse, but also abuse of a psychological or emotional nature. In terms of section 4.4 of the code, the test to determine whether conduct constitutes harassment is assessed on an objective basis from the perspective of the person who alleges the harassment. The primary focus should be on the impact of the conduct on the person who alleges the conduct, with reference to the reasonable person test. In other words, would a reasonable person in the position of the complainant view the conduct as harassment? Intimidation, Chair, the dictionary definition is the action of frightening or threatening someone, usually in order to persuade them to do something that you want them to do. And the code defines intimidation as intentional behavior that would cause a person of ordinary sensibilities to fear injury or harm. Victimization is defined in the dictionary as treating someone in an intentionally unfair way, especially because of their race, sex, beliefs, etc. The statutes regulating labor law do not deal directly with victimization. However, the Labor Relations Act indirectly deals with it, in terms of which certain unfair labor practices could amount to victimization. So, for example, unfair conduct by the employer relating to the promotion, demotion, probation, or training of an employee, or relating to the provision of benefits, the unfair suspension of an employee, or any other unfair disciplinary action short of dismissal, a failure or refusal by an employer to reinstate or re-employ a former employee in terms of any agreement, and an occupational detriment other than dismissal in contravention of the Protected Disclosures Act on account of the employee having made a protected disclosure as defined in. Chair, the last part of the aid memoir deals with the general issues that I alluded to when I started, and these are issues that are raised in the PP's Part A statement, which members are obviously familiar with and would have read. And whilst members are going to be deliberating on the charges in particular, I thought it's necessary to deal with these issues. The reason being that members must be certain that the process that they followed is fair. And these are issues where the PP has indicated that the process isn't fair or that point of unfairness. The way in which I've categorized it in terms of the headings is my own categorization, but where possible, underneath in the subpoints, I've taken it as directly as I can from the Part A statement. Nature and flaws of the Section 194 process. The PP alleged that the process does not represent a genuine impeachment process. It's a political process as emphasized by the Speaker, Chair, the President, and the DA cooperated in court pleadings, and not a conventional legal process. And the process is a politically motivated witch hunt. It's a vanity special project of the Democratic Alliance aimed at scoring political points, as being the first party to have caused a head of the Chapter 9 institution to face impeachment. It is a racially motivated campaign born out of the fear of real change which might actually benefit the poorest and most marginalized of society, who are mainly Black, at the expense of those who benefit from the untransformed economic status quo, who are in the main white and the backbone of the DA constituency. The DA has falsely labeled Advocate Enquiry as spy and has made at least 5 separate attempts to remove her. The DA is abetted by the African National Congress. The ANC is motivated in turn by retaliation and revenge for the exposing of corruption and wrongdoing by powerful ANC leaders such as the President, and she refers by way of example to the CR17 matter in Phala and Minister Gordhan in relation to the SARS Road unit matter and what she called the fake retirement of his friend Mr. Pillay. There's an unholy alliance between the DA and the ANC, and these parties will use their majority power to remove her. The outcome is therefore predetermined. And in addition, the PC Justice at its meeting of 6th of March prejudged Advocate Mkhwebane The chairperson, who was a member of that committee, also made adverse remarks, such as here we have budgeted for incompetence. The process is illegal, inherently and irreparably unfair, biased, predetermined and doomed. Advocate Mkhwebane has participated under protest for the purposes of disproving the popular narrative that she was avoiding, was scared of the process. The inquiry is a charade. The proceedings are defective as a result of the following: the refusal to exclude charges in respect of which there was no prima facie findings, the repeated conduct of proceedings in her absence and in the absence of the legal team, the refusal of the chair and Mr. Milam to recuse themselves, the refusal to call the president, Ms. Mazzoni, and Minister Gordana as witnesses, and the refusal to grant Advocate Mkhwebane sufficient time to prepare her evidence. On matters of suspension, she said her suspension is not bona fide, it's vengeful, retaliatory, and an illegal act by the current president owing to the multiple investigations that she was seized with, including CR17 and Pala Pala, to name a few. Those were the only two that are named in there, Chair. And the suspension is the real reason why we are here today. In terms of witnesses, she noted that Mr. Makebokwe was a helpful, cooperative, and truthful witness, but Prof. Madansela was a hostile, uncooperative, and untruthful witness. The committee refused to call key witnesses requested by her, and the committee refused to recall Mr. Van Rottenberg, Ms. Valoy, and Mr. Philip. On the charges, she said the charges have been concocted by Ms. Mazzoni. Any objective, fair, and reasonable analysis will lead to a conclusion of not guilty. And Chair, I don't like the use of that language. That language is not contained in the motion about guilty or not guilty. It's whether the committee has found that there's misconduct and incompetence, even though we refer to charges. Witnesses called by evidence leaders have effectively exonerated Advocate Mkhwebane of any impeachable wrongdoing in respect of every charge, and no fair court will uphold a contrary finding. The impeachment effort is therefore doomed to fail if subjected to fair judicial scrutiny. The IP recommended an inquiry in respect of matters where they found prima facie evidence only. However, the committee illegally extended the scope by, for example, considering the Pillay pension matter in the HR charge. The committee failed to deal with the motion, therefore, as filtered. She said the removal rules were crafted as a copy-paste job by the DA, and the rules were targeted at her, and this is evidenced by the fact that it provided for a mummified lawyer to sit in the inquiry. There were also some what she called glaring absurdities. She points out that her 7-year term ends in mid-October 2023, and by the time she had drafted her statement, she had said that was in 6 months' time, but of course it's far closer now. The inquiry is estimated to cost the taxpayer approximately 1 million per day. And Chair, this amount gets bandied about, but I think it came from a statement made by a member very early on in the process. But nonetheless, the cost of instability to the office of the PPSA is incalculable. Advocate Mkhwebane has made several attempts through the courts to stop the continuation and the commencement of this illegal process, but these efforts to stop this futile and costly exercise have always been opposed by the Speaker, the Chairperson, and the DA. Chair, a lot of these issues that were raised have been considered by the committee. Some of them we've responded to in writing. Some of it was raised in the first recusal applications of the example issues, if I recall correctly, on the summonsing of the president and so on. So for purposes of drafting the report, we will obviously place a reliance on what the decision of the committee was in respect of some of this and what's contained in correspondence in respect thereof. Chair, in conclusion, in determining the veracity of the charges, the committee must have due regard to the evidence before it, which includes witness statements, court records, oral evidence, the statements of the PP, evidence before the independent panel, and evidence tendered as part of the report. The summation that's been done by the evidence leaders merely seek to summarize the evidence before the committee. But it's important to remind members that the role of the evidence leaders are not to make findings on behalf of the committee. The summation is based on relevant evidence, and the evidence leaders have therefore not summarized things that may be irrelevant to considering the merits or veracity of the charges. So if I give by way of example, you'll see that the summation doesn't deal with evidence from Mr. Nyatela because that wasn't directly related to any charge. What the evidence readers also haven't done, Chair, is to consider the credibility of any witness, where they've relied on evidence either because evidence has been corroborated or because there was documentary evidence. It's for members to decide whether the testimony of any witness was not credible and therefore calls not to be considered. However, I am reminding members that the evidence leaders have tried to show where there is evidence to support the evidence, notwithstanding where there may be a credibility issue. But of course, that's for the committee to decide. Again, the committee can only decide if there's been misconduct or incompetence by judging what the standards are against the evidence and in that way reach a rational conclusion. And importantly, the committee must be satisfied the process has met the threshold of fairness as required in the removal rules. In this regard, the committee is reminded of all the correspondence, and I think one of my colleagues from legal services in the first 2 or 3 weeks of the committee referred to as a carnival of correspondence, and he thought that was a carnival at the time. I'm not quite sure what to call it, but there's a lot of correspondence that has been tabled. A lot of it deals with objections and so on. Members would have obviously read it and are aware of it. And they need to apply their mind because before moving to the issue of whether there are reasons that support or don't support the removal, members must be satisfied that the process has been fair. Also, Chair, I just want to mention that Advocate Nkwebani's statement was obviously drafted some time ago, and since then there's been further objections to parts of the process and further issues raised that wouldn't have been captured therein. She has captured those things though in the correspondence, and it includes, for example, the second recusal application, and it includes the fact that she alleges that the committee has proceeded despite her not having legal representation. So the committee can consider that further. Chair, I'm sorry that took a little bit longer than I expected, but I hope that helps members as we move to the next part, which what we've done there, Chair, is to make things easier to set out these questions. We have done those definitions of incompetence and misconduct to try and assist the committee, but because the motion deals with subject matters like sex and theatre, they don't necessarily follow the motion in order. But hopefully that will assist members, and those questions will also reference where in the summation the summary of the evidence can be found. Thank you, Chair.
Thank you, Ms. Ibrahim. That was mouthful, very comprehensive to lay this context. It's a live background and just refreshing our memories on the issues. I think, as you indicated, members will make use of that as we go through the next exercise. It's an important resource that I hope you can come back to where there are doubts or lack of clarities on certain matters. There you are, members. I think that was just the first bite to just situate you to an exercise that we're going to go through. As I want to go to the next exercise, I think I've already given you a tea break when we're fixing that. So unless there's a request for that, I'm hoping that we're now going to march until lunchtime, especially if there's no comment or clarity on this issue. I want to immediately go into the real task and work that we're going to go through minute by minute as an exercise. Is that in order? Should I proceed, or do you want a 5-minute, 10-minute break? Okay, we'll allow the quick break. And then when we come back, we will get into the questions and members. It's going to be an interactive process. And I'll be guided by members' hand, but at the same time, I will also point you out even without your hand as we get into this. And I must indicate upfront that when we come back, that exercise is going to require both here at M46 and virtually that all at least 19 members are going to have to be present for each of those questions as we answer. Because each of those is a decision of this committee. But as things stand, we are fine. We're beyond that. Thank you. We will take 7 minutes and be back at 12:10. Just a break. Ilebo so ithathile wena before.
Recording stopped.
ask everybody outside to come in.
Recording in progress.
Thank you. Welcome back from the short tea break. As I indicated, we are now about to start the important tedious process of us doing our work as we have been mandated. I forewarn that it's not going to be a quick and nice work, but it's an important work where we comb everything. I will be leading you with the questions and the things are going to be put up, just to indicate that as we do this exercise, and it's the reason why we've called the evidence leaders to be here, that where you need clarity or anything question, they are here to assist us with that, or some recollection that you want to make sure about. They're here to assist the process, but not to involve themselves in a decision. I now want to proceed. I have two hands, Honorable Heron as well as Honorable Maneli, Ngosi and Mola. In that order, Honorable Heron.
Thank you, Chair. Chair, just before we start, I just wanted clarity on what we are about to do. And in particular about the evidence summary that was provided to us from Sunday. In quite a large volume of information was sent through from Sunday. And just going back to the question of fair process that Advocate Ibrahim raised when she did her went through her aid memoir, has the summary of the evidence been provided to the public protector to assess or to invite her to comment on the summary of evidence? I am concerned that the evidence, the summary of evidence is presented in a way that answers the questions that are in the motion, and it extracts evidence that was given by witnesses. But I would imagine that if they are willing to participate, the public protector's legal team may have evidence that is not recorded in that summary. So I'm just wondering what the status of that summary of the evidence is and whether the public protector's team have also received it. Thank you.
Thank you, Honorable Heron. I think we can have a quick response to that before I go to the next members about us, whether we have shared that and that related matters. Ms. Ibrahim.
Chairperson, as I understand it, the Secretariat has indeed shared the summations, but it wasn't shared for comment. Members will recall that we had inserted in the terms of reference that the PP must be allowed to make an opening and closing argument. So indeed, that opportunity was provided, but the PP has cited the fact that she doesn't have legal representation and therefore she cannot comply with any of the deadlines that we had inserted in the new procedure. And one of those deadlines would have been to inform the committee as to whether she would like to do a written closing argument or whether she would want to do it orally and then supplement it in writing if necessary. That would have been where one would have expected that they would have drawn together all their evidence and submitted it in a clear format for the committee to consider, Chair, but that hasn't happened. The role of evidence leaders, as I said, they're not prosecutors. So what they sought to do was to capture all of the evidence before the committee so that they could assist the committee. And I will ask Advocate Bauer to clarify, but my understanding is that includes things raised in the PP statement, and there's reference made to where their versions are different so that the committee is alerted there too. Thank you, Chair.
Thank you, Ms. Ibrahim. Maybe you want to come in there, Advocate Bauer.
Chair, I concur with what Advocate Ibrahim says. I don't really have anything to add to. Save to point out that if there is anything specific that the member thinks we haven't touched, and we do say that in the evidence, or if there's something that they thought we should have raised and we didn't raise, then we're happy to go and add to it, do it during the course of the proceedings to look at, or if there's something we have inadvertently missed that we should have raised, we're happy to traverse it, put it before the committee, or the member can put it before the committee. But there was an endeavor on the most controversial issues to cover the evidence.
Okay, thank you. Maybe before I proceed to the next members, any follow-up, Honorable Heron?
Thank you, Chair. Look, I mean, I do understand that, and I have read that the summary of evidence invites members to point out where there are perhaps omissions or questions that could be raised. My concern was just that the Public Protector has received the summary of evidence, and I would have hoped that she would have been invited to respond to it, because I have, since the beginning of the hearing, asked several times whether the members are going to get a copy of the record. Now, we don't have a copy of the record. We have a summary of the evidence, and there may well be have been evidence that the Public Protector would like to contradict using the evidence that has been presented before the committee. So we don't have a record. I don't have a record of the hearing, and I'm probably relieved not to have, because it must be tens of thousands of pages long. But the question is, I guess my concern is that the Public Protector may have evidence that they would like would have liked the committee to consider. So I heard Advocate Ebram saying that this summary of evidence was presented or given to the Public Protector, but there was no invitation to respond to it. And I just raise it as a concern around her own point about a fair process. I take it no further than that. Thank you.
Thank you, Honorable Heron. My understanding is that there is the record, Mr. Ngoma.
Good afternoon, Chairperson, honorable members, evidence leaders and guests. You are correct, Chairperson. The committee does have a record wherein we have initially even asked members that require assistance and provided such assistance to some of the members who have indicated as such. And that record is on the Alfresco, which is Parliament's document management system. Thank you, Chairperson.
Right, thank you. Honorable Manil.
No, thank you, Honorable Chair. I just wanted to raise a point on the presentation that was made by the legal side, not the one we're still getting to. If you allow, Chair, so that I couldn't stop that call from nature, given the time. Thanks. Chair, I think we should appreciate the presentation. I think that's from where one is sitting. And that there should be a way, because that presentation talks to putting the context in which we are proceeding as this inquiry. And there would have been a reason to start from that foundation when Mr. Ibrahim was called in. So I want to start from that point because from time to time we're going to make a reference to that. And that when that would have been questioned, there was an alternate that was put before this committee, and this committee allowed that. And that is also captured, I think, the report properly. And you can see similarities. And that's why I would call it the framework from which we are moving from in understanding the work of the public protector. So that we'll also locate the charges as we deal with them around that part. But the other issue, Chair, would be as part of that context, given the fair nature of running this inquiry, it's important the points that have been noted about how the inquiry would have been perceived from the side of the public protector. However, it should also be boldly stated that yes, you may also have had members, a few of the members who would have agreed to that. But equally, there's been quite a substantial number of the committee that have really objected, but also clarify the matters that would have been raised, even if those are not captured as they are not in this case, in the detail that you would have detailed the ones that the PP would have raised. Because this will be part of our record. So it shouldn't be like they were approved, we accepted, we engaged them. And from where we have engaged, this would have been the reason, actually, that we proceeded with the inquiry, even when those matters would have been raised. It's because we're convinced that a number of them would not hold water in the way the inquiry has been handled, including where there would have been legal challenges on it. We have come out there successful in that we should proceed with the work that we do. So that's the second element I want to raise. But there's also an important element, Chair. You raised it in your opening. It may have not come out clear unless it is in that break. If that's the case, I would accept, Chair. The part about us, the members, asking the questions. We did that before we started, and those were taken, and those were said to be answered later on, because the PP would have not been on the stand at the time. As we pick up matters from witnesses and we're made to submit, so there's not been response to that. The second was this other attempt, again, to check other matters and giving the opportunity for the PP to answer those in a way that could refute some of the things that would have been said, at least give her own side of understanding those matters, what you called unchallenged questions. I think in the context, it's important because we may raise some of the points as a result of the questions we would have asked where the people would have elected not to respond, so that we're also not blamed that we come to certain conclusions in the absence of the answers. So I just thought those three points, Chair, one needs to speak to them as part of proposing that we incorporate that has been put as part of the report, particularly in the beginning, to set the context, so that whoever was not following the inquiry would understand as we move forward that we started some. Thank you, Chair.
Thank you, Honorable Manid. It's not a question, but I'll give you to clarify. I think you amplifying a lot of things and even expanding on the context of the issue. She would have indicated that on the issues, general issues raised by the PP, would have responded them formally either in letters or in applications. But the point you're making is that on the spot, in sessions, members would always have responded to those issues. So I think that's the point you're making around these kind of issues, but also the further contribution you made. I think that's welcome. Ms. Ibrahim.
Chair, I just wanted to indicate, and members will see it from the correspondence that has been exchanged, is that Chinese attorneys have still not briefed counsel for purposes of the merits of this matter. They've maintained the position that they're not able to brief Advocate Mpofu and the two juniors until such time as they familiarize themselves with the record. And if I have my dates correctly, as of 3rd of July, they indicated it would take them approximately another month longer to do so. And the brief to counsel was limited to only bringing the recusal application. So they made it clear until such time. The correspondence from the chair indicates that is unreasonable, and the reasons are set out in some detail. And I think the recusal application response also deals with it. But as things currently stand, the PP maintains that she is not legally represented because Chan attorneys are attorneys of record and not her legal representation for purposes of the inquiry, and therefore she remains unrepresented. The chair's response has always been that the committee has not denied her the right to be represented. Thank you.
Thank you, Ms. Ibrahim. Honorable Ngosi.
I don't want to prolong the matter, but on the aid memoir, point 10, which is raised by Honorable Maneli as the second point. I think the fact that there were responses, firstly one, the fact that other members did raise in the committee in agreement with some of these, and two, the fact that there were responses should also be recorded. Otherwise an impression is created that these issues were not challenged. So it should either in the conclusion or as a paragraph, as a standalone paragraph, indicate that these matters were variously responded to, supported or not supported, etc. I think that's my point really. Otherwise, the detail, the aid memo assists us as a tool. It's really that it's a tool for us when we consider all these bulky documents to always refer to it. Thanks.
Thank you, Honorable Ngosi. You pick up that gap. I think the suggestion, as Honorable Maneli was saying, and now Honorable Ngosi, that let's fill up that gap so if there's no assumption made. Mr. Brian?
Chairperson, that won't go into the aid memoir because that wasn't the purpose of that document. That would go into the report. So obviously the process of the report drafting is something that happens from day one, because as committee staff, we're capturing things as they happen. So the report will certainly contain these objections of the PP and how it was responded to and where the committee took decisions, for example, to proceed in the manner that we've proceeded, and the reasons why the PP then did not participate.
Thank you. I hope that covers for both of you, Honorable Maneli and Honorable Ngosi. Thank you. Honorable Sukas, and then I go to Honorable Ngwada.
Good morning, Chair. Good morning to my colleagues and to everyone on the platform. Chair, with your indulgence, I will keep my video off because my internet is a bit unstable.
Please go ahead.
Yes, mine is, Chair, to just raise two issues that is related to the report and what is contained in it, and with your guidance. Chair, while we are primarily seized with determining if the public protector is competent to hold office, there are two other important aspects to our work. And this primarily deals with learnings and recommendations following what has been an extremely lengthy process. These indeed should only be addressed, of course, learnings, recommendations, after the House has voted on the competence of the PP. However, we fail to address them, Chair, I believe we will not be discharging our responsibilities to the public, and we will not be justifying the large amount of money spent on this process. The two issues that need to be addressed are reporting on how to improve the functioning of the Public Protector Office. You made this clear when you asked witnesses who worked at PPSA if they had suggestions to improve the functioning of the office. It would be a total waste of taxpayer money if we do not make recommendations a part of the report. Of course, however, it would not be fair for us or appropriate to make them until the House has voted. So there is this a delicacy around that. But finally, we have to improve the impeachment process itself, and those learnings we need to, I believe, should form part of our report as well. So even though we are a young democracy, we've said over and over, it's a novel process. We need to learn from this process and make recommendations for improvement, especially with regard to cost, protection of witnesses, and ensuring a committee has the power to compel the person impeached to appear. I think it's important, Chair, to raise this along with the other technical matters that has to do with the primary objective of the report. Thank you, Chair.
Thank you, Honorable Sukas. There's certainly a very good intention, not for today and not when we consider the report, to separately have a session where we deal with what we call reflections and lessons, so that we're also helping the next process, whether it will be section 177 or a further section 194 or whatever. There's certainly going to be that, and that might not even need to wait until NA adopts, because it's part of the work that we can do, but we've got to separate it from the discussion and the drafting of the report. So your points are well taken, Honorable Sukas. Thank you. Honorable Mwala.
Thanks very much, Chair. I think on the first part of the progress on the briefing of the senior counsel, I got a clarity from what Mr. Ibrahim is saying. I'm quite shocked that until today, after the work the committee has done in ensuring that we give access to resources and everything else for the public protector to have a legal representation in that, until today we are still lingering on issues of legal representation, counsel not having been briefed, and all that. And Chair, from where I'm standing, judging from what Ms. Ibrahim is saying, that they said they briefed them for purposes of the recusal application and nothing else. From where I'm seated, Chair, this is nothing less than a dereliction of duty and an abscondment. I think it must be on record that the public protector is staging an abscondment on the inquiry. Two, Chair, I see in the item memo, Ms. Ibrahim is taking us through the evidence that has already been accused in the committee through two forms, which was a written affidavit and then on the oral presentation. But if we recall, the public protector submitted two affidavits. It was part one and part two. But in part one, she has been able to adduce both the written submission and the oral submission. But in part two, she has been able to submit, but haven't been able to do the oral submission. And in line with that, the committee sent questions, written questions, and they were not responded to. So I want to check from the aid memo that does it include the second part where there was no oral evidence adduced and the questions were not answered, the written questions of the committee were not answered. Secondly, Chair, the charges emanate from 4 reports. which is Fred SARS, CR17, and CIX. Now, does the 8 cover all the 4, or only cover those that which the PP was able to do the oral presentation? I just didn't get that part as I was listening. Thank you very much.
Okay, I'll ask Advocate Bauer or Advocate Mayos if they want to quickly respond.
Are you referring to the summations we provided, or are we referring to Ms. Ibrahim's aid this morning?
Okay, the ball is passed to the back line.
Yeah, so Chair, my aid memoir does not contain any content on the veracity of the charges. That's what's contained in the summation, and indeed the summation deals with every single charge.
Covered, Honorable Mwana. Thank you very much. We now proceed, colleagues, as I indicated, so that we start the process. We'll start with charge 1. It's called those different names: the lifeboat, investigation report, CX matter, Reserve Bank, and so on. And I'm sure Tsepo will assist us so that you follow. I'd like us to start with this actual detail work that we need to do. And I think it's also important that you understand that the issue of the charges are sometimes a lot overlapping, and they can be overlapping on the same matter, whether it's issue of misconduct or incompetence and so on. Maybe as a first, inviting members to, we're going to start with paragraph 1.11 of the motion, as well as chapter 1, part 1 of the evidence summation, paragraphs page 26 and 34. And we'll start with the meetings with the presidency. And with the presidency, the issue here is not necessarily just the President Zuma himself, but officials in that. So the first question that I want to pose that members, that during the investigation, did Advocate Mkhwebane meet with the presidency? From the process that you have followed, the evidence that is in front of us, and everything else. I'm not going to proceed to the next one until you respond. So this is where I'm looking for hands. I'm looking for people, because you're going to have to speak to these matters. There's no assumption to be made. I'm not going to think that you agree to this or this is your answer to it. Honorable Ngola.
Thank you very much. It's just that I may not recall those who have had a lot of witnesses, but in terms of the evidence that was submitted through testimonies from witnesses here, is that the public protector did meet with the presidency, but where it becomes problematic is that in the report, it was not covered that there was a meeting with the presidency. So that's where it becomes so problematic for me. Thank you very much.
We might come back and cover that. So thank you for that. That's your response. Is there any different view to that? Maybe somebody's got a different understanding. None. I proceed to the next one. I don't see any hand. If so, therefore, did Advocate Mkhwebane meet with the presidency secretly without disclosing the fact and import of the meetings in the lifeboat report? Honorable Ngola.
Thank you very much. The meeting with the presidency is said to have happened with an objective of conducting an investigation. So if it does not appear in the report that there was a meeting with the presidency, it then means the meeting was secret. And there is no other explanation. That was in the, it has been a culture in PPSP that before you go to remedial actions and all that, you first table the form of investigation that has been undergone. And that appears in the entire report when PPSA or the public protector delivers a report. So if it does not appear in the report itself, that when you were conducting the investigation, these are some of the procedures we have followed. So if it doesn't appear, it means it was secret. Thank you very much.
Thank you, Honorable Mola. I again ask if there's a different view or understanding. I don't see the hand. Honorable Heron, the screen is now blocked by this, but they are going to help me.
Thank you, Chair. I just.
But to you?
Yeah, can you hear me, Chair?
Yes, I can.
I guess my point really is whether the meeting took place secretly, and whether anything hinges on secretly, because as far as I can recall, and from the summary of evidence, there were members of her staff that attended the meeting with her. So it wasn't a secret meeting, it was an undisclosed meeting in the report.
Okay. Thank you, Honorable Heron. So your take is because there would have been these officials together with her, that in your understanding, it's not secret but undisclosed.
Yes, sir.
All right. We'll record that. Thank you. And then I proceed, therefore, to the next point. So if so, did Advocate Mkhwebane fail to file transcripts of the meetings with the Rule 53 record? Any volunteer? We're now doing our work. Honorable Gossi.
Yeah, Chair. If the meeting did take place, the question is where the trustees are they? It's clear from what we have here. The transcript will not available, and therefore will not available for anyone. So that meeting did take place in effect, but as required by the practice in this office, every meeting that takes place officially is recorded and forwarded. In this case, it does not.
So to answer the question, therefore, directly, did Advocate Mkhwebane fail to file those transcripts?
Yes.
Okay. Okay, thank you. Do I have a further hand, a different view, or another contribution? Honorable Mylam.
Thank you, Chairperson. Chairperson, it's just to expand on what's been said so far. First of all, we know that those meetings took place, and the public protector has admitted to those meetings taking place. What we don't know was what was discussed in those meetings, what the content was, what the purpose of those meetings were. That's the part that is unclear. So we know that firstly that the meetings took place. We also know that the record of the meetings and the content of those meetings was not disclosed in the Rule 53 record, and therefore we don't know what the meetings were about. What we do know is that the president was an interested and affected party or an implicated party, and that they were there as part of an investigative process, and that as such, there should have been a transcript or a record of those meetings. Thank you, Chair.
Thank you, Honorable Myla. As you indicated, you want to further amplify the issues. Honorable Maneli, before I proceed
No.
to the next point.
Thanks, Chair. You, I think, disorganized us a bit by moving quickly to an opposing view. You know, so, I'm sure
I will learn for
we'll
the
learn
next.
from that, right? No, I think one agrees with that point, Chair. But the point I want to make is an understanding that there was an opportunity to deny this, as this also comes from the independent panel. It's one of the areas that it looked at. And when that opportunity was before the committee, still there was no explanation on why those transcripts could not be put forward, including the fact that you disclose even late about the 17th of June, 2017 meeting. So I just thought one needs to make the point about the IP side of things, because this is then the confirmation of what was to be prima facie evidence that must be looked at. So I just thought I should raise that point. Thank you, Chair.
And in your view, what would have been in the IP's report would be sustained?
It's now substantiated in that score.
Thank you. Any further point on this matter before I proceed?
Yes, Chair.
Yes.
I just want to, if I may.
Honorable Aaron.
Yes.
And then followed by Honorable Klape.
I think it's, you can call it common cause that there were that the transcripts of the meetings with the presidency were not included in the Rule 53 record, so they were not disclosed. But the evidence of Advocate Mkhwebane was that there were no transcripts to disclose because she didn't record the meetings. And so the question is, was she obliged to record the meetings? Now, Honorable Milam suggests that she was obliged to do so, and I'm not so sure that there's any obligation on her to record or to record in a way that can be transcribed every single meeting that she has. So the question is whether she failed to furnish something in the record that existed, and on her version, if I recall correctly, and if I read the summation of the evidence, her evidence was that there was no record of those meetings because she didn't record them. So the question is, did she fail to file transcripts of the meetings? The answer I would say is yes, but her evidence is that there was no transcript of those meetings to file.
Thank you, Honorable Heron. I get your point. You agree that she failed to file a transcript, but you elaborate that from your own understanding, she did to the committee indicate that she did not do the transcripts. If I get you correctly, I think that's the elaboration that you're making.
Yes, that the transcripts don't exist.
From her evidence that she put in front of us. Thank
Yes,
you.
sir.
Thank you. Honorable Klape.
Thank you, Chair. The last speaker now is confusing my train of thought. Chair, I was looking at
Oskaba confused. Please stay on lane.
Yes, the word fail, according to what we're discussing here, for me, is a bit off track. I would be comfortable if we say she omitted to file the transcripts, because if you fail, you would have made an effort, you would have tried, and you did not succeed. So, like the honorable member is saying, there were never transcripts. For me, they were excluded, like omitted. They did not come forth. There was never an effort to bring them forward. So that was my thinking, Chair. Thanks.
Thank you. I see why you're crying for this confusion before you spoke. I think all of us would agree that from the evidence, there were no transcripts that were made. And there would have been questions in the testimony as to it's not a normal. Normally, these transcripts are made. I remember those kind of interactions. But at the end, for that, there would not have been transcripts. And so the question therefore remains that in the filing in terms of record 53, none of that was submitted. And you bringing Honorable Klabe that you find fail being hard and you would want to soften it. I get your points there, but maybe if there are any other members who wants to engage further on this before I step off it. Honorable Maneli.
No, thanks, Chair. I think for me, the point, like I raised earlier, I took it that it's agreed that we take the points that have been given as a framework and context in which you test that you are dealing with. In that test, it would mean that you start from the report itself. If in the report you do not disclose that you have met with the president, Rule 53 will be a later issue. It therefore says that you can't withhold the information that you have just from a point of ethics. So it should have been disclosed even at that level. And there's admission that that would have not been the case, even though later on in the court, this would have been a matter that get raised as an admission. But even in that admission, it's only on the meeting of the 17th of June, as the other honorable member would have said, without disclosing even contents about that. So that's still withholding. There's no other way I could put it, Chair. So in that score, like I said, it then puts that misconduct in that way, that it is there. Okay. So I just thought I should add that so that the point is not just about the transcripts, which I also admitted that it's a misnomer that you would not have when all meetings get to be recorded as a way of proving that you've interacted. When you have to make follow-ups, you have a point of reference. So in this case, you don't. We also still do not know the real contents of such a discussion. So that's a point of that to raise, Chair, just to clarify where I came from on that point earlier.
Thank you, Honorable Maneli. Back to Honorable Heron and then Honorable Goss.
Well, thank you, Chair. I want to agree with Honorable Maneli. I think that was the point I was trying to make, that the meetings, if we go back to the first question, the meetings were not secret because she was accompanied by staff, but they were not disclosed in the report. And the failure to file transcripts, I'm not sure is sustained if there were no transcripts to file.
Okay, thank you. Honorable Ngosi.
Practice or a duty to report meetings, it would be an omission not to submit the transcript. Yes. The real issue is that there was a meeting which was not disclosed. The records of that meeting, whether written or unwritten, the record, whether it's written or it's a tape recording, ought to exist. And therefore, for me, it can be a simple issue of an omission because you omit, it's just negligently so. But the thing is there, but you forget. So for me, it's that because the meeting took place, and for me, that the meeting was secret. The intention was not to disclose the appearance of the meeting itself. So everything that flows from that means that you will concede even the record of that meeting if you took it. So it can be an omission. Yeah.
Thank you, Honorable Ngosi, Honorable Mailam and Mananiso.
Thank you, Chairperson. Chairperson, I think it boils down to not so much whether the transcripts were filed or whether they existed, but whether they ought to have existed. In other words, whether there ought to have been a transcript of that meeting, and as such, that should have then formed a part of the record. And that's where the problem lies, that there were no records taken, but there ought to have been records taken. Thank you, Chair.
Thank you, Honorable Mailam. I'm going to Mananiso and Van Minen. Maybe before that, Ms. Ibrahim.
Chairperson, I think that's correct because the charge talks about without furnishing transcripts, not necessarily without filing transcripts. There's a difference between not filing a transcript that you have and not filing a transcript, as Honorable Heaven says, that you couldn't have filed because such a transcript didn't exist. So the question is more as to whether there ought to have been disclosure of what occurred in that meeting.
Thank you. Honorable Mananiso and Honorable Van Minen.
Thank you, Chairperson. I think one would want to agree with Honorable Bekinkosi in terms of there was no omission, but one would want to affirm that the sentence and the question is still right to say that she failed on the basis that we have been taken through in terms of what is the procedure thereof in terms of investigations in the PPSA. That's my submission, Chair. Thank you.
Thank you, Honorable Mananiso. Honorable Van Minen.
Thank you very much, Chair. Chair, my view is that, these are people who are holding public office and are having meetings accompanied by staff. So to my mind, there is a duty to ensure that there is a record of this meeting. To not have a record, I think, is a huge omission. And then stemming from that, I think there is also a duty to, in fact, file such records so that everything is a matter of public record. So that is where I come into this debate. Thank you.
Thank you, Honorable Van Minen. Maybe before we conclude on this and go to the next point, I'm going to invite Advocate Bauer, and I'll do this consistently as every point before we conclude it, so that if she has got anything to clarify or to say, she would be given that opportunity between yourself and Advocate Mayos. Over to you.
Chair, there seems to be three things that emerged from this. You clarified at the start that it was not a meeting with the president, it was a meeting with the presidency. There was some confusion during the evidence that was later initially in that regard. The second aspect seems to be that she was accompanied by her officials during the meeting. The details of the meeting and no documentation in respect of the meeting bakes its way into the life of the that seems to be what the gist of it is. I think that's covered when the writers of the draft report puts it into the draft report, they understood they have another look at it to see whether it's captured with reference to the facts in a proper way.
Thank you for that. I said you'll be the last, but Honorable Majosi, because you did indicate you've got load shedding challenges, let me give to you.
No, thank you, Chair. I couldn't hear what Advocate Bauer was saying, and because I wanted to get in on this item of maybe providing a clip of what transpired in the meeting between the public protector and the presidency. So if I may ask Chairperson if that information is important for this inquiry, to have that recording of what transpired in the meeting. So couldn't we, if there was something that was recorded, couldn't we subpoena that we get the recording, so that we are able to have that recording instead of, I don't know, I think maybe we are putting a blame on one party only. I know that it was the PP that was supposed to report about this process, the one that is on the inquiry, but as well, maybe as the committee, we do have that responsibility of having that recording, and if we did, they would then ask what other means did we have to make sure that we get the recording besides from the PP. I don't know. I need clarity from that, Chairperson. Are we just mentioning it for the sake of reporting, or we are we wanted to have that recording so that we hear what transpired within the meeting? If I can get that clarity first.
The clarity and reminder is that the evidence presented here was that there was no recording, and it was seen as an anomaly because there are recordings in all meetings. There were no recordings of that, so the recording does not exist. I hope that assists Honorable Majosi.
It does, Chairperson. So if there was no recording, then can I also get another clarity? Why then are we emphasizing that much on the issue of recording, or is just the issue of wording, whether she failed to provide or she omitted to provide? I wanted to get clarity on that, because I really want us to then move to a direction where we agree maybe on what is it that we are doing, because I need that clarity to say, is it a matter of reporting to the committee, or what is happening?
All right, thank you. Advocate Bauer.
Chair, if I could perhaps assist the member. If one looks at the charge has 4 components to it. Forget about the introductory comments at the moment. That needs to be established. Firstly, the meeting of the presidency, whether that was secret without disclosing the fact thereof in the report. And then the next component is without furnishing in transcripts of the meeting and the obviously record filed with the application under review. Now, the members will recall that based on the court rules, everything that you have regard to for purposes of the compilation of the report must be furnished to the court as part of the court record in the litigation. What was filed as part of the court records was handwritten notes of the meeting that took place with the presidency, which then gave rise to the question of, well, where's the recording of this meeting or the transcript of this meeting? Because in the ordinary course, the practice or operation of PP's office was effectively that all meetings or investigations with persons had to be recorded, and if required, there needed to be a transcript, and there wasn't in this case. And we do know that it was accepted that what had Secretary Nkabani had said, that the discussion with the presidency was in respect of, there were essentially 2 meetings, an April meeting and a July meeting. The April meeting was a meet and greet. The July meeting was a meeting in which she discussed an appropriate remedy, which she sought to give in her report. And hence the view was, well, that meeting should have been recorded, as was the practice of the office. And the absence of those details from the record is what gave rise to the charge. Chair, it might be easy if we do start, and I'm sure all the members have the summations we made, that we direct them to the relevant paragraphs of the summations up front, which then has a sort of a concluding paragraph, which sets out the basic facts, to just refresh their memory. And if we'd omitted anything, then the member would also remember that.
So in other words, you're suggesting, because I would have referred on it, but so that it's beamed on the screen, that part, before we get into the questions. Is that a point which makes sense?
I think maybe the motion first, because the motion is the core, as I understand what they did. The questions that was put up, so they just broke down the charge in the motion.
Okay.
Into those components for the members to answer each component.
As you have just done now.
As I just did now in trying to answer it. And then if they have the summation in front of them, because that's what is done with, if I look at it from paragraphs 50 to 82, where the conclusion is, then in some of the answers that's coming from members would be a lot clearer as we go through.
Okay. Advocate Mayus?
So Chair, I think what would assist is if the motion goes up, because the motion really tells us the questions that must be answered. And that's the questions arise from how the motion is worded.
Okay.
So I think it'll be a good frame if members have the motion in front of them, because then that tells us why it is that the questions are being asked.
Okay. We'll endeavor to do that as we go to the next post. I think we have taken us to the motion in your summary there now.
I think, Chair, for ease of the members, for those who can, they all have the summation on the part one, right after the general index, to make it easier for them, we did put the motion in for ease of reference.
Okay, that's fine. All right. It's taken much longer than I thought in this one, but that's how we're starting. We'll get it flowing as we go through. It's important that would have allowed this kind of interaction so that all of us are clear and will clarify what is not clear in our minds. So I want to thank you for that. Still part of this, I just want to go to the second part, which is about the meetings with the SSA. And then after that, we'll pause for lunch. Is that okay? It's just brief. Can we do that? I'm now between your lunch and but we'll do that, and then after that we'll take lunch and then come back. Honorable Sukas.
Yeah, Chair, I hope I am not taking us back, but I just wanted to ask something in terms of the what was referred to earlier by Honorable Zandile. If and I'm asking the evidence leaders really, if there was no record or there was no piece of evidence like a recording, should there not have been a recollection or an affidavit? Then if there's a failure or an omission to record, let's say, and I think it's the interplay between the two words of omission and failure, but I'm asking the question that if you haven't done the one in terms of Rule 53, then should you not then have followed that up with an affidavit to provide your best recollection of a certain meeting if you didn't record it? I'm just asking the question in general. And I think I'm pointing to what the Honourable was asking in terms of omission and failure. But with your guidance, Chair, I don't want to harbour the point. Yeah.
No, that's understood. As long as you also know that there were handwritten notes as part of that as well. Advocate Bao?
So Chair, from a Rule 53 perspective, you can't file and you can't disclose what you don't have. Just so every piece of paper that is generated in the course of that decision-making process needs to be disclosed when you file your Rule 53 record with court. So if you didn't do the recording, you can't have a transcript and you've got nothing to disclose. That's the first principles. That must be a different issue from, and so when you come to court and you explain how you came about with your remedy, your answering affidavit as the decision maker would probably have to say, well, I had this meeting and I, in consultation with the presidency, considered the remedy of making the referral to the SPU to do that. That's the recordal of it on the one hand. The second part of the recordal is when you submit the report and you write down your key sources of information and you detail what documents you thought was key and what meetings you thought was key and what people you interviewed that was key. And so the first component of the question goes, well, do you disclose this in the report? And the second component of this question is, do you disclose this in your Rule 53?
Okay.
I hope that helps.
Thank you, Advocate Bao. Indeed, and I'm sure Honorable Sukas is assisted in that regard with those clarities. Thank you, members. Can we step off that? I just want to deal with the next point, which is the meetings with the state security aid. During the investigation, therefore, in your view, members, did Advocate Mkhwebane meet with SSA? Did Advocate Mkhwebane meet with SSA? Just go back to the evidence. There would have been a recording played here. Any hand? Yes, ndijonge kuwe into yakho. Honorable Dlakuthi.
Thank you, Honorable Chair. I would say yes. The meeting did take place secretly, without disclosing the facts and also without furnishing any transcripts. So they did. Thanks.
Thank you, Honorable Dlakuthi. You've gone to the next question to respond to it already. But your view is that the meeting did take place. Honorable Heron, I will plug your response to the next point, because the next point is about asking whether the meeting with SSA was secretly done without closing the facts, and as you have just alluded, Honorable Dlakuthi. Honorable Heron.
Chairperson, you anticipated where I was going. I mean, I think on Advocate Mkhwebane's own version, she did meet with the SSA, but I think the meeting I would describe the meeting as undisclosed rather than secret.
Thank you, Honorable Heron. Any other view before I proceed? Honorable Mwala.
I want to get to the secret and undisclosed. I'm trying to replay my mind. There's a meeting where staff members of PPSA were strictly instructed not to record. Is this not the same meeting? It's the same. If chair, is the same meeting where the staff came and testified in this committee and said they were instructed strictly not to record, not to take any records of the meeting, then that meeting was not undisclosed. It was strictly secret. It goes against the practices and standards of how PPSA conducts investigations. Now, it can't be undisclosed. I kept quiet on the other meeting, and I said, fine, undisclosed, maybe a neutral wording. But this was strictly secret. There was a clear instruction from the public protector that do not record this. And unfortunately, in the evidence that was adduced here, there was no contradicting submission in that respect. Thank you very much.
Thank you, Honorable Ngola. Even though we know that there would have been several of those meetings with SSA. Honorable Van Minen.
Hello, thank you very much, Chair. Look, I want to agree with the previous speaker. The fact is that the meeting was undisclosed. There were no transcripts. This is not a case of a meeting that simply wasn't reported. This was a secret meeting. It is very clear from the evidence that every effort was made to conceal this meeting. And I think that's the important point, that when someone is trying to conceal a meeting, it is a secret meeting. And that is how we have to see it. Thank you.
Thank you, Honorable Van Minen. Your second bite, Honorable Heron.
Thank you, Chair. I mean, I think we could go around in circles. I cannot see how a meeting that includes other staff members can be regarded as secret, because other people now know about the meeting. So it's not a secret meeting. It's an undisclosed meeting.
Okay. You repeat the point. Don't. The point has been made before, and that's his view.
still he is not persuaded by the other views about it being secret. So we take that. We're not going to want to persuade and let him change his understanding, but and he motivates for why. Honorable Maneli.
No, thanks, Chair. I was not going to persuade. This is now London, it's a second language or third to some of us. The point, Chair, to make is that there's concealed information. Because even this one, I think this was on from the evidence of Mr. Kekan. This one was in a series of other meetings that would have been held. And that there is an instruction in this meeting when he had already started. Now, I'm taking it back to the questions we asked.
Yes.
And those questions not answered.
Yes.
So they make this to remain unchallenged. So let's just get that picture. He had already started taking notes and was instructed not to take notes from that point. The only reason you will do that is to keep it secret. You want to conceal the information. So their presence doesn't make it an open meeting. They are present, yes, but they themselves can't produce anything further than where the notes were taken and stopped. And the stoppage, as I say, it's not coincidental, it's an instruction too. And I'm saying it has not been challenged, Chair. So I'm saying we'll go around, I think, London. But let's agree, Chair, that at least there's evidence that the information is concealed, and through an instruction, it is meant to keep it that way, that it doesn't go outside. Thanks.
Thank you, Honorable Maneli, Honorable Mananiso, and Honorable Lotrit.
Thank you, Chairperson. I don't want to be rhetoric, but I want to align myself with what Honorable Maneli could have said. The meeting still, it was a secret meeting. Thank you.
Honorable Mananiso, Honorable Lotrit, and Honorable Gondwe. Honorable Heron is at an old hand. Please lower your hand, Honorable Mananiso, so that I see I don't miss you. Thank you. Honorable Lotrit and Honorable Gondwe to follow.
Thank you, Chair. Also, not to go around in circles, but I also agree with the second last speaker that it was quite clear from the evidence that there was an instruction not to take notes. And then the question is, why should there not be notes? And the only inference I can draw is that it was meant to be kept secret. So I believe that this meeting was in secret. Thank you.
Honorable Lotrit, Honorable Gondwe, welcome.
Chair. Thank you very much, Chair. I just want to agree with Honorable Lotrit, Chair, that the fact that there was an instruction given that no notes should be taken and no recording should be made of that meeting with the SSA, gives the impression that it was the intention of the public protector for that meeting not to be disclosed and for no one else outside of that room to know about the meeting. Thank you. So in other words, her intention was for that meeting to be secret. Thank you.
Thank you. And the last question I would pose before I go to the Advocate Bauer at the end, then if so, did Advocate Mkhwebane fail to file transcripts of the meetings with Rule 53 record? Yes, Chair. Honorable Ngosi? Yes, Chair, she failed. Thank you. Honorable Lotrit?
Yes, indeed, Chair, she failed to do that. And all we had in the end was a page taken by the official who were instructed not to take any notes. Thank you.
Thank you. Honorable Gondwe?
She failed, Chair. Thank you.
Thank you. And now, is there any different view to that? None. Advocate Bauer or Advocate Mayosi, any points you want to raise?
Chair, we just need clarity, and we're asking this clarity so that when they put the draft report together, there isn't some confusion on what we're talking about. So there were 3 meetings that involved the SSA. In the first meeting, the lifeboat report discloses that there was a meeting with the Department of State Security on 3 March 2017, which precedes the provisional report. Well, it's after the provisional report and to take those. So there's that is disclosed in the report. There's then 2 further meetings which takes place on 2 further dates, which is on the 3rd of May and then the 6th of June. Those are the meetings that are not disclosed. Now, what becomes important about the way the charge is framed is that the fact and import of such meetings isn't then put into the report, and that comes back to a later charge that happens because that relates to the proposed amendment to the Constitution that comes out of that meeting. So it is important that when the members clarify this, and when they say the meetings were secret and undisclosed, that there is a clear indication from the members as to whether we're talking about all the meetings or we're talking about some of the meetings, and are we saying that the fact and import of the meetings precisely was not disclosed, so that we can get it right in the charge when it comes out. We are reticent as evidence leaders to want to suggest answers to the members or to later be accused of unduly influencing any decision. But we do want some sort of clarity so that when Mr. Ibrahim and the others look at this and they put together the draft report, that we do try and deal with it. And one of the reasons which Advocate Mkhwebane gave for the non-disclosure of the meeting, which we must highlight, is that it was a meeting with the SSA, which was secret, and so that needs to be dealt with by the members. Whether the fact that there was a meeting with the SSA, specifically members of the SSA, warranted that the meeting not be recorded.
Okay. I guess you raise that now as a general point going forward, note that there's no clarity from this input by members now.
Well, I think there's either then what the drafters must do is they must feed the facts into it. And when the members go through the facts, they must then disagree that that is a relevant fact, that it isn't a relevant fact, or they must raise it now. I'm not sure, but I think it must be clear from the floor what is being debated in respect to the facts of the case. Because
Let me go back to what is your actual clarity? Because you too broad. What is your actual clarity? I as a chair, I'm sitting here. I seem to.
There's a summation of factual evidence in which we represented what was the evidence of the witnesses and what was the evidence of Advocate Mkhwebane. In that summation, we deal with, for example, this case, we set out that there's 3 meetings. What would be clear for the draft report purposes is for the members to indicate whether they disagree with how the facts were set out, whether there was an additional fact that comes to it, or whether they are answering the questions posed, taking into account what those facts are, so that there is some clarity in drafting, because we wouldn't want them to then draft a draft report together and the members come back and say, well, we answered these questions, but we didn't actually in this session refer back to the facts. So we need to know what methodology we're using in doing that. Are we assuming that we're basing this on the facts in the summation and together with the facts that we heard at the hearings? I just want that to be clarified.
Any member wants to take up and respond to that? So, Honorable Manel.
Thanks, Chair. Not sure if this would assist. I think the first point, Chair, is that you look at the report. What has been the disclosure in the report? So the report, it gives a disclosure of one meeting of the 3rd of March. You cannot then ignore the evidence laid before the committee that says other than this 3rd of March, there were probably about 2 occasions when there were those meetings and those would have not been disclosed. But again, Chair, this would have been other witnesses. But in her own way of responding, as she come before the committee, she will then give a clarity about a meet and greet with the Minister of State Security, without referring to the name now. But then indicate that as far as the investigation is concerned, it was with Mr. Fraser and Mr. This Ramblin, right? But still, you do not have the reasons why that has not been disclosed in the report. So you'd have failed to do that, and that would still make those meetings secret in the sense that you do not know the context. But even the Rule 53 part, yes, submissions could be made, but you'll have what we saw as evidence presented here, that these are the notes I took and that's what I can submit. But from this point, there was an instruction not to take notes. So I'm not sure if I've confused you even more, Chair, but I just thought it's important to understand that that's how I understand.
Okay.
Thank you, Chair.
Thanks. Honorable Ngosi.
It's 2 meetings. It's the meeting of the 3rd of March and a further meeting of the 6th of June. Am I right? The first meeting is fine. It took place. That meeting was acknowledged by Advocate Enquiry that it was necessary as a follow-up because SAC was a successor to the NIA. It is the 2 meetings that it is alleged were not disclosed. And in respect of the first one, an instruction was given that do not record, which is the meeting of the 3rd of March. The subsequent meeting with a representative of the SAA took place around the 6th of June.
Sorry, if I could just interrupt. There's 3 meetings. The 3rd of March, the 3rd of May, and the 6th of June. The meetings of the 3rd of May and the 6th of June are not.
The 3rd of May and the 6th of June, yes. So I think that to assist Chair, it's in respect of those meetings that you're saying she has not disclosed this. If it makes it clear.
It does. Honorable Heron.
Chair, I was just going to say the same thing. 3rd of March was disclosed. 3rd of May and 6th of June were not disclosed. Thanks.
Thank you. You can switch off your mic, Bauer. I don't know if that's helpful in terms of those responses, and then I come back to you as we summarize this part. Advocate Bauer and Advocate Mayos.
Chair, so the fax and import wasn't disclosed. So the fax and import is set out in the submission, and that wasn't disclosed, although the meeting of the 3rd of March was disclosed, and the meeting of the 3rd of May and 6th of June was not disclosed. As I understand it, there is a debate as to whether a meeting is secret because other people attend the meeting, or whether the meeting is secret but undisclosed in the two opposing views.
Honorable Dlagode, and before I summarize that, because I think we have generated a fuller understanding of that. There's a particular view that was raised, and only that view. Honorable Dlagode and Mola.
Thank you very much, Honorable Chairperson. Yes, the staff were there.
we took some notes and we were stopped not to record the meeting. This means that the meeting was a secret meeting. Thank you.
Mola? Chair, I don't know where we get this thing that the requirement of a secret meeting must have one person. I really don't know where we get it. It can still be a secret meeting even if it's 50 people on the other side, it's 50 people on the other side. But the meeting still remains secret. I don't know how we want to calculate numbers, how many attended and all those things for us to declare secretly. Chair, the meeting did not follow the practices and standards of an investigation of the Public Protector South Africa office. That makes it secret. So I don't know why should we take this long discussing the numbers. That. I understand, Chair, we're going to elections, so numbers are important, but not for this purpose. Thank you very much.
Thank you, Honorable Mola. Honorable Van Binnen. And then last.
Thank you. Thank you, Chair.
For lunch.
Secret is generally defined as not known or not meant to be known or to be seen by others. It doesn't mean solitary. So a meeting can be secret and still be a number of people. It might be a bad secret, but it's still supposed and the intention is to be secret. Solitary is something else entirely, and I think we mustn't confuse language here. Thank you.
Honorable Heron.
Yeah, Chair, I mean, I think the question really is also a legal question. The public protector is obliged to disclose in her reports how she arrived at her decision making. And whether she conducted a secret meeting or not is probably irrelevant. What's most relevant is that she didn't disclose those meetings. So whether you want to call them secret or not, I don't think they're secret when other people are aware of them, unless they were sworn to secrecy and told never to tell anyone, which no one testified to. But the point really is they were undisclosed, and that was her legal obligation to disclose the meetings and how she arrived at the recommendations and the remedial action that she did. And whether the meetings were secret or not, I mean, I don't think they constitute a secret meeting. But I don't think it's legally relevant.
Okay. Thank you, Honorable Aaron. I think we're going to leave it there. That meetings are undisclosed, unknown, and secret. But I take your articulation and the views around that, and I'm sure as you put the report, we'll be able to design that properly. Thank you. I think we're now. Mr. Ibrahim, we have to go for lunch.
Chairperson, just very quickly before lunch, can I just ask that when members make a comment that is not or that doesn't accord with the majority, that they please indicate very clearly if they need us to capture that as a sort of a dissenting view in the report or not. The point now about the secret meeting, as to whether it was secret or not, Honorable Helen is 100% correct. That really isn't the test of what the report would be looking at. So it might be unnecessary to capture a whole paragraph that there was a debate about this. So if members can please just clarify if there is a dissenting view that they feel must be included, that they make that clear so that we can keep notes of that. Thank you.
That's fine. That's in order. I do ask for a different view. So, and I think you, even without asking the member, we're going to have to record that if there is a different view to what has been raised from the majority decision. So I don't want people to be, and I'm sure when they feel strong about that, they will do so. Can we pause there for now and take lunch for 30 minutes? Be back at 10 past or 2:15. We adjourn for lunch. Thank you.
Recording stopped. Recording in progress.
Thank you. Welcome back, colleagues, from lunch. We now resume and then proceed from where we left. So we've done just two sections or subsections, the meeting with presidents and SSA. We now move to the next, within that, next. Paragraph 7.1.2 of the motion, as well as chapter 1, part 1 of the PP report, pages 34 and 48, as well as the paragraphs 89 and 129. So we're going to focus on, and this is about the question is, what was the scope of the investigation in the provisional report of this CX sub or lifeboat matter? And we're going to have similar questions in this, because the next one is, what was the scope of the investigation in the final lifeboat report? Whether the scope changed between the two reports? If so, did that change materially broaden the scope of the investigation? If the scope materially broadened, which parties were affected thereby? And then there will be just two more others questions on this. So let's start with 16. What was the scope of the investigation in the provisional report? This being not an answer, you can assist us, Advocate Power, because you're not being given us a decision. It's merely to indicate what that scope is. I don't want members to crack.
Honorable members, on the virtual platform, we are working to resolve the challenge. We have lost connection on our side.
Okay, thank you.
Thank you, ma'am. Mr. Madam, I see your hand is up. You can just give us a few minutes. We try to resolve the technical glitches that you are experiencing from the venue. I hope you could hear me, Ms. Oh, sure. Thanks, Mr. Madam.
Recording stopped.
That's all. Welcome
Recording
back.
in progress.
We'll check if Honorable Lottridge, can you hear us?
Yes, Chair, we can hear you.
Thank you. Apologies, members and everybody. We got disconnected, and it seems the problem was here with the internet. So we've lost some time in that way. So I'm going to just continue from where Advocate Bauer to do what I've asked her to do. We're now proceeding to paragraph 1.12 and paragraph 7.12 of the motion and chapter 1, part 1 of the Public Protector, pages 34 and 48, and paragraphs 89 and 129. I'm just going to quickly go through all the questions that we'll be focusing on here, and then thereafter ask evidence leaders to just remind us about those issues of scope and so on. The first question is, what was the scope of the investigation in the provisional report? What was the scope of the investigation in the final lifeboat report? Did the scope change between the two reports? If so, did that change materially broaden the scope of the investigation? If the scope materially broadened, which parties were affected? If so, did Advocate Mkhwebane give notice of the broadened scope of investigation to those parties? If Advocate Mkhwebane materially broadened the scope of investigation, did she fail to furnish an explanation for her conduct? We'll be dealing with those, but for now, I'm going to ask evidence leaders so that you don't have to answer those questions, but we can refer to where that is, and then members can respond to these questions. Advocate Bauer.
So the Chairperson get that thing off the screen and the meeting's been. But the factual inquiry principally focused on whether the South African government, National Treasury, and South African Reserve Bank failed to recover public funds through the government by Bank. The substantive scope of the investigation focused on compliance with the conclusion with the concluded contract with SARB and Bank laws and prescripts regarding a decision to not recover an alleged amount of 3.2 billion of government bonds used as security in respective loans by the Bank allegedly owed to the government of the Republic of South Africa and SARB. Second component would be, so that was what was in the provisional report. Now we come to the final report, what we call the lifeboat report, where it's where the following is added. Right? The report in the circumstances seek also to look into reform of the Republic's monetary system in order to realize government's commitment to improving socioeconomic inequalities in society and solicit an amendment to the Constitution in respect of the South African Reserve Bank to create inclusive economic benefits for the people of South Africa. Chair, just so that we understand the questions and the sub-questions we're asking. We're asking the questions in the context of the opening paragraph of the charges. It says, Advocate Mkhwebane adopted a dismissal, high-handed, biased, and procedurally irrational and unfair approach in the conduct of investigations. In that she did the following: materially broaden the investigation, etc., along those lines. Members must just bear that the back of their mind. So those are the two provisions, and then there's a factual analysis of the evidence which then follows on until answering the questions until paragraph 129 of the summations.
Okay, thank you, Advocate Bauer. So we sought to make sure that we give you the background so that you don't have to think hard about that. And therefore, the questions you'll have to respond to relates to whether the scope between the two reports would have changed. If it did, was the change material? And if that material, if the scope of materially broadened, which parties were affected? If so, did Advocate Enquiry give notice of the broadened scope of the investigation to those parties? And if Enquiry materially broadened the scope of the investigation, did she fail to furnish an explanation for her conduct? I see the hand of Honorable Mylam.
Thank you, Chairperson. Chair, the first question is about what the scope was, and the scope initially excluded the role, function, and mandate of the South African Reserve Bank, and the final report then included that in its scope. It materially affected the recommendations of the report because the public protector made specific recommendations that addressed competency that lay with Parliament. It lay with the drafters of the Constitution. It was outside the scope of the initial complaint, and it was a very far-reaching change that was proposed purely on the basis of a policy position of the public protector, which role she does not have. She is not the formulator of policy. So I would argue that there was a substantive change and that it was materially affecting a number of respondents, most particularly the South African Reserve Bank and Parliament of South Africa. Now, the kind of follow-on question to that is, were those people who were affected by it consulted in the scope change? Were they brought in and asked for their opinions? And the answer is no. We've heard that the economist that was brought in was from the SSA, that the Reserve Bank were not consulted about the change in the mandate of the bank, and no other economists were consulted. We heard that Mr. Goodson, I don't even want to try and describe him, but he was not certainly a well-regarded economist who could have given impartial advice to the public protector. So I think that the answer to all of those questions is that there was a scope change, it was material, the people that were affected were not consulted, and that the public protector failed in her duty in that regard. Thank you, Chair.
Thank you, Honorable Mylam. Any additional inputs? Honorable Golangola, followed by Honorable Lockrit and Honorable Ngosi.
No, Chair, I just want to say Melana, no, Honorable Mela. Thank you.
Thank you, Honorable Golangola. Agrees with the issues raised by Honorable Mylam. Honorable Lockrit.
Chairperson, I'm also not going to repeat. Safe to say that I also agree with Honourable Mylam's position on this. Thank you.
You, Honourable Nkosi.
Yeah, I agree. We just have to be specific on the parties that were affected. It's Parliament, there is the bank, it's APSA, and Australia.
Thank you, Honourable Nkosi. Is there any different view? Don't see any further hand, but I do want to ask if there is a different view from the three speakers that have spoken. None. It therefore means that we are of the same mind on these issues, except obviously in the detailing of those affected parties. Thank you very much. Any remarks before we proceed on this from the evidence leaders?
It's just a fourth component to it, which is from paragraph 121 of the summation, is whether Advocate Enquiry failed to furnish an explanation for her conduct.
Honorable Mylam did respond to it in saying she failed, and the members who agreed with the NF supported that. You missed just that one. Thank you. No, the chair is here for that. Thank you. If there's no further comment on your part, I would like to proceed to the next, and I'm going to invite you to do the same as we do that so that we take it step by step. We're now proceeding to paragraph 1.11 of the motion and chapter 1, part 1 of the evidence summation, pages 26 and 34, and paragraphs 58 up to 88. It's Advocate Bauer was doing this too. We're now on paragraph 1.1.3. Okay. Yes. Yes. Chapter 1, part 1, pages 48 to 66, and paragraph 130 to 181. And the issues we need to be looking at before I invite the evidence leaders is what was the remedial action proposed in the provisional report? What was the remedial action imposed in the final lifeboat report? Did Advocate Mkhwebane materially alter the remedial action in the final lifeboat report from what was contained in the provisional report? If so, did Advocate Mkhwebane make the alteration on the instruction / advice of the presidency or the SSAA? If Advocate Mkhwebane materially altered any part of the remedial action, did the alterations require that any affected persons be afforded notice thereof and an opportunity to comment? If so, did Advocate Mkhwebane fail to give such affected persons notice or an opportunity to comment? I'm going to invite Advocate Mayosi so that we are also assisted around issues that might have forgotten, and then we'll invite members to respond to the questions thereafter. Advocate Mayosi.
Thank you, Chair.
With a new card.
Like yours, Chair. Thank you, Chair. So members will see that the charge in this paragraph 1.1.3 call for a comparison between what was contained in the provisional report and what was contained, the remedial action that was in the provisional report and the remedial action that was in the final report. And it also calls for an inquiry into whether those changes were done on the instructions and or advice of the presidency and or the SSA. And thirdly, whether those the changes in that remedial action were done without giving a notice to affected parties and an opportunity to them to comment. Just to remind members for context, the summation as to the comparisons really between the two reports, a proper comparison or very useful comparison is in paragraphs 134.1 up until paragraph 134.5 of the summation. Members will just exactly that. Both reports directed that steps should be taken to recover the interest that had been accrued in ABSA's favor. And then the provisional report directed National Treasury and the SAB to take steps to ensure that the applicable systems, regulations, and policies prevented the recurrence of something similar to what had happened in the lifeboat incident. The final report didn't include such a direction. The provisional report directed National Treasury and SAB to institute legal action against ABSA to recover the accrued interest. The final report then directed the SIU to take steps to allow it to recover that amount of money. The next difference between the provisional and the final report is the provisional report directed the president to consider whether it was necessary to appoint a commission of inquiry to investigate the apartheid corruption alleged in the CIX report, whereas the final report directed the SIU to take steps to investigate the alleged misappropriated public funds given to various institutions as mentioned in the report. The lifeboat report that's the final report. It directed that steps should be taken to amend SAB's mandate as set out in the Constitution, and it prescribed how the Constitution should read after the amendment. In the provisional report, there was no such stipulation. I think I've skipped 134.4. Members will see what it says there. So in short, those are the differences in the comparisons between the two reports. So the questions that the chair then read out earlier then arise from a comparison of those two changes between the remedial actions in the provisional and the remedial action that ultimately ended up in the final report, and how it is that those remedial actions came about and whether the affected persons were notified and given an opportunity to comment. So that's just for the context, Chair.
Thank you. I nearly said honorable. Thank you, Advocate Mayosi. You're not there. I know there are people with some wishes, but honorable members, the context has been given in the summary to clarify the differences. I now want to invite members to, and I would have gone through all of the questions because I think it helps to do that. Before lunch, as we were starting, we were settling into this, but from the last one, it looks like we can do it much better. So I'm inviting if there are any takers and comments on these matters. The issue of what the remedial action proposing the provisional and lifeboat has been now clarified, context given, issues of material altering, whether the alteration were from an instruction of the presidency or the and the SSA, and so on. Any takers? You also remember what I said. If I don't see a hand, I point out. Okay. Maybe let me. Now I was going to help them one by one, but I see Honorable Milam, please go ahead.
Chair, thank you.
You are invited.
Yeah, I didn't want to be the one to talk to all of these things, but okay. So I think that
No,
the issue here.
Don't worry. We all going to talk and repeat. It's a tedious exercise. Go ahead.
So thank you, Chair. I think the issue here is that the remedial action was vastly different in the final report compared to in the original report, in that it made specific recommendations to amend the Constitution. I think that the role of the SSA, I don't think we can go so far as to say that the president or the SSA instructed the public protector to make changes to the report. I don't believe we have that evidence in front of us, but I do think that she acted on their advice and used words that were provided to her by, for example, Mr. Moody or Dr. Moody at the SSA. So I think we would be stretching it to say that she was instructed, but I do think that there is sufficient evidence to show that she was working alongside them and using wording that was provided by them. And I think I'd leave it there. Thank you, Chair.
Thank you, Honorable Milam. The next person will be Honorable Anneli Lottridge.
Thank you, Chair. I also agree with Honourable Milam in that there is a substantive change in the remedial action in the report, but I also am a bit hesitant in stretching it as to say that it was on the instruction of, but it is quite clear from the evidence that there were discussions, conversations held. If we're looking at what the court found and how Advocate Kwebane contradicted herself, that in essence it does come down to that there were discussions. with the presidency as well as state security. Thank you.
Thank you, Honorable Luttrich. You also agreeing with Honorable Milam, including on us having to reframe that the instruction comes across as hard and very definite, whereas it could have been issues of leaning towards them or conversation issues. I now recognize Honorable Maneli, followed by Honorable Gondwe and Honorable Nkosi.
No, thanks, Chair. I also agree with what could have been the difference, including the fact that in the provisional report, those that are not consulted with the change of scope were consulted earlier. I think it's important to bring that point, that whilst there may have been a right to look at matters, extend the scope, but you need to inform the affected parties so that they also understand when you get to the remedial action what then needs to happen. So without mentioning already what has been mentioned about how Parliament was affected, how bank is affected, and so on, that principle of going back to give them an ear so that they make inputs. I think in as far as it relates to the presidency and the SSA, I think from a point of instruction, indeed, it may be something else. But what we know from a point of record, in as far as what has been led before us, that you'll get also from Kekana in the main. As it related to the presidency, it was to meet the legal people on that side, on the part of remedial action, in the which, as we said before, so I'm raising this from a point of consistency, that if the contents of the discussions with the presidents have not been made known, it will not be correct to come to an assumption that there's probably instruction from there. So I just thought it's important to make that point. We do know, again, I'm saying do know because this has not been challenged, Chair, that from Mr. Kekana side is that then a meeting with the SSA was such that even the wording thereof will be assisted from that angle. So when you talk about that part of meeting the SSA, there's also that element there, right? But I would not, as I say it's an instruction from the presidency or the other, but based on what is before the committee, at least that we know that there was a role played, including meeting certain people to even help with the wedding in that regard. So I thought I should raise that. Thanks, Chair.
Thank you, Honorable Maneli, for the contribution. Honorable Gondwe.
I am covered by the previous speakers, but I just wanted to impress upon the fact that we have heard evidence to the effect that there were meetings with the presidency and the SSA and around the involvement of Mr. Mahendra Moodley in terms of the crafting of the remedial action for the ABSA Banco report. So I think the emphasis should be on that we do know that there were meetings with the presidency and the SSA, and we had evidence led, I think, by more than one witness to the effect that Mr. Mahendra Moodley was involved in the crafting of the remedial action. And I tend to agree that indeed the remedial action, varied in the second report as compared to the first one, and to a great extent because now there was, the suggestion that the mandate of the Reserve Bank should be altered. But Chair, I just want to speak also to the exclusion of certain parties in the whole investigation. And I think Honorable Milam alluded to it earlier to say that the Reserve Bank, and I think to some extent Treasury as well, should have been heard. And also maybe, the banking sector in terms of the remedial action, but that didn't happen. And so the picture that was painted from all the evidence that we heard was that it was the voice of the SSA that came up. And there's no denying that the SSA, you will recall that it was NIA at the time was also involved. They played a role in the whole agreement. But what came across very strongly is that the SSA was more involved than any other party in the whole investigation. Thank you, Chair.
Thank you, Honorable Bonda, for your contribution. Honorable Recusal.
I agree with the inputs made by colleagues. Just to indicate that in doing so, in the final report, she exceeded her powers by trying to give instruction to both Parliament and the SIU, something that is not premised on any legal prescripts that gives her the powers to do so. Thanks.
Thank you, Honorable Ngosi. I'm now calling if there's any different view or dissenting view on what has been expressed by the members who have spoken. None. Thank you. Proceed and invite evidence leaders if there's any final comment you want to make or remarks before I move to the next. They are well covered. Thank you very much. We now proceed to the next. And that would be found in paragraph 1.1.4 stroke paragraph 7.1.4 of the motion, chapter 1, part 1, pages 66 and 74, paragraphs 182 to 214. And we'll be interested in dealing with the following questions. Which persons were affected by the findings and the remedial action contained in the final expert report? Did Advocate Mkhwebane give those persons notice of the findings and remedial action and an opportunity to comment thereon? Did Advocate Mkhwebane fail to give notice to South African Reserve Bank and allow comments in respect of the findings and the remedial action contained in the final expert report? Did Advocate Mkhwebane fail to give notice to the Speaker of Parliament and allow comments in the respect of the findings and the remedial action contained in the final report? If Advocate Mkhwebane did fail to do so, were the circumstances such that they should have been afforded such opportunity? Should Advocate Mkhwebane reasonably have known this? If so, did Advocate Mkhwebane's conduct result in consequences that were severely damaging for the South African economy, the public protector South Africa's reputation? Those would be the questions. Some of the question would have been a bit of a repeat from what members had already said. And so I'm now going to invite evidence leaders, and when members speak, you don't necessarily have to repeat what you would have indicated, but if it's for emphasis, that would be fine. Advocate Bauer.
Yeah, I think it was common cause from the evidence that there hadn't been notice given in respect of the findings and the remedial action in the lifeboat report, other than the consultation that had taken place with the presidency and the SSA. So yes, the South African Reserve Bank wasn't given notice about that, and that was the concession that led to the public protector abiding the decision to have the initial remedial action removed with the interlocutory application before his lordship, Justice Mervyn. So that fits into the uh, the judgment that came. So the court had decided that, and she had admitted that she had made changes to the provisioning report without allowing interested parties to have a further opportunity to consider the draft and make submissions.
Thank you, Advocate Bauer. Honorable members, I invite you to reflect on those questions that I've just read to you. Should she have known this and the impact in the South African economy and PPSA's reputation, and whether they really should have been given opportunity to comment those affected parties? Your comments on those issues? I need to see hands there if they are. Slow circle. None. Further comments from the floor? Honorable Lotridge.
Thank you, Chair. I think from the evidence that we have read here and heard, that it was quite clear that these different, from the speaker to the SARB, APSA, were not given the opportunity. And from my understanding, it is also clear that the public protector did not give them the opportunity, although she obviously should know that she should have given them opportunity. And there were enough, I think, opportunities to have given them the opportunity to comment on the report. Thank you.
Thank you, Honorable Lotridge, for your contribution. Honorable Nkosi and Honorable Maneli.
No, Chair, I agree with Honorable Lotridge, particularly on the fact that she would have known that she is supposed to, in terms of her own districts of the previous operation, to have given notice to these entities and individuals of the implications of the remedial action that she was proposing. First. Second, she would have known that from her knowledge of her competency and the law, that she doesn't have the right to make those type of recommendations of the Constitution on amending the mandate.
Honorable Nkosi, Honorable Maneli, and Honorable Mwala. Maneli.
No, thank you, Chair. I think, as you said, we may probably repeat. So I would say that point about notices to affected parties is covered, but I just wanted to get back to the reputation issue, if allowed. That indeed it does affect the reputation of that office, including these other role players that are never disclosed in the reports, but you are able to come to a determination. But from evidence led by Ms. van der Merwe, if my notes are correct, because that's where the issue about amendment to the Constitution comes in, which is a matter raised by Honorable Lucas on us looking at reflections of the data. Because if everything else said by Van der Merwe on where that amendment originates from political party that are to contest an election and then use this as a private member's bill and so on. What it does is that
You're remembering Ubuntu now.
Yes. So what it does is that it leaves an impression of a captured office by politics when it's supposed to be a standalone office that anyone can go to. And you police that matter up until where the SSA gets involved in wording it, knowingly that it's something we should not do. But again, from evidence led before this committee, she herself understood now that you could not make such directives to Parliament when you know we are encroaching in that space. So that has a lot to do with the reputation of that office. That's a submission, Chair.
Thank you, Honorable Maneli. Honorable Mola.
Yes, Chair. Evidence or testimonies before the committee show that indeed there was a threat into the stability of the economy of the country. And most unfortunately is that the public protector proceeded even at the time when qualified and seasoned economists advised otherwise. Such that it should have came to her mind that this would have damning implications into the stability of the economy of the country and in turn the country at large. Chair, it did damage the reputation of the PPSA. Now, Chair, there is a particular reason why Parliament set up certain requirements for people to be recommended as public protectors. And there is a particular requirement, there's a particular intention why those requirements must be strictly adhered to, because part of it speaks to the quality and the caliber of a holder of a public office. A person whom in the ordinary would be expected to have known and had a foresight that if I take these actions, these are the repercussions that are going to follow me. So this goes against why Parliament just undergoes that process of interviews, public participation, and all that, the quality and the capabilities of the person that must be appointed by the president as the public protector. So I think, Chair, in a nutshell, Chair, this has happened before. Not only in the lifeboat, but we're going to get to the details of the SARS rogue unit report. There's been an encroachment there that she has done. In the OSASA R17 report, she has done the same. But we'll get to the details of that when we arrive there. I want to show that it's her modus operandi. Thank you very much.
Thank you, Honorable Mola. Any other hand? And perhaps before I proceed, is there any dissent or different view on what has been raised? None, thank you. Back to the evidence leaders for any remarks. Just your mic.
There is one aspect that I must draw to the members' attention, because the Enquiry provides an explanation in paragraph 191 of the summations, where she tells the committee that she didn't give them an opportunity to comment in the hearing because at that stage in the PPSA, they were not generally giving a second hearing, which called a second audit, where she changed the remedial action, and she had obtained an internal legal opinion from Mr. Nemasisi that says those second audits were not necessary.
Okay, thank you. I see Honorable Maneli wants to have a quick bite on that.
No, thanks, Chair. I'll be quite accepting that at a particular level. The point we have raised earlier on, maybe evidence because we have to clarify that. The point that we raised earlier on, as you look at it, there are two issues there. You had a scope that produced the professional report. You make an assessment, which, as I said earlier, it may be granted that you can look at the report and say, no, probably that have increased. The change of scope would mean that you also have to go back to the affected parties and say, I'm now looking at other issues which they must respond to. So it's not just really at the level of getting the final remedial action. And that is why I'm saying, instead of those that are really directly affected, we do hear other role players who would have been met from different times, from which there's not even been disclosure in some of the engagements with them. So I'm just saying, probably that may need then clarity for purposes of a final report. That would it be proper that you engage in a different scope, and therefore there's no need to engage, because that opinion, in my view, Chair, would be about generally as it would be practiced. But when you change the scope, the investigation is taking a different direction from what was understood up until the final report. Yeah, that's a submission, Chair. Thank you.
Nelly, do you want to comment on that? Anthony Bauer?
Yeah, I think when they,
Yeah,
the committee can have a look at the draft when it comes of the discussion around the issue.
All right. Thank you. We're now going to proceed to the next paragraph. I think we're picking up the pace now. And that will be paragraph 1.1.5. So paragraph 7.1.5 of the motion. And chapter 1, page 74 to 77, paragraphs 215 and 223. And there we'll just deal with two questions. Was there an agreement between the PPSA and the South African Reserve Bank to provide the final lifeboat report to the South African Reserve Bank 5 days before it was publicly released? And if so, did Advocate Mkhwebane fail to honor the agreement? Advocate Mayosi, for my commentary from members.
Thank you, Chair. This one is a fairly simple one. The relevant paragraphs in the summation of evidence are from paragraph 215 to paragraph 223. Members will recall that Mr. Chiwalula, Advocate Chiwalula, gave evidence about the existence or not of this agreement between the Reserve Bank and the PPSA in relation to the final report being given to the Reserve Bank 5 days before its release. Mr. Chiwalula spoke about correspondence that was exchanged, I think in October, during September, October 2016, when he was still employed by the PPSA, where the South African Reserve Bank made reference to an undertaking or an agreement that had been made by Advocate Madonsela in 2013 that they would be furnished with the provisional report. I think 10 days, they would be given a 10-day period to comment on the provisional report after the provisional report was finalized. But paragraph 1.1.5 of the motion doesn't talk about the 10-day period. It really talks about a period of 5 days, and it relates to the final report. Members will see from our summation of the evidence that the evidence that was given by Mr. Chiwalula, as well as evidence that came out from affidavits made by the South African Reserve Bank in the litigation when it was challenging the lifeboat report. They stated in one of their founding affidavits that they asked for an undertaking from Advocate Mkhwebane relating to giving them sufficient time before the release of the final report, but Advocate Mkhwebane didn't give them that undertaking. Advocate Chiwalula couldn't tell us much about the 2013 meeting because he was not in attendance at the 2013 meeting. And in any event, the 2013 meeting speaks about some form of undertaking, a different kind of undertaking. It's a 10-day period for the provisional report. So members will see from paragraphs 215 to 223 that the evidence as we set it out and to which Advocate Mkhwebane has responded. Her response in her statement is that she has no recollection of giving such an undertaking to give SAB the final report 5 days before it was released. The summation that of the evidence as appears there, we could not find evidence that disputes that, but the committee's inquiry then will need to ask whether there was an agreement, and if there was, whether Advocate Mkhwebane then failed to honor it.
Thank you, Advocate Mayosi. Back to your members. 2 issues to look at: the issue of those report being released 5 days before, as well as whether if there was any agreement with Honorable Heron.
Thank you, Chair. I thought Advocate Mayosi was going to go all the way there, but I think it's clear from paragraph 223 of the summation of evidence that there is no evidence of an agreement. And then, as proposed by the evidence leaders, if there had been one concluded with Advocate Madonsela, there's no reason to hold Advocate Mkhwebane as being bound by that agreement. So I think this charge has not been sustained by the evidence. Thanks.
Thank you, Honorable Heron, making a strong point that the evidence is not able to sustain the charge. Any other comments? Is there any different view, therefore, from what Honorable Heron has raised? None. There's no difference.
If an institution as big as SARP they've made up an issue of there being an agreement and put it on paper that there was such an agreement, there was such an agreement, to give them time. The days are important, but they're not material. The issue is such an institution wouldn't make such an error. So despite there being no evidence, I think that for me, it's important for us to really have established whether indeed this agreement agreed. Where did it arise? In what circumstances? Because this materially affects the arrival of the PPA at the finding.
Thank you, Honorable Ngosi. Advocate Bauer.
Chair, maybe as a clarification, we've done an assessment of the evidence. We're not saying that our investigation is not the truth or the untruth of the evidence before it. So to be clear, there is some debate in the papers where the South African Reserve Bank asks for an undertaking. But there must be an ask and there must be an answer. And we were not convinced that the answer was that unequivocal that the lines could have been placed on it. And so if we were not sure about that aspect of it and we couldn't get some finality on the evidence, we didn't find on a balance of probability that could be concluded. But that doesn't mean that there wasn't anything about the 5 days being sought. And I think there was correspondence about it, but there was never, we didn't find an answer where an undertaking was given. Yes, you've asked for it and I'm going to give it to you. If that puts it into some sort of a context from where the Reserve Bank was coming from. They certainly wanted it. We didn't see that she had given it.
Thank you, Honorable Bauer. I don't know, does it help? But as you indicated, the issue of the day is not material, but you were more curious about why the Reserve Bank would have in the first place thought about that and asked that. But I think the points you are raising still remain. It's not you're not necessarily disagreeing with the Honorable Heron in saying that we're not necessarily having evidence to sustain what is in the motion. Any comments? I don't think Advocate Bauer is able convincingly to say this, and she's just answered now that they couldn't find I think what you're looking for. Honorable Manel.
No, thanks, Chair. I think we should accept that there's nothing to touch and feel as concrete evidence from a point of response. But I also don't want us to ignore that there is a response. And that response says, I have no recollection. So when you do not have recollection, you are neither dismissing or accepting it. And I think it's an important point when you have taken over from a previous or your predecessor, because you don't know at what point that commitment would have been made. So I'm just writing on a point raised by Honorable Gosi, that for an institution big as that one, where there are serious implications of what will come out of a report, as shown when this was being the concerns about financial systems and everything else. It should really take pains to make such. So I was just saying, Chair, we would have difficulties in pursuing it further than that when actually there's no recollection. That's what I would choose. Thank you, Chair.
Thank you. Thank you, Honorable Walel, for that elaboration. Does help. I guess that's where we're going to leave it. And it will be recorded as such. We're now going to proceed to the next brief section. I would not mind that we just take 10 minutes tea break, and then come back and do this. We're still going to be here for some time. We take a 10-minute break. Thank you.
Recording stopped.
Hello.
Recording in progress.
Welcome back, colleagues. It's now 1600 hours, 4 o'clock. We now resume the next, and I'm going to put together two small sections together, which will be paragraphs 1.1.6 stroke paragraph 7.1.6 of the motion, chapter 1, part 1, page 76, 77 to 82, and paragraphs 2 to 4 to 40, as well as paragraph 1.1 of the motion generally, chapter 1, part 1, pages 82 and 83, from paragraphs 241 to 242. We'll put those together, and the questions that we want to attend there will be: does the lifeboat report refer to or discuss the submissions of the South African Reserve Bank in response to the provisional report? Does the lifeboat report refer to or discuss the submissions of other interested parties who responded to the provisional report? And 39, under the next paragraph, given the conduct found to have occurred pursuant to the above paragraphs, was Advocate Mkhwebane dismissive, high-handed, biased, and procedurally irrational and unfair in the conduct of the investigation? That is going to become a very key question. And therefore, before I invite members, I'm going to ask Advocate Bauer to do as we always do,
So Chair,
context-wise.
we split this up into dealing with the three main parties, and we looked at each of these submissions in turn. And so the first one is the South African Reserve Bank submissions, which we deal with in paragraph 225, 226 of the submission. And we come to a conclusion, having evaluated the evidence, that in paragraph 228, that from a consideration of the report, most of the Reserve Bank's concerns in one way or another appear to be referenced in the document. So then we turn to the submissions made by the Minister of Finance and National Treasury, and we deal with that in paragraphs 232 onwards. And Advocate Mkhwebane had explained in an affidavit to the committee, paragraph 230, that in response to input from the National Treasury, she had removed some of the remedial action previously proposed, to the effect that there was a need to amend the Reserve Bank, and then that's what she, Reserve Bank Act in 230, quote from her statement. And then we look at the submissions that was made by the Minister of Finance and National Treasury, insofar as it's in the report, and we do see that some of the submissions that would be material are not reflected in the lifeboat report, which we come to that conclusion in paragraph 233 and in paragraph page 80. And then we the lifeboat report also doesn't reflect or discuss the Minister of Finance's submissions regarding the national government's agreement with CX, including whether the agreement commenced, why it was terminated, the reasons for such termination, and why Cabinet would not have acted on the report. And they express there's an expression of concern that those reasons as to why the government given for terminating the agreement with CX doesn't appear emerge from the report. And so we say that it doesn't deal with the minister's concerns regarding the extent to which the report undermined the government's institutional integrity and its ability to promote public confidence in the administration. So that deals with those aspects. And then we looked at the absent submissions and what they deal with in paragraph 238. and ABSA's submissions in respect of access to evidence and the remedial action are not referenced in the report, but the substance of the other submissions, even if not necessarily satisfactorily or addressed to ABSA's satisfaction, is dealt with to some degree in the report. That's a little bit of a yes and no response, Jay, having looked at all the components of the evidence.
Okay. Thank you. I'm now going to invite members to respond to those three questions. 37, 38, and 39. No comments on those. Does the life board report refer or discuss the submission of in response to the provisional report? Does the life board report refer or discuss the submissions of other interested parties? And lastly, this overall question need to respond to that given the conduct found to have occurred pursuant to the above paragraphs, was Advocate Enquiry dismissive, high-handed, biased, and procedurally irrational and unfair in the conduct of the investigation.
Chief, sorry, I didn't address that aspect. Sorry.
Then please address it before I go to members. Then you can take this mic above your laptop so that that's it. Then members can hear. Sometimes you lose you.
Sorry, Chief. They are, that's addressed in paragraph 2, 41 and 242 of the written submissions, and it goes towards the question of procedural fairness and the question as to whether it in some way infringed on the powers of the Reserve Bank, and whether there should have been a discussion with the experts of the Reserve Bank before such a recommendation has been made, and the conclusions that was reached by the full court that was then upheld by the majority of the Constitutional Court subsequently thereto. Thank you, Chair.
Thank you. Thank you, Advocate Bauer. Over to you, members. Are there any takers? Honorable Recusal Nkosi.
Chair, with respect
to follow.
Yeah, with respect to the questions, I think that as indicated in the summary, with regards to the Reserve Bank, indeed, that some of the in the live board report, some of the issues are raised. So there's no issue about that. It is with respect to the Minister of Finance, 237. I think that where it's clear that the input of the Minister of Finance about the institutional independence of the Reserve Bank, its relationship with government, the concerns about the integrity of government processes, and the investigations that had been done on CX, and the views of the independent panel, etc., that were not factored in the live board report. And that opportunity had not been given to, and not opportunity as such, but that the inputs of National Treasury had not been, or the Minister of Finance had not been factored in the report. And also related to that is the fact of the confusion of the roles of Presidency, Minister of Intelligence, and the Minister of Finance. And that overall it indicates that there was unreasonableness on the side of the PP. With regards to ABSA, I think the same, that the ABSA's concerns were not reflected in the final report, irrespective of the fact that they were given. And I think that on the issue of procedural fairness, it's clear that the PP did not adhere to that requirement, and the concerns raised by the bank as a acting participant in that process were not factored in the report. And in that regard, then the question is answered in the, for me, in the affirmative, that to say that she did act in an unreasonable, high-handed manner. Yeah.
Thank you, Honorable Gossi. Honorable Twalangola.
I agree with the Honorable Ngosi, and just to add some few on in respect of this report, was she dismissed? So you recall that I had said even before the final report was issued, there's been a number of inputs in the public outcry and a public discussion about what damage will this cause the economy of the country. And the economists, many of them have been at the forefront in saying this would have serious repercussions in terms of the stability of the economy, but that was ignored in terms of the approach and everything else. It does not mean that when you take consideration of something, you agree with it. But dismissive means you just say, no, I don't care what you are saying, I'm proceeding, regardless. So I think from where I'm seated, it's my view and my analysis of the evidence that has been tabled in this committee that yeah, she did wasn't in a dismissive and heavy-handed. You'll recall, Chair, that SARS, South African Reserve Bank actually says there was an agreement of 5 days or something, 5 days before the actual issuing of the report. They must be notified and all that, and that was dismissed and ignored. So from where I'm sitting, I think I'm saying yes. Thank you.
Thank you, Honorable Mola. Any other member? None. Is there any different view or dissenting voice? And Honorable Lotrit.
Chair, I raised my hand before you ask your last question, but this is just to also express my support.
You don't want me to refer to you as dissenting?
No, please not. I okay. Concur with what the previous two colleagues said. Thank you.
Thank you, Honorable Lotrit. I guess there's no other further point. Any remarks from the evidence leaders? If none, we'll proceed to the next point. Thank you. I take you to the next section from 40 to 43, paragraphs 1.2.1.1 of the motion, chapter 1, part 1 of the evidence summation, pages 83 to 92, paragraphs 243 to 278. And those would be the questions that we want to focus on in affidavits in the litigation regarding the lifeboat report, both before the High Court and the Con Court. What accounts did Advocate Mkhwebane give of the meetings she held with the presidency in the course of finalizing the report to the High Court, Con Court? Were those two accounts to each court full, frank, and honest? In the affidavits in the litigation regarding the lifeboat report before both the High Court and the Constitutional Court, what accounts did Advocate Mkhwebane give of the meetings she held with the SSA in the course of finalizing her report? Were those accounts to each court full, frank, and honest? So it will be in relation to the SIA, the lifeboat, and so on. So I'm going to ask evidence leaders to give us a context around these and then invite members.
Okay. maybe the context must start with the following. There's proceedings before the full bench of the High Court. That High Court rules against Advocate Mkabani and dismisses or grants the review application and makes a personal cost order against her. There is then a direct appeal to the Constitutional Court only against the cost order. Right? So we must understand that's the context. There are majority judgment handed down by the Constitutional Court, and then there's a minority judgment, which is a dissenting view, which is from the then Chief Justice McQueen, signed on by one of the other judges. Both, you will recall, both Advocate Mpofu and myself took you through those judgments right at the start when Mr. Kakana gave evidence. Advocate Mpofu took you through the minority judgment, the dissenting judgment, and we took you through the majority judgment. And so the question that's been asked is split up because the question isn't just about, it says litigation, and there's two sets of litigation, one before the High Court and one before the Crown Court. The High Court makes the finding as one of the precursors to the cost order they make, and we conclude that in paragraph 251 of the summations that the version of events of the June 2017 meeting remained what the court called veiled in obscurity, as it was not disclosed in the Life Court report or explained or referred to in the affidavit. There was no transcript in the minutes of the meeting. That's before the full bench. So there's that issue on the meeting of the presidency. Then we come to what the Constitutional Court does. So when the matter comes before the Constitutional Court, there's two versions. There's the version that's put up in the application for leave to appeal to the Constitutional Court, which you see there in paragraph 252, where she explains that the meeting on the 25th of April 2017 was the meet and greet and not an issue that related to the sorting. And then on the 7th of June, which you go down further, she says that was the meeting where she was accompanied by Mrs. Nemasisi and Kakana, and that had nothing to do with the substance of the content of the report. So that's the explanation that's given on that. So we call it the founding papers in the application for leave to Concord. There is then a replying affidavit in the Constitutional Court. And she then explains to the Constitutional Court that why she had not disclosed the meeting with the presidency. And then she later says it wasn't deliberate, but that what she had discussed related to figure out 256 in a replying affidavit. She discussed the issue of the remedy of the SIU for the presidency, and that it was necessary to meet with them in June 2017 at their behest. And there was then a need to discuss it because she had indicated in a High Court application that she was concerned about the issue of the draft remedial action to direct the president to establish a judicial commission, and they may have similar difficulties that was being faced with what was then at that stage the challenge of the state capture report. So it was in that context that there was a concern about what could have been regarded as a differing approach in the affidavits that was put before the various courts. And so there is then a replying affidavit filed in which she discusses that in greater detail, including which is set out in 261. And she says that the meeting of June 2017 had nothing to do with the substance of the content of the report. So the issue comes as to whether there is a varied version, whether she did discuss the remedial action of the presidency, as indicated in one affidavit, or whether she didn't discuss, as indicated in the other affidavit. And that is linked with Mr. Kekana's notes that he had produced at the time, and in paragraph 264, proposition was put to Mr. Kekana during cross-examination. That the issue that was being dealt with at the meeting, second meeting with the presidency, dealt with the issue of the SIU, in other words, the practicalities about the SIU proclamation. And so there is a definite difference in the way one looks at the affidavits. And so it's in that context that the question is asked under paragraph 1.2.1.1 in doing that. So that deals with the reserve bank, and there is a difference of interpretation that was put out between the views of the majority judgment and the minority judgment on the extent of disclosures that was made. And then when we come to the SSA, which we discussed in paragraph 271 onwards, quite a bit of it was not before the High Court matter. In her answering affidavit. And when it came to the Constitutional Court, she relied back on the High Court affidavit. There is no dispute before this committee that the remedial action regarding the constitutional amendment was raised with the SSA. That Kabani told the High Court in respect thereof. And we now know we have more information before us as the committee as what was before the courts. I can take it. We've summed up the evidence in this paragraph.
Thank you. Thank you. It was a bit long, but we're here for that. Thank you. And therefore, all members, any takers, any responses to those listed questions there, now that you have also the refreshed background on the context, in case you would have forgotten. May I invite contributions? Indifferent. You have no view.
No, we do, Chair.
Okay, Honorable Begizo Ngosi.
Yeah, Chair, I just want for evidence leaders to indicate the salient differences in the between the two affidavits. I think generally you get the idea that she did not disclose full information in respect of both So if you get the salient differences, 1, 2, and reference to the paragraphs that explains that. Without.
Okay. Thank you, Honorable Ngosi. Before I go to Honorable Maneli, Advocate Bauer, did you get that? Okay. Is that too quick? Okay. Honorable Maneli.
No, thanks, Chair. I want to raise from the point that indeed there is a sense of differences. That on one, there may be signs of no disclosure completely. But then when you get to the other level, that's because the council has withdrawn and then particularly prepare properly, then will come back to say something about it. So recognize that the president has got the proclamation order that he gave. So you see the relevance there, which is also backed up by what Mr. Kekan. I think I raised this issue before when I said, what is it that's before us? As it relates to SSA, you may not have disclosures, but at the end, you do know that the wedding was done by the SSA, right? So you do find those, as far as I'm concerned. But as I say, the evidence does know we want to get to the exact points as put in the paragraphs that were flagged. But clearly, you have that difference that's put there. And I want to emphasize all the time, Chair, that these are meetings that are not disclosed in the courts as a starting point. Before you talk courts, which is, I think for me, an important aspect, because as you get to the court, they are using these reports, all sorts of source documents that you use to argue the case, right? That's fine. The first. The second issue, that I think for me comes out is that whilst there is an expectation, and I'm coming to framework at what you started with, what Ibrahim raised with us, right? That if you had this info that you're able to raise in a court, why would you have withheld that info at the law court? Because surely it means they would have considered something different based on what you're presenting. That is not just about making those appeals, Chair. It's directly linked to the resources that go with that. The matter that could have been handled and dealt with at a particular level, and especially where you are the one litigating. I think it gets to be something that's a bit of a problem, which shows that there's a problem that in the office now the PPS and this matter. Thank you.
Okay, thank you, Honorable Maneli. Any other member? I know that Honorable Ngosi will come back once Advocate Bauer assists him there. Is there any other member, even with a different view? None. Back to you, Advocate Bauer.
I'd already gone into more detail than what I wanted to do, but I think if I can direct the honourable member to the paragraphs in the summation that sets out the different versions. So if we look at how it starts with an affidavit from the applicants in the litigation, and then Advocate Enquiry files an answering affidavit, which is dealt with paragraph 245, right? And she explains that the president called for a meeting relating to section 7(9) notice, and that she agreed for this meeting to happen on the 25th of April, She was accompanied by investigators, and that following the discussion at this meeting, she became concerned that the remedial action proposed in the provisional report could run into difficulties. And what had previously been alleged in the affidavit before the High Court was there was a meeting on 7th of June 2017 that had taken place with the presidency's legal advisors, and that they found from the notes that they discovered in the Rule 53 report, which we now know to be the notes of the investigators, right? So we've got that on the one hand before the High Court. Now we come to the Constitutional Court, right? So we know that the affidavit before the High Court doesn't say anything about the meeting on the 7th of June. It's raised by the South African Reserve Bank. She doesn't answer. So now we come, and there's nothing before the High Court that says what was discussed at the meeting with the presidency in that regard as to the 7th of June. And so the full court reaches a conclusion, which you see in 251. Now let's come to the High Court, the Constitutional Court after that. Advocate Enquiry then applies for direct access. You see that in paragraph 242, 52. And in a founding affidavit, she describes the meetings with the presidency. So she first explains that the date was wrong, that it was only a meeting on the 25th to do with the meet and greet. She had gotten the date wrong, and she had previously related the 25th of April to the meeting that occurred on 7th of June. And then she says, my meeting of the 7th of June, look at 252.3, right, had nothing to do with the substance of the content of my report. The presidency had requested this meeting in order to clarify their responses. Okay. Then there's an answer that's put up in the Constitutional Court. And then there's a replying affidavit in the Constitutional Court. And in the replying affidavit, she explains that she had had difficulties with filing of the answering papers before the High Court because of the withdrawal of counsel, etc. And would settle the affidavit, and that was by way of an explanation as to why things had been wrongly presented to the full bench. She then explains to the Constitutional Court why she had not disclosed the meeting with the presidency in the lifeboat report. And she says that I didn't disclose the meeting in the report because it is covered by the presidency's response to the provisional report, which requested a meeting in order to clarify the response. The meeting occurred on 7th June. That is where I indicated that there is a pending judicial review about state capture, and I asked about the report of the SIU, which they did not have, but clarified that if the proclamation is issued, there's no report that remains valid. That was raised when I asked about the issuing of proclamations, which is the sole preserve of presidency. And she asked for clarity. But later in a replying affidavit, she also said the June 2017 meeting was not deliberative as it dealt with the presidency's clarification at their request and in accordance with section 79A of the responses to the provisional report and in respect of the status of the proclamation that had been issued to the SIU, to which no report of the SIU had been issued. So, but on this revised timeline that's set out in Advocate Nkambani's founding affidavit in the Constitutional Court, it was called into question what another aspect of evidence before the High Court was. Because in the High Court, she explained that from the discussion during our meeting, I became concerned that my draft remedial action to direct the president to establish a judicial commission faced similar difficulties as currently facing the state capture report. That means that she had concerns about this judicial commission, the remedial action that arose after a discussion of the issue with the presidency. That's what the High Court affidavit says. But the difficulty for but before the Constitutional Court, the version that was put before the Constitutional Court was that she had only met with the presidency in June 2017, at which this was raised at the prerogative in the presidency. However, the other affidavit was signed in May. And in May, She indicated that she had concerns about it that was raised as a consequence of a meeting with the presidency. And that was the difficulty that one had if you compared the affidavits in that regard. I hope that assists the members.
For their own recollection, let me check them. Honorable Maneli and Honorable Ngosi.
You retable the questions.
Okay. Okay, you're done. You want me to check to go to the questions, Honorable Ngosi, to remind you? The questions then Honorable Ngosi are in her affidavits in regarding the lifeboat report, both before the High Court and the Concord. What accounts did Advocate Mkhwebane give of the meeting and meetings she held with the presidency in the course of finalizing the report to the High Court, to the Constitutional Court? Were those accounts to each court full, frank, and honest? The key question. In the affidavits in the litigation regarding the lifeboat report, both before the High Court and before the Constitutional Court, what accounts did Advocate Mkhwebane give of the meetings she held with the SSA in the course of finalizing the report? Were those accounts to each court full, frank, and honest? Now, just the questions should be rounding them up, having connected with the context. Honorable Ngosi.
Oh, it's fine. In that case, Chair, I think I agree with Honorable Maneli's responses. I'm just concerned that sort of big concern that while she's not able to move, then she goes to legal counsel. And that is not, there's no indication what legal counsel provided. I stand to be corrected. Yeah, I think the primary thing is that the meetings are not disclosed. The reflections of those meetings in both the High Court and the Constitutional Court were different in what was submitted in the High Court and in the CC.
Thank you, Honorable Ngosi. You want the second bite, Honorable Maneli?
Just to conclude point in the discussion. It therefore means that you did not have full disclosure. And of course, once you have different versions on one matter, you can only display dishonesty in answering that question. So I thought that for purpose of record, that's what we read from it. Thank you, Chair.
Thank you, Honorable Maneli. There being no other member on the point, we will move to the next. And now again to put two. And now, no remarks from the side. Thank you. Proceeds to paragraph 1.2.1.2 of the motion, chapter 1, part 1 of the evidence summation, pages 92 to 99, paragraph 279 to 308. In affidavits in the litigation regarding the lifeboat report, what claims did Advocate Mkhwebane make about relying on the evidence of economic aspects while drawing up the report, again to the High Court and to the Constitutional Court? In those affidavits, did Advocate Mkhwebane correctly represent her reliance on the evidence or misrepresent her reliance on such evidence? And I would want to conclude the other one, paragraph 1.2.1.3 of the motion, chapter 1, part 1 of the evidence summation, 99 to 100, paragraphs 309 and 314. What accounts did Advocate Mkhwebane give of the investigation of ABSA's repayment of money to the South African Reserve Bank? And lastly, were her accounts contradictory, unintelligible, and obfuscating? Those are the questions, but we'll start with the context first from Advocate Mayusi.
With the allegations in paragraph 1.2.1.2, which is that Advocate Mkhwebane misrepresented her reliance on the evidence of economic experts when drawing up the lifeboat report. So, Chair, the summation, of course, as you've said, appears from paragraphs 279 to 308 of the summation document. So in her affidavit before the High Court, Advocate Mkhwebane made a number of claims about relating to economics and reliance on experts. She said that she was making these claims on the basis of advice received from economic experts during the investigation of the complaint, and so on and so on. So the question then arose as to who those experts were that she relied upon. She then continued in her answering affidavit to say that after the review applications were instituted, she engaged the services of a Dr. Tsepo Mukoka, who's an economist and a lecturer at Wits, to consider the true nature of the lifeboat scheme. So on that version, then, Chair, it then becomes clear that Dr. Mukoka could not, his services were not engaged during the course of the investigation, because on her own version, the public protector stated that he was engaged after the review applications had been launched. So that would have been after the report had been finalized. The litigation then continued, and she made an application, I think, for direct access to the Constitutional Court, and in her founding affidavit there, she then specified that she interviewed, amongst others, a Mr. Stephen Goodson, whom she described as a well-known author and a former independent non-executive director of the Reserve Bank. The Reserve Bank then, in their answering affidavit, they challenged her. They said that her claims about reliance on economic experts, what she stated in the issues she stated in her affidavit, actually came directly from Dr. Mukoka's investigation, which as demonstrated, Chair, she engaged Dr. Mukoka's services after the lifeboat report was already finalized. So then in her replying affidavit, she explained her version more clearly and zoomed in on her reliance on Mr. Goodson. And then also it then became even clearer that Dr. Mukoka only came into the picture after the review. So Mr. Goodson then was the economic expert, as she described him, that she relied on during the course of the investigation. Mr. Kekana's evidence also comes into play here, because he also testified about reliance on Mr. Goodson. He also then testified about reliance on Dr. Moodley. And there, what Mr. Kekana said in his evidence is, I think he attended a meeting. He said he attended a meeting with the Advocate Mkhwebane and representatives from the SSA, where Dr. Moodley was introduced by Advocate Mkhwebane as an economist. During the cross-examination of Mr. Kekana, Advocate Mpofu confirmed that Advocate Mkhwebane's evidence was going to be that Dr. Moodley was presented as some kind of economic expert who had also worked in the South African Reserve Bank space. So Mr. Kekana then said that during this meeting, Dr. Moodley produced a single page that contained a draft of proposed recommendations that were to be inserted in the lifeboat report. And the content of of that single page appears at paragraph 297. And it will be evident from that content that Dr. Moodley, that the content there does not contain any economic advice as referred to in Advocate Mkhwebane's answering affidavit. It didn't set out any detail about the role of central banks, the functions of a lender of last resort, and so on, economic issues. So the expert then that she clearly relied on during the course of the investigation is Mr. Goodson. She also relied on Dr. Moodley to some extent, but as the content there shows, that which the content that he provided, which was ultimately inserted in the final report, does not relate to economic issues. Members will also recall that Mr. Baldwin Nshunzi also talked about Dr. Moodley. He described him as an expert in IT from the SSA. He said he met Dr. Moodley when Dr. Moodley and Mr. Fraser and Mr. Ramabulana attended a meeting at the PPSA. So Advocate Mkhwebane hasn't called Dr. Moodley to testify in these proceedings. She hasn't qualified him necessarily as an expert. We don't have a statement from him describing his exact expertise and the full extent of his economic advice to her during the course of the report. So the questions that then arise in this inquiry, in which the chair has read out to members, then seek to inquire into whether she misrepresented her reliance on the evidence of economic experts in drawing up the report. I think, Chair, if you could, I think there are three questions that arise from that. If you could just. Just to point out, Chair, that the members do have Dr. Moodley's CV for the purposes of assessing his expertise.
Thank you, Advocate Mayosi. Honorable members, I invite you to make your comments. I started from 44 to 47. We'll repeat that, those questions. We start with Honorable Milam.
Thank you, Chairperson. Chairperson, I think it's clear from what we've seen, the evidence that we've seen, and from what Advocate Mayose has just reiterated for us, that there was a misrepresentation of the reliance on economic experts. And I say this because, first of all, the wording of the remedial action in the report is directly, correlates directly with the document that was provided by Mr. Moodley of the SSA. So the pattern of influence is clear. However, it goes further than that. And that is the question of whether or not the persons that she relied on, namely Mr. Moodley and Mr. Goodson, can be quantified as economic experts, whether they are sufficiently diverse to provide an impartial recommendation to the public protector, whether they have adequate broad economic experience, knowledge, and input to give that an impartial flavor. And I would argue that they don't. I would argue that it comes from a particular ideological background that then the public protector has imported into her findings and into her reliance in reaching a remedial action based on their input. The input of the academic from WITS
as has been pointed out, came after the fact, and you cannot then say that she relied on that input going into her final report. So I think that the evidence is clear that Advocate Mkhwebane did misrepresent her reliance on economic experts. Thank you, Chair.
And would you say that her accounts were contradictory, unintelligible, and obfuscating?
Chair, I'd rather not venture an opinion on that at this stage.
Okay, thank you. Honorable Gonde?
Yeah, I was just going to agree with Honorable Mileham to say that she didn't rely on economic experts. She relied on Mr. Goodson and the content of his book, because you recall that I think it was Mr. Kakana who said that she said he must read Mr. Goodson's book. It's a good read, that type of thing. And she also relied on Mr. Moodley, whose qualifications to this day, I'm not sure I even know what they are, although I have seen the CV, but I don't know. But she did not rely on any economic experts. Had she done that, then she would have relied on the evidence provided by economic experts in the Reserve Bank or maybe in academia. So she didn't. And she misrepresented her reliance on the evidence of economic experts. And, I mean, if you're going to rely on economic experts, you have to rely on people that are feeding into the discourse around economics and are well known. And I'm sorry, Mr. Goodson can't be considered a well-known, economist and author, and Mr. Moodley as well. He worked for the SSA. I'm not entirely sure why she would then, rely on anything he has to say, because as far as I know, he wasn't working for the SSA as an economist. So yes, I tend to agree that she misrepresented her reliance on the evidence of economic experts. She didn't rely on economic experts. She relied on two individuals, Mr. Goodson and Mr. Mahendra Moodley, for reasons best known to her. Thank you very much.
Thank you, Honorable Gonde, for your contribution. Honorable Maneli.
No, thanks, Chair. I think the points have been canvassed, and I think the conclusion to make is really that honestly there was no reliance on economic experts. But I think what gets to be quite contradictory, Chair, is that almost in the same period, on one important aspect where the poor needs to be protected and treated by an institution that is meant to protect the poor. The reason would be that there would have not been resources to have economic experts. But in pursuance of something that's way outside of what you need to deal with, then there'll be all sorts of them, with one becoming IT, security, and economics at the same time, Mr. Moodley, in this scope. I think it's also something that tells a lot of stories about changing the engagement depending on what you are engaging in, even if it is the same matter. Thank you, Chair.
Thank you, Honorable Maneli, for that contribution. Do I have any further members or members with a different view? None. Any remarks from the evidence leaders?
Chair, there was a second component to your question which hadn't been answered because I was going to address it, and that was the provided contradictory, unintelligible, and obfuscating accounts of the conduct during the investigation. Now, three aspects have been dealt with thus far: the meetings of the presidency, the SSA, and her version regarding the reliance on the evidence of the economic experts. Paragraph 311, we quote what the Constitutional Court said that Advocate Nkabani either failed entirely to deal with the allegations that she was irresponsible and lacking in openness and transparency, when she did address them, offered contradictory or unclear explanations. And so so that assessment needs to be made in the three aspects that have already been addressed by the committee. And then we raise the fourth aspect, which relates to the payment by Absa Bank, where the lifeboat report records that the CX report had alleged that the Reserve Bank had failed to recover the amount of 3.2 billion from Bangkok and Absa, and that the correct amount of the illegal gift was effectively 1.125 because Absa Bank had made a payment of 1.5 billion. But in the affidavit before the High Court, it was stated that Bangkok had never paid a single cent to the Reserve Bank, and then included the challenge to Absa to demonstrate in reply what these payments were. So the report was contradictory to what was stated on affidavit. And there was no mention in the section of the affidavit which discussed the unlawfulness of the lifeboat scheme at all of the amount that Absa had repaid to SARB. That was the only additional aspect apart from the three that the committee has already considered in that regard.
Okay, thank you. Any comments on that last part by Advocate Bauer? None. Honorable Lotrich and Honorable Maneli, as well as Honorable Heron.
Thank you, Chair. I think that if one goes through the evidence led, to my mind, it is clear that the affidavits were in a few instances contradictory and also obfuscating. The unintelligible, I won't express myself on that, but definitely there are contradictions. And then also we have different kinds of information being given as to economic experts. So I would say here that yes, her affidavits were indeed contradictory and obfuscating. Thank you.
Thank you, Honorable Lotrich. Honorable Maneli.
No, Chair, I think I'm covered in the contradictions, but I think there's a point made in the paragraph before we look at the figures that talks about the responsibility and transparency. Because the reason you would change from time to time based on what you are asked at a particular level is that voluntarily you are not transparent, and that talks to the office, as I say. But if we go to the framework, it's also an expectation just even from those that are law officers who come before courts to help the courts to make a proper decision.
Thank you, Honorable Maneli. Honorable Heron.
Thank you, Chair. I agree with Honorable Lotrich. I think the evidence supports a finding of contradictory and obfuscating accounts.
Thank you, Honorable Heron.
Without the unintelligible.
Just repeat that.
No, I said
you got cut.
Sorry, Chair. I was supporting Honorable Lotrich proposed the public protector had been contradictory and obfuscating, but that I think it's a stretch to go to unintelligible.
Thank you. Point taken. Honorable Heron. I think with that, with there being no further points from members, who will proceed from that and go to the next. If there are no remarks, the following will be dealing with the issues of incompetence still within charge one. As I would indicate at the beginning, you have these overlaps in terms of those. And I'm now going to move to paragraph 7.1.1 of the motion, as well as chapter 1, part 1 of the evidence summation, pages 100 to 201, and paragraphs 315 to 321. We'll start with basically the questions will start at at 50, because everything else necessarily just indicates those issues that you see there. But the first question would be, did Advocate Mkhwebane, by imposing the remedial action in respect of the constitutional amendment, grossly overreach and exceed the bounds of her authority, unlawfully trench on Parliament's exclusive authority, and unlawfully trench on the National Executive's authority to determine socio-economic policy? And did Advocate Mkhwebane concede the unlawfulness of the above on review? You might have touched on some of these issues before, but we're here now, and we want that emphasized on the record. Thank you. I will invite the evidence leaders, whatever context they want to provide, and then invite the members.
Thank you, Chair. So the three issues that arise from paragraph 7.1.1 in relation to the lifeboat report. The first is the issue of overreach and exceeding the bounds of her authority. That's the first question. The second is whether she unlawfully trenched on Parliament's exclusive authority. And thirdly, whether she unlawfully trenched on the National Executive's authority to determine socio-economic policy, and did she concede the unlawfulness during the review proceedings? Just starting with the question, did she impose remedial action in respect of the constitutional amendment? Members will recall that she directed the chairperson of the portfolio committee to initiate a process that would result in the amendment of section 224 of the Constitution, and further stipulated how section 224 should read after the amendment. Did she concede the unlawfulness of this during the litigation? In the litigation, she considered that the remedial action she had prescribed could not stand because it conveyed a mandatory remedial action that the parties affected had to implement. She expressly conceded in the litigation that the remedial action trenches on the powers of Parliament, because only Parliament has the authority to amend the Constitution, and that authority must be exercised at Parliament's own discretion. So she accordingly agreed then that her remedial action in respect of section 224 of the Constitution should be set aside. And she tendered the costs of that application. So by her own concession under oath, then she conceded that she had acted unlawfully in exceeding the bounds of her authority and in infringing Parliament's authority. The question of whether she infringed the National Executive's authority, she conceded there too that she had no power to dictate to Parliament how to exercise its original legislative mandate. So the questions then, Chair, you pose arising from 7.1.1 are for the committee to answer, and they arise from that context.
Thank you, Advocate Mr. Mayosi. I now invite members to make their contributions. Honorable Xola Ngola, Honorable Heron, Honorable Jane Sebuletse Mananiso, Honorable Mailam, in that order. Honorable Ngola.
Thank you very much. I think, Chair, the answers are obvious. Yeah. One, she, as Advocate Myers says, even in the High Court in the review application, did concede that she has gone beyond the scope of work as determined in the apologies, I'm sick.
What is sabotaging you there?
Yeah. So the Public Protector Act clearly determines what is the role of PPSA. So we don't even really have to go beyond of how far did she go in terms of overreaching. To Chair, the Constitution is clear, which is the supreme law of the country, that the obligation or the duty to enact laws of the country rests to Parliament. She did not only do that, she went to tell Parliament how they must construct an amendment in the Constitution that determines what needs to be said. So, Chair, it has already been said that she considered even in the High Court. Thank you very much.
Thank you, Honorable Ngola, for your contributions. Honorable Herron.
I'm covered, Chair. Thank you.
Honorable Herron. Honorable Mananiso.
Thank you, Chairperson. I think one would want to say yes to all the questions that have been asked, affirming what Honorable Ngola have said in terms of the Advocate Enquiry going overreaching her executive authority. And one would want to fully agree that she actually conducted a gross in terms of everything that she did. Thank you.
Thank you, Honorable Mananisa, for your contribution. Honorable Mailam, followed by Honorable Majosi.
Thank you, Chairperson. Chairperson, I agree with everything that's been said so far. I just want to add in one additional point, and that is that policy, and particularly socio-economic policy, is determined by the executive, not Parliament, although Parliament obviously plays a role, but the determinant of that is the executive. What Advocate Nkwabane did in her remedial action was to impinge on the role of the executive and to determine what policy should be. And I would go further and say that in some of the evidence that we saw, she appointed policy advisors to give her political and strategic advice on what that policy should be, which already calls into question her impartiality. So I do agree that as far as this particular report is concerned, she did impinge on the role of the executive.
Thank you, Honorable Mailam, for your contribution. I now recognize Honorable Zandile Majosi.
Thank you, Chairperson. I think I concur with other colleagues that this part it has more clarity in terms of how she overreached, and in terms of when you are reporting to Parliament and at the same time telling Parliament what to do. And but nonetheless, what I wanted maybe the evidence leaders to then explain further, because I think this one goes back too far, Chairperson, and I don't know where we left off with the Public Protector in terms of the questions. And when maybe she was asked some of these questions, did she reply in that manner, or is it are we now taking what is on the report and what she had submitted on an affidavit, so that we don't get another court interdict that now she wants the recordings of the committee. So are we in line with everything, or is it not going to affect us in terms of when maybe she would then try to do that? But in all essence, what has been explained, that it's very clear, and it's proof of what really transpired. But I just wanted to check there, only, Chair. Thanks.
Thank you, Honorable Majosi. There be no other member evidence leaders you want to respond, or I will assist you. Please, Advocate Mayosi.
Chair, I think the honorable member was asking a question, asking us to assist her, but I'm not sure I got the question right. So if she could please, or perhaps you got the question.
No, the question was whether suspended public protector Mkhwebane did respond. If she was asked this question and responded to these. So the standing answer is that whatever questions that were asked by members and evidence leaders in relation to all of these issues, she chose not to respond to all of them. Hence, we said many of these matters remain unchallenged from her based on that act, basically. So that would be a response to Honorable Majosi. So there would not have been.
Thank you, Chair. I'm covered. Yes.
Thank you, Honorable Majosi. We then proceed if there's no other members. Any final remark on this before I proceed? Honorable Maneli.
No, thanks, Chair. I'm not sure if this point has been raised, if it's raised in between. You stop me, because there was also a question about whether on the side of the PP, she would have seen this to be unlawful. And I want to say that the understanding is that from where one understands from a court point of view, yes, there would have been that admission quite late. But remember that in the committee, and this talks to the contradictions again. In the committee, it would have been an issue that this would have not been intended to prescribe to Parliament, because it will be illogical and unimplementable. Whereas from the point of the court, there's been an admission. So one can then come to that conclusion that probably on hindsight, it would have been understood by herself that that would have been unlawful, understanding what Honorable Ngola would have explained about the Constitution and what does what. Thank you.
Thank you, Honorable Maneli. That covers it. I now proceed still on the issues of incompetence. Paragraph 7.1.7 of the motion. Chapter 1, Part 1 of the evidence summation, pages 102 to 109, and paragraphs 326 to 358. And 5 questions, very brief, straightforward. Did Advocate Mkhwebane in investigation and report and subsequent litigation demonstrate the following: irrationality, forensic weakness, incoherence, confusion, and misunderstanding of the applicable contractual, constitutional, and administrative law principles? I hope you got those. If the evidence leaders want to put a context, I think it's straightforward. I would want to go straight to the members. If you do need, you can do that. Thank you. And I'll invite members. Honorable Ngola.
Say yes, Chair, in all 5 of them. Thank you very much.
Repeat that.
Saying, Chair, the answer is yes in all 5 of them.
Okay, thank you, Honorable Ngola. Any other member? Honorable Maneli.
No, thanks, Chair. No, my hand was also going to say yes, Chair. But I think on the last point, merely to indicate about this coherence and all that. It's also in relation to the understanding of interpreting the laws, which is an expectation from that office. This administrative and everything else. I think important. And unfortunately, amongst the witnesses that came before the committee, it sounded bad when this thing would have been raised. That we may understand the law, but the application of it, it's another issue. And I think as reports get to be looked at, that also does come. That sometimes it may be in the understanding of that application without mentioning the witnesses. So thank you.
Honorable Malele, for your elaboration. I see Honorable Ngola wants a second bite. Go ahead.
Yes, Chair, just to add on the last part of one of Malele, that in fact, you'll find that in all the 4 reports where these charges emanate, there is a problem of the misunderstanding of the applicable laws. It's a general problem. It does not resonate only with this, but we'll get to the details when we end up those reports. I said it's a modus operandi.
Honorable Ngola, any further comments? And is there any different view from what has been said? None. I proceed. I go to the next paragraph, still dealing with these issues of incompetency. Did Advocate Mkhwebane, during her investigation and reporting the matter that is the subject of charge 1, and in the ensuing litigation on up to review the lifeboat report, demonstrate that she does not fully understand her constitutional duty, namely to be impartial and to perform her functions without fear or favor or prejudice. And it indicates where that is addressed and so on. Maybe a bit of a context and emphasis there from evidence leaders, if you need to.
Yeah, I think the factual or the evidence surrounding that has been summed up in various categories, and the last couple of grounds are sort of overarching. If you look at all the evidence together from the meetings, the growth of the CD Court, the economic experts, High Court sums it up, the Constitutional Court looks at it.
Thank you, Advocate Bauer. Any comment and a take from members on that, those 2 issues? Under 53, Honorable Mailam.
Chair, just to say what I said earlier, and that is that it appears that Advocate Mkhwebane was importing a particular ideology or brand of social and economic development and social and economic transformation into her reports, and that did not necessarily align with the Constitution. And in so doing, she abrogated her constitutional responsibilities and her impartiality. Thank you, Chair.
Thank you, Honorable Mailam. You did make that point before, yes. So thank you for the elaboration you're making again on this, where you find there's a connection. Any other member or any member with a different view? None. I proceed to the next paragraph. Paragraph 7.1.9 of the motion, chapter 1, part 1 of the evidence summation, pages 109 to 115 and paragraphs 359 to 378. Did Advocate Mkhwebane demonstrate a failure to appreciate public protector's heightened duty towards the court as a public litigant? I think that's going to be the last of the question there on charge 1. Any elaboration or context? If not, I go to the members. Thank you. Honorable members, your take. Lead Advocate Mkhwebane demonstrate a failure to appreciate the public protector's heightened duty towards the court as a public litigant. You would have been taken through what Sokone would have said and what Mr. Ibrahim would have said as those standards. I have a view.
Repeat the question. I can't see it.
Okay, the question is, did Advocate Mkhwebane demonstrate a failure to appreciate the public protector's heightened duty towards the court as a public litigant?
Yes. Yes.
Over to you, Honorable Gosi.
Yes, in the affirmative, and it's demonstrated by what is required of that office, but also the manner in which you approach litigation, and not appreciating the fact that as an officer of the court, she has a particular responsibility that must reflect those ethos.
Thank you, Honorable Ngosi. Any other member? Honorable Maneli.
No, thanks, Chair. In seconding the yes part, I just want to bring the other aspect as it relates to this charge, one in particular, and the matter we've dealt with. That those contradictions, Chair, at different courts, affidavit done by the same institution, leaves much to be desired in terms of keeping that standard. Like we've raised, it's not just about the litigation that happens, but it's also the resources of the state which are supposed to go to the people that get wasted in that scope. When a matter probably you could have left it because I'm responsible for not putting the information in terms of Rule 53. And then you'll come later to justify in another court why you couldn't do it, but still not really convinced by putting any matter before the table for reconsideration. And you still get almost the same decision that you got. And then you have to go back and look at that. That again defeats what was shared before this committee. That from every court process, there's a review process that happens within the PSA, and they learn from that so that they do not repeat the same. And some of these, as I say, those contradictions show repetitive actions where we do not learn as an institution. Thank you.
Thank you for the contribution, Honorable Maneli. You can remove that slow tap so that I can see if I have got hands further from members. Honorable Majosi.
Thank you, Chair. I would respond yes, maybe on a different view altogether. That even the what do they call them? The investigation officers. I will say that gave that came as witnesses here. They did say that. She was at other cases as well. She was not willing to listen to what they were advising on, and she would make that decision without taking into consideration that they've advised her on certain issues that they shouldn't proceed with other cases because they are going to lose them. But she would go on as well, which then shows that as a leader you are not competent enough to then fulfill your duty as a public protector. So on that case only, I would then respond to yes. Thanks, Chair.
Thank you, Honorable Salile Majosi, for your contribution. Any other comments from members? Is there any different view from what has been shared so far? None. Thank you.
I think this brings us to the conclusion of charge one. We're now going to move to Friede, but before we move to Friede, we're going to take a 30 minutes light dinner and tea and be back at 6. We will pause for that. Thank you very much.
Recording stopped. Recording in progress.
Thank you. Welcome back, honorable members and colleagues. I indicated before that break that we'll now change focus and get to Friede. I'm going to start this differently. We'll immediately go to the evidence leaders to give us the context and bit of summary, and then I get into the questions for members, and then we'll, with the lessons of what we have done so far, we'll try and see how we were able to pick up the pace. Thank you. Over to you.
Chair, the Friede matter covers two sets of charges. That which is concluded in paragraph 2, the incompetence charges are dealt with in part of, I think, the latter part of charge 3. And it's also some of the evidence that one takes into account when you look at charge 11, which is a lot broader. But what is to be borne in mind when you consider the Friede matter is that when we get to the CR17 SARS unit matters, there is a comparison to be drawn between explanations provided in Friede juxtaposed with explanations provided in the other matters, and the contrast in how these matters are dealt with. So that's just broad context. And then there is a High Court decision on the merits in the Friede matter. The judge then waits for the Constitutional Court to rule on the issue of costs, the ABSA matter, and then she hands down a cost judgment in the Friede matter. That then gets taken on appeal right up to the Constitutional Court and is dismissed all the way up. So the only judgment we have is the judgment on the merits, essentially from the judge in the High Court in Friede matter. So when we do the explanation on the grounds, we move between the report, which is important, evidence from the witnesses, and the affidavits that's before the High Court that assists you on the background, and then dealing with ground 1. Should I just go into ground 1, Chair, or would you want me to? Do you want to go do it first? Okay, so then you have to look at the grounds which is set out in ground 4.1 as the first ground, which deals with the narrowing of the scope of the investigation, which is charge 4.1, and it's dealt with paragraph 34 onwards, which is at page 126 of the summations. The way we crafted it, which is we're going back to 1 in terms of the numbering as we start a new charge. And the charge provides that deals with the narrowed scope of the investigation required by the complaints, which have been commenced by Advocate Madam Sala without providing any rational or proper explanation. And what makes it in some ways easier is that there were 3 complaints from the complainant lodged in 3 different periods, which is explained in paragraphs 37, 38, 39. September 2013, March 2014, and May 2016. In those paragraphs and estimations, we detail the contents of each of the complaints that have been lodged during that period, right? And according to the evidence of the Advocate Enquiry and the content of the Friede report itself, the report was issued in respect of all 3 complaints. There's no reservation or undertaking to further investigate any allegations not dealt with in the report. So that's the first point to be made. If you go to the report itself in paragraph 41, we report what the report says it refers to. And you see that says that they make findings in respect to whether the Free State Department had improperly concluded the public-private partnership and whether there'd been non-compliance of procurement and whether they failed to manage and monitor the STN's budget evaluation, expenditure controls and performance. And it concludes that it was difficult to determine whether goods and services procured at inflated prices. So the report itself lists 6 issues that were not investigated, and it provides the reason for it not being investigated is due to capacity and financial constraints. And the 6 issues are the cause of cattle deaths, issues arising from the third complaint, the value for money obtained, newspaper articles referred to known as the Gupta leaks, how money was spent by Astina, matters relating to beneficiaries who were intended to benefit from the project due to lack of information. And in the statement before this committee, Advocate Mkabani's statement, she categorically denied that the third complaint was not investigated at all. And I think we must be clear that when she says at all, it means that we accept that she's saying that there were aspects that were, my interpretation of the sentence, right? So over and above the 6 issues identified in the Freire report, it also does not refer to the complaint of non-compliance of environmental prescriptions, which was expressly raised in the second complaint, and it was raised in the provisional report that was there. And I'm going to refresh your memory to put the context to it. There is a draft provisional report in this matter. It is so let me rephrase that. It's a draft report. Let's not call it a provisional report. We defined it as a draft report, and in the Rule 53 index, it's referred to as a draft provisional report. It's the report which Advocate Madam Sala gave evidence on. She didn't finalize. That's important to recollect that. That is the only report that is in the Rule 53 record apart from the final report. So there is no finalized provisional report in the Rule 53 record for reasons which will become apparent as we go on. And the explanation that is given to the High Court as to why the environmental prescripts was not investigated was because it was regarded as an unsubstantiated complaint because the complainant failed to provide additional information as requested. So now, if we go to, Chair, I don't know how far you want me to go before you turn to the members. Must I start on the 6 issues that's not investigated? So if we then in the report deal with essentially the issues that we say, which according to the report was not investigated, to consider whether they could have been investigated and what was the impact of capacity and financial constraints. And then we reach a conclusion in the section. So the cattle deaths is an issue which arose in the second complaint in 2014. And in looking at the, because of the length of time and the nature of the complaint in paragraph 51, we couldn't find any evidence to confirm whether the deaths could actually have been investigated after Advocate Mkabani took office. And we reached that conclusion in 51. We don't have that evidence to say that actually there was a way it could still be investigated. Remember, Advocate Mkabani only comes into office in October 2016. And so in looking at this question of practicality of investigation was also something we took account of in trying to figure out, well, could it actually be done given the fraction of time? The second issue, which Advocate Mayosi will take you into greater detail because it also falls under charge 4.2, is the issues arising from the third complaint. The Freire report indicated that the issues arising from the third complaint were not investigated because the issues pertaining to the investigation were already identified in the executive summary, and it stated that an investigation as at this advanced stage could not be investigated due to financial and capacity constraints. Bear in mind, as indicated above, the third complaint was made in May of 2016. Advocate Mkhwebane comes into office in October of 2016, and the final report on the Freedom Act was issued in February of 2018. Right? So, if one then goes, and I want to take you to paragraph 68 of the note, and skipping over the details of what the third report is about and what steps in the investigation was taken after that. Right? In the judgment before the High Court, the public protector justified her decision not to investigate the third complaint that was lodged because she said it was too late to do so. One must in this regard note that the final report was only issued in February 2018. It is inconceivable that having regard to the dates, she could seriously contend that it was too late for a proper consideration. And then in explaining to the committee in her Part B statement, Advocate Mkhwebane explains it as follows. The issues raised therein largely overlapped with the first and second complaints. The exception was the issue of the shareholding of the beneficiaries. The issue was left out because the investigation was at an advanced stage and the issue had not been incorporated in the 6 months preceding my occupation of office. This failure was placed at the doors of Mr. Salmon and Professor Manzala. Right? The third issue is that of value for money, and that was raised as pointed out in paragraph 70 in the first complaint. With reference to the significant government expenditure on infrastructure, machinery, and cattle. In the second complaint, which requested an investigation into the extent to which Justina contributed to the Freedom project, whether it was befitting from the supply of goods and services and the hugely inflated costs. And then they listed in the second complaint a number of items that were subjected to inflated prices that was not addressed in the NT report is the National Treasury report, which preceded the complaints of the public protector. And the National Treasury report that included a number of information which indicated that prices were indeed inflated in doing that. And so if looking at the evidence that was before that, and in paragraph 74, what the High Court concluded, because one of the aspects that arose was whether or not it was a public-private partnership. The public protector said it was not. The National Treasury said it was, and the High Court determined that the public protector was wrong in that regard. Right? And then in paragraph 76, it set out the instances that where the National Treasury report had reached several conclusions regarding the values and costs. And I think the one most commonly known is the cost of the pasteurizer that could be installed for 450,000 that was recorded as costing 60 million. And the fact that there was a recommendation by National Treasury that the government should not continue with its project since it won't receive value for money. Now, what follows on this that comes later is that more money is still paid out after the National Treasury report was issued. So this report refers to evidence in respect on the inflation of prices. The cabinet indicated that to her knowledge, the accountant general had dealt with the issue. She lacked the financial resources to hire experts to redo the same exercise. And that's recorded in paragraph 11 of the 3 report. And so there's only to a limited extent where some of the things were recorded and the bulk of it was not. So the next item which wasn't investigated, which be the Gupta emails. Paragraph 84, you've gone past it. Now, bear in mind that we're talking about in some ways a comparison between the CR17 matter and Freedom matter in one hand, and this is probably one of it, is that the 3 complaints made no specific mention of the Gupta leaks. That didn't investigate it because it wasn't of concern to the complainant in the matter. It wasn't raised in the complaints, and it wasn't part of the scope of the investigation. We summarize the issues that arise in the question of us in paragraph 117, the explanation and the evidence of what the various witnesses' views were on the Gupta leaks is recorded. But in summary, in paragraph 117, the different views are put out. First, Advocate Enquiry appeared to be saying that by June 2017, the Freedom investigation had been completed. But the 7I notice and the response process was not yet complete. So the latter may have required further investigations, and investigations can't actually be completed prior to the response of the Section 7I notice being received. Second, that the Freedom investigation had ensued beyond mid-July 2017 until beyond when the Gupta leaks were publicly disclosed and widely reported in the media. So much so that the task team was created to finish the investigation in the latter part of 2017. There is a difference of opinion between some of the members of the task team that says they were only, Mr. Sitoli indicated that he understood it to only be part of quality assurance, and the other members of the task team and the references to the task team say investigation and finalized. So the third issue was 17.3. Advocate Nkabani did not disclose that she had been provided with the outer report prior to the conclusion of the investigation. And since it is mid-23, media articles had been published alleging that the Gupta family negatively benefited. In fact, it was those media articles that gave rise to the Treasury report and were addressed then. So none of the investigators were provided with the outer report by the inquiry. So that fourth, notwithstanding the 7I notices that I've mentioned at the time that the colleagues came before, in dealing with the evidence in part A statement that the Nkabani testified that investigations can ensue up until the report is issued and the second 7I notice may have to be issued. It follows that it can never be too late to have regard to any matter that arises during the investigation up until the final report is released. Fourth, she testified in reference to CR17 that it was incumbent on her to follow her leads led to fulfill her mandate. But the same didn't apply in the further investigation. Six, that absence in and of itself of any mention in the 3 complaints to the Gupta family and the email correspondence in respect of the Gupta family didn't preclude an investigation. So those were sort of the summaries without, I think it's common cause it wasn't investigated, but some of the evidence that when evaluated came to the fourth, the fourth ground, yeah. 2, 3, 4, 5. First one is how Stephen spent the money as effectively the beneficiary benefiting from the supply of goods and services from contributions from the provincial government, the hugely inflated costs, etc. That will form part of the first and second complaint, and it was elaborated on in the third complaint. When allegations came to the surface that they had benefited under the contract provided by the Premier's legal department at the expense of taxpayers, the beneficiaries and the state, and they'd received approximately 183 million rand for building a dysfunctional dairy infrastructure and purchasing cattle at inflated prices. And Estina was allowed to basically abscond from the project without any accountability. And this is one of the issues that wasn't investigated, ostensibly because the Directorate of Priority Crimes was dealing with the issue of the hawks. And so stated there that in the freedom matter, in terms of, we look at 122, whilst the SAPS Act expressly provides for the hawks to investigate offences in Chapter 2 of Record, the PPA also provides that the public protector is competent to investigate alleged offences under Chapter 2 of Record if they relate to public money. So she did have jurisdiction to investigate it, but elected not to do so because the hawks was doing so. And we do know as to what then transpires is that several arrests are made in February 2018. I think within days after the further report was released in 2018, there was a number of arrests that have been made. So essentially that was one of the main reasons given why that wasn't done. There wasn't an evaluation done as to whether the Treasury regulations have been complied with. And there was a view taken in the answering affidavit in the High Court that because Estina was a private company, it didn't fall under the public protector's jurisdiction, even though public money was involved. There was also an allegation in the papers that she couldn't access documentation because they had closed shop. So that lead wasn't followed up any further to do that. So the effect is we set out in the following paragraphs the explanations that have been provided in the answering affidavit as to why that investigation didn't. So what is not there is an explanation to the court as to why documents could not be obtained by a subpoena or through a search and seizure to the office, and why officials in the Free State Department was not subpoenaed to answer questions on the oath or to produce whatever records the department had within its possession. And so we then deal with a further comparison, and we say that in paragraph 140, Advocate Enquiry makes the statement that it cannot be disputed that monies were paid and used for purposes other than for what it was intended. That conclusion, although in the affidavit, is not in the report, nor in the remedial action does it deal or give any direction to the department to take steps to recover such unlawful expenditure paid to Estina. There is no indication in the Freedom report that Estina was in fact no longer in existence, or if it wasn't in existence, how that was ascertained, or that it mean any effort made to get the bank records or accounting records. That then takes us to the beneficiaries, which was raised in the first complaint, the second complaint, and in the third complaint. And clearly it required a determination of who the beneficiaries were, what their benefits were meant to be, whether they had received those benefits, and if they hadn't, what steps could have been taken to ensure that they did receive it. And we know that the Public Protector's Office was in possession of the details of the beneficiaries, including the ID numbers, addresses, cell numbers, if not all, then most of them, because it's included in the Rule 43 record. And we know that how they came to be identified and the irregularities contained therein, because the Treasury report details that. And so we explain what transpired with the beneficiaries. In paragraph 150, we say that for this committee, Advocate Enquiry denied that there was a failure to investigate the third complaint. made the submission earlier on that she said at all the issues raised, they've been having overlap with the first and second complaints, except for the shareholding of the beneficiaries, which was left out of the investigation because it was at an advanced stage and the issues had been incorporated 6 months preceding the occupation, placing that failure at the doors of Mr. Salmon and Advocate Public Salmon. However, without any use of additional paid resources after the portfolio committee raised the Freire 2 report comes out, using the beneficiary list, it had already had to make contact with beneficiaries, contained extensive findings in respect to beneficiaries, and ordered appropriate remedial action. It appears that much of this information came from engaging directly with the beneficiaries themselves, something that could have happened with the first investigation. So it couldn't be because of a lack of information, because they didn't have any new information for the Freire 2 report. And so that's why we say that was implausible. We also know that from the evidence before this committee, that blame was laid at the door of the then leader of the DA, Mr. Maimani, for not having provided the evidence. When one has regard to the affidavits before the High Court, then he denies that was so, and he explains the context of his meeting and how it came about. That he took a number of the beneficiaries to the offices in December and what he actually tendered. So what it does show is that there were several steps that didn't happen. The beneficiaries were not interviewed. CFO from the precinct department, the director from Christina, Mr. Bas from the CEO from the department, Mr. Tabeti, and Mr. Prasad from the Indian partner company. None of them were interviewed. Although at least the latter one, Mr. Prasad, participated in the Treasury's investigation. There was documents that was not considered as agreement, like the shareholders agreement, securities register, the management agreements, and there doesn't seem to be any consideration given to the beneficiaries in this matter. To then go through the evidence, we set out in paragraph 80 what the High Court found as the reasons for excluding the beneficiaries. Which essentially relates to correspondence. And the High Court finding in 181 was that the decision to limit the scope of the investigations was so dramatic, it was irrational, as it sidestepped the crucial aspects regarding the complaints and led to a failure to execute the constitutional duty. As I indicated earlier, the appeal courts did not revisit this conclusion. They both refused to leave to appeal. The final issue relates to environmental issues. And the answer was effectively that it wasn't done because the complainant had not provided additional information. There is a draft report that substantially addresses the question of environmental compliance. This is all taken out of the report on the eve of it being finalized. So it was investigated, it's just not reported on. So it's not quite so from one looking at drafts that it was not listed as an issue in the final report because it was an unsubstantiated complaint. This is not borne out by draft reports which precedes the finalization of the report. There is also a dispute before the High Court as to whether further information had been requested from the complainant. We did not see any. We were not furnished with any correspondence reflecting such to do that. Chair, the next issue on this is the issue of capacity and financial constraints. So maybe we must let the members go to the grounds before we deal with it was justifiable to say that capacity and financial constraints limited us from dealing with.
Thank you. Thank you, Reverend Power. It's been quite a dense area, so just reported that you we've traveled with the members through that. Now come back to members from 58 to 61, just to attend to those questions. What issues did the complaints require to be investigated? Each of those issues, as you would have heard, if any, did Advocate Mkoba not investigate in producing the pre-day report? Which issues identified by Advocate Madonsela did Advocate Mkoba not investigate? If Advocate Mkoba did not investigate any of the issues in paragraphs 58 and 60 above, as would have been shown, did she offer a rational or proper explanation for her failure? From 62, just it's a listing of the issues that were taken through. So I'm inviting you to speak to those questions. And you take us, Honorable Anneli Lockridge. You're noted.
Thank you,
Please.
Chairperson. Thank you. I think given the evidence that we've had, as you say, it is quite dense. It is clear that complaint number 3 was not investigated, and that refers mainly to the political, the administrative role in the province. So it's the Department of Agriculture, all those issues, whereas the first 2 complaints, which refer to the beneficiaries and vast sums paid, was indeed investigated. And I think the reason proffered by the Advocate Mkhwebane in terms of why the 3rd complaint was not investigated is not plausible, because the report was only issued, if I'm correct, 2018, whereas this was 2016. So she had more than ample time to actually do that. And I also don't think the question at that particular point of financial and other resources that were limited, I think in such an important matter, could really be accepted, because other measures could have been taken. So from my side, Chairperson, I would think that in this regard, there was definitely an omission and negligence. Thank you.
Thank you, Honorable Lockridge, for that contribution. Further views, comments, contributions? Any further members wants to take up the issues? Is there any different understanding or view from what has been shared by Honorable Lockridge? None. We all agreed. Thank you. We will proceed from that and go to the next section, paragraph 4.2 of the motion, chapter 1, part 2 of the evidence summation, page 171. Yes.
Chair, there's a second aspect to this. Important one, sorry.
Sorry.
Before I mislead you.
4.1.
She narrowed the scope of investigation, which I think the member answered. The second part of it is not providing any rational, proper explanation before.
Okay, the 61, yeah.
Yeah, and I didn't address the issue about proper and rational explanation. And the answer given was a capacity and financial constraints. And just to be clear, so they don't mislead members, that is dealt with further in the notes from paragraph 191 to 13 of this. And the issue arose as to whether there was a full explanation, which the court found it didn't. And this committee had received evidence that that was only inserted into the report the night before. The third aspect was whether it required specialized expert services. In a nutshell, those were the 3 issues as to whether explanation provided was rational.
Okay,
Sorry, Chair.
any comments? Honorable Maneli?
No, thanks, Chair. I think the difficulty about commenting is that as we deal with these matters, we make comparisons earlier on. And then they come back, maybe just to.
They have made the point, and I think Honorable Lotrit also made a reference to it.
Yes.
But for emphasis, please go.
I think what comes out clear is that whilst the reasoning would be financial constraints and all that, on the first matter we dealt with, we've shown that aspect there. That when you want to push something that even leads to overreach, you are able to have experts you rely on as economists. As I said, whether they are security or ICT, it's another issue. But they are relied upon as experts, and you are able to draw them in. That requires the protection of the poor, for which the office in the mind needs to look at. It's what you do not get. But again, there's this comparison of what happens in the SR17, the same presentation. And again, we'll come to a conclusion there that again, it's about what you want to pursue and get your mind fixated on that and chase it at all costs. But in this case, that's not the case, right? Of course, the other matters that are said to have been referred back at the time when the then public protector would have received those roles of politicians and so on. Sending back probably there would be some justification in that there was no provisional report that was signed off. At least that was confirmed by Advocate Tsela when she appeared, that it's confirmed the matter went back, but there was nothing that came. But on those areas, as I say, where it said it's financial constraints and that you can't get expert advice and so on, could not be enough reason if in the same period you were pursuing other projects where you are able to draw in experts and realize later that you actually went even to terrains where in terms of law you are not supposed to be even there, as courts would have found. Thank you, Chair.
Thank you, Honorable Maneli, for your elaboration. Any other member? Thank you. We'll proceed. You share the same sentiment. Thank you. Honorable Sukas?
Yes, Chair. I could not hear the evidence leader, but I am going to just add to what was said by Honorable Maneli now around the issue of resource planning and the overall overlaps around issues. I think what is important to note is the note on the exclusion of the beneficiaries and the mention by the High Court that this is a blatant failure, was a blatant failure. So in terms of that is the impact on the intended, ultimately the intended, as per the constitutional mandate of the PP, it is the poor, the most vulnerable. And so I just wanted to add that in terms of impact, the issue around resource planning, and how that relates again to a competency of and as mentioned by Honorable Lotrit, negligence in that regard. Thank you.
Thank you, Honorable Sukas. We now proceed then to the next paragraph 4.2 of the motion, chapter 1, part 2 of the evidence summation, pages 171 to 172, and paragraphs 224 to 231. And the questions there, two questions that are important. Did Advocate Mkhwebane fail to investigate the third complainant at all? And if so, did Advocate Mkhwebane provide a rational or proper explanation for her failure? Before members respond, Advocate Mayosi, if you can bring a little bit of context there.
Chair, thank you. Advocate Bauer has alluded to some of the context that is relevant here. It's not in dispute, Chair, that the third complaint was not investigated at all. This was one of the findings in the Preda High Court judgment, and that particular finding was not the subject matter of the appeals that the PP subsequently pursued. So she's given various explanations in her High Court answering affidavit for why the third complaint was not investigated. They vary from financial and capacity constraints. She said the investigation was already completed before the third complaint was received, or that the investigation was not completed, but merely deferred. And she's also claimed that the allegations that there was insufficient information, or that information promised was not given to them. During the cross-examination of Advocate Raidani, Advocate Mkhwebane's version was that all three of the complaints were rolled into one, and that most of those complaints were addressing the same thing. So her team and they took the decision to regard them as one thing, and then they assessed them as one thing. But this is the first time that that version was raised. That is not to what was said in her answering affidavits in the High Court litigation. Also, during the cross-examination of Mr. Muntu Sitole, he said that by the time his team became involved, the three complaints had basically been rolled into one, and they'd been collated into one complaint because there were overlaps, he said, between them anyway. So I think the version was that Advocate Mkhwebane then produced a merged report to deal with all of these complaints. But that explanation is contradicted by the text of the Preda report itself, which states that various issues were not investigated, including issues emanating from the complaint sent on the 10th May 2016, as the issues pertaining to the investigation were already identified, and investigation was at an advanced stage. There are also various issues that the Preda report plainly didn't make any findings on, and Advocate Bauer alluded to those issues earlier in her address. So despite it being put to Advocate Raidani during cross-examination, I think what was put to Advocate Raidani during cross-examination was that the National Assembly called on her to investigate specific issues which had not been raised in the previous complaints. This is self-evidently not correct, given that Advocate Mkhwebane was to address, amongst other issues, possible prejudice that was suffered by the intended beneficiaries of the Preda Dairy project. And this issue was raised in all three complaints. So in cross-examination, it was also raised that the issue of the beneficiaries was a crossover issue, because it was raised even in the first cluster of complaints, but it was also part of the second investigation. So the questions that then arise from this short context are questions around whether the explanation she gave for not investigating the third complaint was rational, or whether she then gave a proper explanation for not investigating the third complaint.
Thank you, Advocate Mayosi. Honorable members, Honorable Polangola.
Well, thank you very much, Chairperson. Chair, I think from the onset, there was no appetite from PPSA to investigate this. There was really no will. If you follow even the testimonies that we have received in respect of the Frede Dairy Farm project. As the summation was read here by Avocate Power, there is a line where she is playing a blame game for the failure for the conclusion of investigations, that the failures must be taken to the doorstep of Mr. Samuel and Prof. Madonzel. That's utter arrogance, that which I think does not, should not resonate with the office that has been established to protect the interests and the aspirations of the people in general. We have heard stories here from different testimonies of scheduled investigations or scheduled interviews with people of interest in respect of this investigation. A point in hand is an issue of the Premier of the Free State, who by that time was fingered to have played a role in terms of this project's failure. But testimonies came here and said, witnesses came here and testified that they went to the office and the PP only spoke alone, and investigators were not allowed to ask questions from people who are suspected to have wronged the project. You have got a series of good-linked emails that point some millions of rands have been siphoned from the project into an offshore account. But that as well was said to not be sufficient enough for an investigation. Now, it tells you that there was no will to investigate completely the third complaint. The second asked question Chair speaks about, was there an explanation of the rationale behind that? And from where I'm seated, I share the same sentiments with Honorable Manel, that from where I'm seated, the non-availability of funds excuse is just blatant. It's just it's a scapegoat. Was if we are able to have a spiraling litigation costs where you get clobbered in a review application in the High Court, you go to the Supreme Court of Appeal, you go to the Constitutional Court, you get clobbered, you apply for a rescission in the blood. I mean, you do have that kind of resource, but you don't have that kind of resource to protect the interest of the poor of the poorest. This poor of the poorest, you came here to the committee and projected yourself as the paragon of protection of the aspirations of those poor people. So the point I'm trying to make, Chair, is that although there was an attempt to give a rationale, but from where I'm seated, it was not sufficient. It was not a sufficient rationale why the third complaint was not investigated in completion. So it's a no, Chair. It's a no, thank you.
So in your view, she failed to investigate the third complaint and there's no rationale.
Completely failed.
Thank you. Honorable Mananiso.
Thank you, Chairperson. I think one would say that with the testimony that came before us and how as well the Majosi has actually given us insight in terms of what is before us. It really shows that the PP had all the details in her possession. However, she didn't use that particular information to contact the beneficiaries. Therefore, as Honorable Maneli could have said, the PP has shown that he had no interest or public interest to protect these particular beneficiaries. So one would say, no, whatever the decision that she took at that particular time was not correct. Thank you.
Thank you, Honorable Mananiso, for conversion. Honorable Mailam.
Thank you, Chairperson. Chairperson, I concur with the previous speakers. I just want to add one thing in, and that is, I think that the statements by the public protector in this regard go further than not just providing a rationale. I think she's misrepresented her reasons for not investigating it, in that at every turn she's offered different reasons and none of them actually are credible. So I think there's an element of dishonesty and misrepresentation in her reasons provided. Thank you, Chair.
Thank you, Honorable Milam. Do I have any further comments, members? And do I have any different view or any dissenting view? None. Thank you. I proceed. We now get to paragraph 4.3 of the motion, chapter 1, part 2 of the evidence summation, pages 172 to 192, paragraphs 232 and 310. And perhaps to ask again the evidence leaders to give us the refresher context.
I'm beginning to think that Mayosi managed to slip all the harder ones through to me.
Go ahead.
Chair, we divided this up into 4 categories, which you will see in the subsections under this charge in the summation starting at 232. In a largely because we tried to follow some of the evidence that was before the committee. So I'm going to deal with it on that basis. But if you look at paragraph 232, it first sets out that one of the first steps taken by Advocate Nkubani was to be apprised of investigations. You will recall from Mr. Chiwalule's evidence, it gave a stick of the reports left behind by Advocate Madansala. So we know that was very early on after she took office, that he met with her on reports. And so what we detail in paragraph 232, which we can see from the Rule 53 record, is from the time she takes office, what is added onto the investigation to do that. Then there was a bit of evidence that was before this committee about Advocate Cilliers' involvement in the Free State and whether she was removed from office from the investigation or not. And given that the accusation was made that she was, the reasons for her removal, we thought it important that we actually address that. And if you look at 239, 240 of our statement, factually, she actually remained involved quite a long time into the investigation, in providing outstanding information, etc., even after head office was seized with the investigation. So there was no evidence to establish that Advocate Nkubani had removed Advocate Cilliers from the Freedom investigation, irrespective of whether she believed herself to be a member of the DA or not. That's not borne out by documentation that we had. But does not mean that Advocate Nkubani had not expressed such a concern to Mr. Ndau as to whether there was no basis on which to disbelieve his evidence in this regard. And I don't understand us to be doing that. But whether that was a reason in which it impacted on the investigation going forward, we didn't see that there. Right? And because the allegations was before this committee, we thought it necessary to look into that. And then on the finalizing of the investigation, what was important, if you look at 243, was that when Advocate Nkubani accounted to the Portfolio Committee in March 2018, she indicated that FREER investigation had been close to complete by 2015. She said something similar to the High Court in an answering affidavit in 23 March 2018, that it was not feasible to appoint a forensic investigator or any expert service provider more than 3 years after the investigation was completed. That is a different response to, they didn't have the money in 2018 to do that in 2017. Just that was the difference in the approach taken. And then we set out what some of the evidence was, and in 249 we looked at what the Parliamentary Monitoring Group's report of the Portfolio Committee meeting of April 2018 revealed, and it showed that at that meeting, Advocate Mkabane had indicated that the report was ready when she took office. To do that. And the evidence shows from what even the senior legal manager told us the day before the report was released. You've heard evidence and you've seen the emails and draft reports, and it's detailed in the submission as to what to do that. So sorry, Chair, I just lost my train. So essentially, we know up to which point they were actually investigating and for when they were working on the report, and how the investigators viewed what still needed to be done. There was an extensive memorandum provided in January of 2018 to show what was still outstanding. The third aspect is findings against politicians and the varying views that came out from the witnesses as to whether or not she had provided, whether she had said she didn't want any findings against politicians, and the evidence that had been relayed to the investigators and their understanding of it, having been relayed through Advocate Doe, and we make the point that and her evidence in that regard is set out in which follows, and we've looked at it in the section. There's also the question about whether she had or had not granted, whether permission had been sought from her to issue subpoenas, and Mr. Samuel's version that they asked, and it was refused. You will recall his version was it was during the in-local inspection. Her version was he wasn't at the in-local inspection, which was then a photograph was produced to show that that wasn't so. So that was all in respect of steps taken and not taken during the investigation to do that, and whether that was actually in fulfillment of her responsibilities under that. And her findings that there was no findings that could implicate politicians. And if you look at the Freedom 2 report, then they do have findings in that respect, and we detail that in 288 and 289, where the Freedom 2 report essentially, which is issued by her at the end of 2020, that the Freedom project was subject to political involvement and undue influence, that the politicians breached their constitutional obligations, that funds were improperly appropriated, and the failure of the politicians caused prejudice to the beneficiaries. Now, all of these were based on evidence available at the time of the first investigation, and was plainly material to all three complaints, not because they dealt with politicians, but because they dealt with improper diversion of funds to Estina and associated prejudice to the beneficiaries. So the very poor people who the project was meant to benefit did not get the benefit of the project, in a nutshell, which comes out of the Freedom 2 report. So the Freedom 2 report is not consistent with what was considered, was put to the committee, that it had not yielded any liability on the part of politicians. And that comes out of paragraphs 87 to 90 of the Part B statement that she had put to it. And then we deal with this question of conducting interviews and acquiring of documentation. Chair, we know that from the CR17 matter, from the get-go, subpoenas were issued. Documentation was obtained. The Financial Intelligence Center was engaged to obtain bank statements. We don't see that in the Freedom matter. We don't see the HOD, the CFO, Premier, the MEC being subpoenaed to come and give evidence for the public protector, which we see in the SARS unit matter and the CR17. So we have 6 interviews conducted with a manager, 3 state chief executive of corporate services, somebody from the Holstein Breeders Association, but we don't see the others having been doing it. And we detail who should have been interviewed in 296, and some of them was available to be interviewed. You have subpoena powers. You can obtain cooperation in that manner, some degree. And in 297, we point out that Mr. Namasisi raises this on the eve of the report coming out, directly in an email with the public protector, where he sets out, and that's in 297. And the report was nonetheless finalized. And the reason why the 300, we set out the documents that could have been obtained or should have been obtained and was not obtained. And then Mr. Nemasisi raises that with her as we detail in 301. And this is also raised in the judgment, which set out in 304. And the reason given to the committee that suggested that none of this was done because there was enormous pressure from the DA to release the report. Stakeholder engagements were referred to as the source of the pressure, and that occurred in, I think, March or April of 2017. And the only letter that was put before the committee was a letter that was sent in October of 2017. And we know that Mr. Maimane comes to the Public Protector's Office in December of 2017. There's no other, we have not found any correspondence from the DA, the complainant, Mr. Maimane, in January or February that says, we want this report now, sit through the night of February and finalize it. None of the investigators could shed light on why was it that that report had to be finalized then. And in some ways, it's probably fortuitous that it was, because the warrants of the arrest of 13 of the suspects we detailed that in paragraph 307 and 308 was issued on the 15th of February. And that would have made number of the associates, the Gupta associates and family members, the HOD, Mr. Petty, were arrested. I'm not talking about the veracity of the charges they were arrested for, but it seemed that that it would have made it very difficult to come out with a report as it stood at that time. If the people not interviewed was arrested a week later, or if the report had come out since it's easier, sort late in February, then there would have been great difficulties with the Public Protector's Office, because the Hawks investigation at that time was showing imminent action was being taken in that regard. So maybe in some ways, by coming out on the 8th of February, I managed to get the report out fortuitously. And the documentary evidence then shows Mr. Nemasisi had highlighted a number of shortcomings in it. And Chair, we know that the budget comes out on the 1st of October, which is 7 weeks later. So that is essentially the issues arising up. 4.3 steps taken. In more case of steps not taken in the investigation.
Thank you, Advocate Bauer, for the clarity in that context. Honorable members, the questions that we interact with will be found from 65, 68, where the complaints of high importance and significant magnitude as alleged in the motion. In the light thereof, did Advocate Mkhwebane take adequate steps during the investigation? If Advocate Mkhwebane did not take adequate steps, did she offer rational or proper explanation for her failure? And the rest, more specifically, to as an emphasis, Advocate Cilliers finalizing the investigation and so on. So your take, honorable members? Honorable Milam.
Thank you, Chairperson. Chairperson, in response to the first question, the complaint dealt with high-ranking members of government. It was a matter that had been high profile in the media. it was related to the Gupta leaks and the broader state capture narrative and corruption narrative that was a hot topic of conversation, both in the mainstream media and on social media. So I would argue that the first point is, yes, this was an important investigation and did need to be dealt with appropriately. With regard to the question as to whether or not it was dealt with appropriately by Advocate Nkwabane, I think that the answer to that is quite categorically no. And we've seen a lot of the evidence over the last several months as to why that would be, not least of which is that she didn't even contact the beneficiaries and she didn't contact those implicated, and she didn't contact the heads of department that are applicable to this matter. So it wasn't thoroughly investigated. It wasn't dealt with in a manner that addressed the complaint, and the rationale provided does not meet a standard that suggests that it has any basis in fact. It appears that this was a political motive on the part of the public protector to either protect or shield certain individuals from investigation. So I think that my answer to the first few questions is that it was not dealt with appropriately. I don't want to venture into the last two questions, if that's okay, Chair.
Thank you, Honorable Milam. Your contribution is taken. Any further members who want to comment on the matter? Are there any further comments? None. Any differing, dissenting view from what has been shared? None. We then agree with what has been shared, that there would not have been any adequate steps taken during investigation. No rational and proper explanations for such a failure. And the first one to the affirmative. We then will proceed from there. Thank you. We'll go to the next paragraph. 4.4 of the motion, chapter 1, part 2, pages 192 to 200, and paragraphs 311 to 347. Before we get to the questions, we'll ask the evidence leaders to touch on the context. And
yeah, Advocate Mayosi's bailed on me, so you're stuck with me at the moment.
go ahead.
Chair, this one is a bit complicated. So the quick answer to the question was the provisional report prepared by Advocate Padensala. We know that it's common cause that there was not. So it begs the question as to how the High Court comes to the conclusion, as it does, that in February 2018, the PP published a report. It is of importance to note that the provisional report was done by the PP's predecessor, Advocate Padensala, as these two reports have to be compared within the factual matrix of what occurred in the implementation and execution of the project. A comparison of the findings, conclusions, and proposed remedial action is inevitable, because that's what the litigants do before court, G. And so part of this explanation puts into the next charge 4.5 as well, in the following sense. In the Rule 53 record is represented that this is a draft provisional report prepared by Advocate Padensala. Is based on that representation in the Rule 53 record that the litigants proceed from the position that it's her provisional report, and that they in their affidavits then conduct this kind of a comparison, and that the judgment then emanates from what the litigants put before court. That's part of the reason why the evidence leaders at the start of the summations tried to explain to the committee that the court is guided by that which the litigants put before the court. And so we unpack what transpires before the court based on the evidence and the Rule 53 that is before the court. And what is represented to Judge Talmay and in the papers in the application for leave to appeal that appears after that in doing that. So this November 2014 draft, which appears in the Rule 53 record, is not the draft report which forms the basis of the Section 7I notice that goes to implicated parties. It seems to be a much earlier version, the genesis of which we couldn't quite put our finger on because we were not sure this was a report that had actually initially come from Advocate Provincial. And so we deal with those explanations. And what we don't see is an explanation from Advocate Nkubani before the High Court, where she tells the High Court that this is not Advocate Provincial's report, or that this is not the provisional report, or that there were several draft reports, because none of it formed part or fell into the Rule 53 record. And so the affidavit is answered by Advocate Nkubani, premised as if this was a provisional draft report that emanated from Advocate Provincial. One reads the affidavits, then one gets that impression that it's the draft. Status of this is not explained in doing that. In fact, she specifically refers to it in terms, and we say that in 323 of the note, the provisional report of my predecessor. Although she explains that the provisional report is just an internal working document with no legal status, she attributes that to the previous public protector. And so it is on that basis, in paragraph 328, we show the full explanation that is given in affidavit to the Constitutional Court. And this is after the High Court judgment had come out, Chair, where she says the provisional draft report had been completed by my predecessor, Advocate Madensala. You see that 328 of the note. And that's the full quoted paragraph from Advocate Nkubani's affidavit to the Constitutional Court. Now we know, Chair, because Mr. Sitoli gave that evidence, that shortly after Judge Palmer's judgment was handed down, he went back to Advocate Saliers and he asked, is there a signed copy of the provisional report of Advocate Madensala? And Advocate Saliers says to him, there was never a provisional report. And we have this email exchange between Mr. Sitoli and Advocate Saliers. He didn't confirm as to whether he had relayed that to the public protector at the time. I don't know. In the scuttle of the number of objections to my questions of Mr. Sitoli on that day, that is lost in the transcript, and I can't recall whether that question had actually been answered. I don't see it on the transcript. So I may have omitted asking the question. But be that as it may, we do know from Mr. Chialula's evidence that he had provided the incomplete reports of Advocate Madensala. So she would have known that there was no provisional report that had been finalized. She had also finalized the April provisional report, which formed the basis of the Section 7I notice. So paragraph charge 4.4, there is no provisional report for Advocate Madensala that we have found. And the explanation that I'm providing you is explained in the paragraphs under this heading in the summation. We also see that there was significant material changes made to the draft that is discovered at court, and it's explained in paragraph 341 what those changes were in dealing out that. And we make the point that what remains unclear is why the November 2014 draft was included in the Rule 53 record, but the various other versions were. Now, we also know, Chair, that Mr. Satoli took responsibility for the Rule 53 record. He said that it's the job of the officials at the office and not the public protector to prepare Rule 53 record. In this instance, we do also know that that she did finalize, did have an opportunity to peruse the index of the Rule 53 record, and it would have thought that once the applicants had the next draft, the report to the founding affidavit, that the answer, there would have been a realization that the applicants have erred in understanding that to be a provisional report about the government salary. Thank you, Chair.
Thank you, Advocate Bauer. On those 3 questions, members, maybe even for emphasis, does look like we already have answers for that. But for what it's worth, I want you to interact with that. 69 up to 71 was the provisional report prepared by Advocate Madonsela. If so, did Advocate Mkhwebane materially alter the remedial action? If so, did Advocate Mkhwebane provide a rational or proper explanation for the alterations? Your interactions or questions in this regard, honorable members? Honorable Maneli.
No, thanks, Chair. Maybe the first point is to accept that, yes, there may have been a draft report that has been termed a provisional report. And at the same time, a warning that says it's misleading to think there was, as projected. And for that reason, I think for purpose of the committee, now that we know that there was no provisional report signed off, it will probably unfair, Chair, even though these matters would have been ventilated in court. But for our purposes, it would be unfair to even think about altering a report that does not exist. For that matter, be exonerated on that aspect, on all those questions, whether it's rationality, but or non-existent. There's really nothing there, Chair. But like I said, we do note that in court it's presented the other way around. It may be matters of misconduct, gross in a way, because it's also misguiding the court for people to belabor on something but that's for the courts. For purposes of the committee, I think she should be exonerated on that because there's really no alteration. Thanks, Chair.
Thank you, Honorable Maneli. Any further comments? None. Any final remarks on your side? None. Thank you. Proceed to paragraph 4.5 of the motion, chapter 1, part 2, pages 203, paragraphs 348 to 362. What explanations did Advocate Mkhwebane give under oath for a failure to investigate in the Freedom matter? With those explanations contradictory? Any take from Advocate Bao or Advocate Mayosi, and then I go to members?
Okay, I've already addressed the issue of this provisional report. There is another issue that arises from, I think there's about 3 other issues that arise from the judgments. One of it is that there's a statement in the judgment, or the statement to the committee is that politicians were clearly investigated She was empowered in terms of the act to determine how the investigation was to be conducted. And that in this case, having determined that the procedure of the pre-array investigation as a result of financial constraints was to be carried out in two parts. The committee is told that in paragraph 89 of statement part B. So the committee is told there was going to be a two-part investigation and the politicians were investigated. The judgment states the PP in addition stated in her affidavit that she exercised her discretion to opt out and not to investigate. The suggestion in the answering affidavit that she deferred the investigation stood in direct contradiction with the statement that she decided to opt out. And that's the judgment in paragraph 96. And then in the affidavit to the Constitutional Court, on the one hand, is set out that aspects of the third complaint had been dealt with, and then proceeded to point out aspects as to why the third complaint was not dealt with. And then that must be compared to the earlier affidavit in the High Court that said, I couldn't actually deal with the third complaint because by the time it came along, the investigation had been completed in respect of the first and second complaint. We've also dealt with the contradiction in the allegations relating to non-compliance with the environmental legislation already. I'm not going to go back there. We do know, Chair, that the first step after the court application landed was to take a position not to oppose the application and to file a rule, what we call a rule 53(1)B affidavit, which accompanies the record, and you explain why you're abiding the decision and you provide reasons. And in that affidavit, the reasons given was capacity and financial constraints prevented the office from investigating certain issues. And we've dealt with that aspect already. But then subsequently, the review application was opposed in its entirety. Every aspect of the review application was opposed. And one of the things stated in that review application was she had utilized the statutory opt-out option not to investigate those complaints that fall within the jurisdiction. Chair, we in the note deal with this notion of a statutory opt-out, and whether as a matter of law she has such a statutory opt-out, and that's also dealt with in the judgment, which we've dealt with before. There is nothing in the report that indicates that any part of the investigation was deferred for later and until the portfolio committee took the issue up in a meeting with then two aspects of those that had been left outstanding was investigated. So the evidence indicates that there was no deferment, and this is contrasted with the SARS unit investigation. We expressed in the report that stated there was 14 complaints. I'm dealing with 6 now, and I'm leaving 8 for later. That does not happen in the report. And then we see that when it comes to the appeal, Chair, in paragraph 11, she says, I have in fact investigated the issues that the respondents claim I have not. I have reported on them and I've made appropriate remedial action. So there is a bit of contradiction in between opting out and stating I didn't decline to investigate any complaints lodged, which you see identified in paragraph 361, which we thought was fundamental difficulty between the various affidavits. So we've highlighted essentially 3 or 4 aspects in comparing the affidavits.
Thank you. Thank you, Advocate Bauer. Honorable members, that would have been the response to paragraph 4.5 or context in terms of those 2 questions. Any takers? You're happy, you have no view, agree what I was saying? Okay, I've raised them already. What explanations did Advocate Mkhwebane give under oath for a failure to investigate and defray the matter, where those explanations contradictory? So those will be the two questions. Any comment, Honorable Maneli?
Chair, now that we have the questions repeated again, no, I think it's quite clear from what has been put in the summation that there have been contradictions from what is being said at different levels. I start from the report, Chair, deliberately all the time, because the report gets to the public. And then from there, you contradict yourself as you go forward. So the explanations in it were contradictory to a point that you do not know whether they were investigated or not. Because at one point they are covered as one, the other time it's something else. That's what I'll submit, Chair. More to agree. Okay.
Thank you, Honorable Maneli. That agreed. Any differing view or comment? No dissent. We will agree. We'll proceed to the next paragraph. We now get to 7.2.1 of the motion. And therefore, there's an important point to make here that most of these principal failures are dealt with under other charges. So there's a bit of an overlap. And then we'll speak about investigations and the remedial action. We'll ask the evidence leaders to touch based on that as a context. We're almost there on Friday. You might want to combine that with 7.22 of the motion, or even 7.23.
We haven't, there is an overlap, so it's good that we're looking at the factual evidence to do that. So what we do, we have referred to the gaps in the investigation, including the failures to address a number of issues that had occurred and the absence of interrogation of a number of the key players, the use of subpoenas, the need to get interviews and bank statements. That all falls under 7.2.1. We've dealt under 7.2.2 with the absence of the beneficiaries involved in the investigation, which I think is not disputed. We know that there is the lack of a meeting with the Premier or the political officials. And we have again an incident which occurs outside of it, but which corroborates earlier versions of meetings that was held without recordings taking place at the meeting, which is the meeting that occurs. And we refer to it in paragraph 387 and 388, not because it falls within the terms of reference of this committee. It must be very clear that the Vrede 2 report is not part of the committee's mandate, but it's useful to refer to it for purposes of showing the what could have happened and the Vrede 1 that didn't happen. In that regard, so that is dealt with in the ensuing paragraphs under that, and then under so the lack of interviews, etc., is dealt with. So that takes care of 7.21 to 7.23. Just see, I don't know, 7.24. No. So one of the other aspects that I must deal with under that. Right. Okay, so, so that, okay, so that takes care of 7.2.1 to 7.2.3, G. Okay.
Thank you. Thank you, Bao. So I would have asked to the 3 paragraphs that want us to attend to because of the overlaps and similarities there, so we'll start with the paragraph 7.2.1. Firstly, dealing with investigations. As would have been covered, issues of what would have been required for lawful and meaningful investigation. Did Advocate Enquiry demonstrate the failure to achieve that standard? And on remedial action, what would have been appropriate remedial action? And did Advocate Enquiry demonstrate the failure to impose such action? And paragraph 7.2.2 of the motion. What was the public protector's duty to the intended beneficiaries of the Free Dairy project? Did Advocate Mkhwebane fail to comply with this duty? And paragraph 7.2.3, did Advocate Mkhwebane fail to investigate issues in Free matter? And if so, did Advocate Mkhwebane seek to defend this failure in the litigation challenging the Free report? If so, did Advocate Mkhwebane demonstrate a failure to appreciate the inadequacy and negligence of her investigation? And whether she fails to appreciate? Can you follow? Maybe if I'm too fast for you. Okay, let's start with the first one. Your comment on that so that I don't leave you behind. Or unless Tsepo has become even more slow. That on the issues of investigations and remedial actions under that paragraph. Do I have takers? And nobody. You're happy. You have no view. Honorable Walangola and Honorable Mailam.
Chair, all government institutions, particularly the provincial government, are governed by the Public Finance Management Act. So one would have expected the public protector to have done a great investigation in terms of following if the procurement process has been properly followed in terms of awarding the project itself. That are the said beneficiaries of the project actually benefit? What has been irregularities in the project, if any irregularities? What are the objectives of the project? Because there is a use of the public funds, huge amounts of public funds. So that would have been, in my view, an investigation that ought to have been done. But from where I'm seated, Chair, I can safely say that that was not done in a way that which it would have been done. It should have been done. The second question, Chair, that speaks on, there is an undisputed fact that the flooded dairy farm was a failure, having public funds used in a failed project. So the expectation of society would have been, in terms of the remedial action, would have been to actually provide what needs to be done, who within government has been on the wrong, and what actually needs to be done. But when you check thoroughly the report, you don't really get to that extent, if I still recall the remedial actions of the flooded dairy farm. So from where I'm sitting, Chair, that the flooded dairy farm investigation has been failed. It has failed, and it has been failed as well. Thank you very much.
Thank you, Honorable Ngola. Honorable Mylam.
Thank you, Chairperson. Chairperson, I agree with Honorable Ngola regarding the lack of investigation. And because there's been a lack of comprehensive and lawful investigation, I feel that you are put in a position where you are where there is no finding on which you can base remedial action. So to speculate what appropriate remedial action should be implemented is very, very difficult. Also, we are not the public protector. We don't have the expertise or the experience or anything like that of dealing with that kind of situation, and we shouldn't try and project or speculate what remedial action might be appropriate. I think that's a stretch too far for this committee. Chairperson, if I may, I'd like to address you on 7.2.2. Can I go ahead on that?
Please go ahead.
Thank you, Chair. Chair, the question of the intended beneficiaries and the failure to interview them is of great concern to me, because this public protector has put herself up as the protector of the Gogo Dlaminis. And if ever there was an example of Gogo Dlamini, it was the beneficiaries of Freda Dairy Farm. So her failure to appropriately deal with this investigation, her failure to interview them, her failure to interact with them and consult them and keep them apprised of the state of her investigation, to me is utter hypocrisy when it comes to her claim to be the protector of Gogo Dlamini. Thank you, Chair.
Thank you, Honorable Mylam. Any further member wishing to comment? Honorable Maneli and Honorable Sukas.
No, thanks, Chair. And I also agree that the investigation would have not been what would have been expected to be a meaningful investigation. Because from the report we have, Chair, in the categories of areas that needed to be looked at, we've already traversed that part, where it's demonstrated that important matters were not looked at. The one is what Honorable Mylam has spoken to now, about the beneficiaries. And remember, with the beneficiaries, there's a lot linked to that death of the animals. In fact, that's what the farm is about. So the essence of having the farm is what is not investigated as to why they just disappeared that regard. But the other thing is that as an investigation gets to be done, you take into account other investigations that may have been done in relation to the same matter. In this case, is the National Treasury. and the National Treasurer could not avoid that aspect of the provincial government and the provincial treasurer, as this would, even in the words of the PP, did not comply to triple peace as promoted by the government. So that's an area that needed to be looked at, because that's where the money actually disappeared. I would say it's the hijack of government funds intended for the poor, taken by a private company and used it for something else. And there's no consequence in that, because you either justify that it's not an area I get into because it's private, or I didn't have the expertise to investigate at that level. Right. So therefore, Chair, then the remedial action surely will have those shortcomings, because for those areas that have not been looked at, you can't say anything that would be done, because they would not be part of the report that you are looking at. And it may be justifiable, therefore, for such beneficiaries to say, yes, the investigation has been done, but the interest of the public has not been protected in this regard. And of course, private companies may have the resources to get lawyers, but surely the reason why the public will continuously knock at that door, it's because that protection could come with ease from a point of view of protector. So that will be my contribution, Chair, on the item. Thank you.
Thank you, Honorable Maneli. Honorable Sukas.
Yes, Chair. I actually just want to underscore what was said by Honorable Milam around the Gogotla minis. If you look at the Estina case, what is really sad is that this, for me, is a grotesque deviation from the standard the public protector professed from the get-go on the stand when she was speaking on the when she was delivering her sort of what drives her, the values that drives her. And I want to underpin what was said here by Honorable Maleni. The interest of the public, the interest of the most vulnerable, and the voice of the people of Estina. And the fact that we have people that, or companies that can protect themselves, and then the interest of the very people, the poorest of the poor, whose only defense is the office of the public protector. We cannot fail to underscore that, because that is to the heart of the very mandate of the public protector's office. I think it is important to note that. And as well, where the issue of resource planning, as said earlier, the driver, the value, the values that drives that office, as given by the Constitution, those aspects are critical issues for us as Parliament and for this committee when we look at the charges in terms of the impact and the failure then of the office to ensure that proper justice is, or investigations is done in order for those individuals to get justice, the poorest of the poor. Thank you, Chair.
Thank you, Honorable Sukas. Any other member? I think you would have covered these different areas. Maybe the last things to raise that you need to still comment on, if you so wish. Having said all of what you have said, it's important to indicate whether you think that Alfred Mkhwebane therefore demonstrated a failure to appreciate this inadequacy and negligence of her investigation, and whether she failed to appreciate her constitutional duty to conduct a lawful and meaningful investigation. Honorable Maneli.
Thanks, Chair. Probably we've said it in different ways, but that's actually what we're saying once we focus on the public being protected. And once that fails, then to call it public protector gets to be under question. Thank you.
Thank you, Honorable Maneli. And thank you for that emphasis. The completeness also helps a lot. If there's any different view, if none, we proceed. Colleagues, I now want to proceed to the next 3 paragraphs and the last part of the Friday. And I want to ask Advocate Bauer to lead us there, or Advocate Mayosi, on paragraph 7.2.4, 7.2.5, and 7.2.6.
Can we do them one at a time?
Yeah, no problem. It helps that way.
So, mindful that the remedial action lies within the discretion of the public protector, one looks at it from paragraph 396 as to the appropriate remedy or remedial action to offer. Now we know that there's a system where before a report goes out, legal services considers the rationality of the report and identifies its shortcomings. So again, Mr. Nemasisi identifies a number of concerns that he has in respect of the Friday report on the eve of its release on the 8th of February. Nowhere at any stage before the courts or before this committee has there been any acknowledgement by Advocate Kabani that there's been any inadequacies or material deficiencies in the Friday report, either the High Court or before this committee. So we started by identifying that evidence is not before the committee. We know that in the remedial action which was proposed in the report, mindful that this committee doesn't step into the shoes of the public protector to propose alternative remedial action, we can only point out to what was the remedial action that was proposed by the legal advisors and the investigators that was taken out of the report and what it was replaced with. And so we do that from 399, where she says that a cow reconciliation undertaking must be given by the Premier to assess how many cows are there. But the Premier had previously given an undertaking that he would do a value for money assessment, but that's not one of the remedial actions that's ordered in the report to make it binding on him to do that. While she admitted that monies were paid and used for purposes other than what it's intended, there's no remedy in there to recover or to ascertain where that money's gone to. Even though that has been raised. In answering affidavit before the High Court, she removes a recommendation that has been made that the AGSA commission forensic investigation, if you look at 4.3, she explains that she took that out of the report because the institution does not do forensic and due diligence investigations, and the PPSA cannot assign functions to the AGSA. Again, we juxtapose that with the CR17 report, but under the powers of the public protector, in fact, she can, the AGSA firstly does have auditing and reporting powers, and the Public Audit Act gives it certain additional powers, which we've set out. So we don't think it's correct that the AGSA couldn't have done what was being sought to be done as a matter of law. It would not have amounted to an impermissible assignment to the AGSA. We also note that there was a suggestion that there be an order or a remedial action given that the Treasury report be implemented, and that there be an investigation into the funds that was paid to Estina by the AGSA or an independent firm, or proper assessment being done. That was removed. And the reason given for that was by the time the report was issued, the Hawks and the AFU was already attending to the recovery of irregular expenditure. Again, we juxtapose that with the position in the SARS unit report where there had been several investigations already conducted. And so the High Court found that the omission of findings of irregular expenditure in the report was inexplicable and couldn't be justifiable unless it was done for some ulterior purpose, but no explanation was provided further for those changes that you see at the judgment of paragraph 75. One of the things that is of relevance across the board is that Mr. Nemasisi seeks to put the recording in there that the authorities may wish to investigate money laundering, and the public protector in terms sets out in the answering affidavit that she does not have jurisdiction to investigate fraud, theft, and money laundering. This would have to be referred to the Hawks as the appropriate body to investigate such allegations. Again, we know that in the CR17 matter, there was an investigation conducted on the allegations of money laundering. We know that in the paragraph 419, there was no direct wording to tell the Premier to take disciplinary action against any particular person, not against the CEO, not against the CFO, but to initiate and institute disciplinary action against all implicated officials. In other words, it's left to the Premier to decide who's implicated. And from what the Premier had previously told the public protector, he didn't believe that the CEO was implicated in any irregularities. So there's that difficulty with the relief that's been issued. Again, public protector took the stance that that under the Public Service Act, only the Premier could do that, and not. Sorry, let me just check this slide. That the MEC had no power to discipline the provincial HOD, that under the Public Service Act, it's the executive authority responsible, and that can be the MEC to do that. So that comes to the end of 7.2.4. Yeah. That's true.
By one, all three of them. So with that background and context, members, if you could respond to those three questions. Was the remedial action contained in the final FIDA report inappropriate? If so, was Advocate Mkhwebane unable to comprehend and accept the inappropriateness of the remedial action in the FIDA report? And if so, does that show legal inaptitude on her part for matters of competence? So, any comments? Your hand, either here or in the air. You agree with this, or you have no view to take? Yes, Honorable Monel.
Thanks, Chair. I'm sure it's not just in terms of how far we've gone, but it's because as these questions come, they are like repetitive in that we would have dealt with them before. But of course, based on
I don't mind repetitions.
So
Switch
passage,
off Advocate Power, thank you.
I think the passage now, given the passage that we've gone through, you'd come to that point that there's that problem of understanding the legal side of things. Once at one point you understand your powers to be quite wide, because that's the word we used throughout this, and then it's limited now. when it has to really strike where it's supposed to strike. Like I initially said, if the Treasury recommendations were taken into account, surely you'd seek to also ensure that that government does implement those and not merely accept that if the executive authority says no, there's no reason to discipline an HOD who is really an accounting officer under which these things would have happened. So do not take that quite easily. Of course, as it gets, I'm saying just on the passage we have dealt with, the part of even removing it when it's put for you to consider by investigators and so on, again goes against what the committee has been made to believe, the respect that is given to the work of investigators as a way of proving that there's no interference to what investigators do. But at that critical moment, when those recommendations are to really bite, they can be temporary in that scope. It therefore says that indeed that attitude on the part of the legal understanding becomes an issue. And for me, I know, Chair, you're saying Grab is still talking to competence. But again, not to do with duties and misconduct. When you're supposed to do it. So you've not conducted yourself in the way you're supposed to do. But I'm just saying, I know it's asked from a competence point of view, but really there are things you should not do, and you know you should not do. And then you still do those. Thank you.
Thank you, Honorable Maneli. Any further comments? Any different views? Are we agreed? Okay, thank you. We will proceed to the last paragraph. 7.2.6. Advocate Bauer.
Parisham 7.6.
Two. Pages 223, 236. Is there something you're looking for with those two?
Okay, sorry, Chief. Okay, it comes from paragraph 457 onwards. And it looks, Chair, as to the extent to which the representations to court is a reflection of the investigation that had occurred and what had taken place. And we go through the gist of the affidavits, answering affidavit in respect of the meeting with Mr. Maimani, what was said in the Rule 53 affidavit, and what she apprised the Vrede High Court and Concord in respect of the November 2014 draft report, which we already covered at 463. And in 464, she takes responsibility for the contents of the Rule 53 record. And we set out in 464 all the versions of the report that would have been circulated and in existence that didn't make its way into the Rule 43 report. And those are listed at 464, including the comments and how it reflected into the final version going in, and you see it specifically 464.10 that at 8:20 on the night of the 7th of February, due to capacity and financial constraints experienced, is written into the report. So it's not something that was at the back of the mind of the investigators at the time of the investigation throughout. And then we see a number of other changes that is made at the report, and that goes through that, including Advocate Radani's account of how the report gets changed between himself and Advocate Nkabani at the time. So that explanation is provided on the basis of the oral evidence of the documentation. So it then sets out, none of that appears in the affidavits report, nor is there an explanation as to why certain things were left out. If you go and just slip up one bit, because I think we've skipped over something that was in the report. That, if you go to paragraphs, page 218, paragraph 436. This, I didn't deal with all the aspects on conducting an investigation set, but this is one example of where what was in the penultimate draft was a picture of the gate that had been built, and which was said with the guardhouse, which if you go down, you'll see what the guardhouse is, and that was said to cost 2.6 million. Mr. Sisi points out that this was an obvious indication of overpayment. Premier comes back and provides an explanation that actually the cost included purchase of a guest house, which was required to house the people working in the project. This is indicated without any evidence of title deed.
You're not saying that's a picture of a guest house. Oh, guardhouse. Okay.
Guardhouse.
Okay.
Probably
60,000. Yes.
2.6 million.
Oh, wow.
Maybe it's underground. But we told that this guest house was prepared in the town of Vrede to accommodate individuals responsible for the implementation of the project, not the beneficiaries, these other individuals. That's the, and that it was necessary to buy this property. And this appears to have been accepted without any provision of evidence or any further investigation. And there was no documentation provided. So that is but one of the aspects of some of the explanations that wasn't provided and what was within the knowledge, and that's how we come to the conclusions that we do. And you see that in paragraph 493, the Advocate Vani tells the committee that the Vrede matter represents part of the mess and unacceptably neglected matters which she found on the desk. The investigation should have taken 4 to 5 years to complete. I did all I could to attend to them. There's no evidence of an alleged agenda to shield certain politicians, which is at the heart of the charge. And Chair, we have pointed out to the committee that it does appear that from the time the first complaint was received in October 2016, Advocate Nkabani assumed office, that the investigation undertaken and the draft report produced appears to have inadequately dealt with the 3 complaints. We do point out that the committee sees with determining whether there was misconduct and or incompetence on the part of that about during a 10 years public protector. So your investigation is what did she do from October 2016 onwards, and whether she took the necessary and reasonable steps to address, i.e. the mess she found on the desk when she assumed office in dealing with that. And we have in the course of that taken you through, and I've only given you snapshots because it doesn't behold me to read everything in the submissions that's been provided to the committee. Highlighting certain parts of the aspects as to what was said to the court, and what else was dealt with. Hope that covers it.
Okay, thank you, Advocate Bauer. Honorable members, having heard that, your response to those two questions of whether Advocate what was the public protector's heightened duty towards the court as a public litigant? Did Advocate Mkhwebane fail to appreciate that duty? As you said, Honorable Maneli, you would have come, but I deliberately want you don't put 0 on record. Yeah, Honorable Maneli.
Yes. So, Chair, we've already given a yes in the on that part. Thank you.
Thank you, Honorable Maneli. Any other view? Any dissenting view on that? Okay, none. Advocate Bauer and Mayosi, any remarks you want to make? I think on this, this is though they are overlapping matters, we might have to do that when we go to the next, but this is Friday. And I would suggest that it's now 13 minutes past 8. I think we've pushed it. Unless members suggest that we can go to the next one, or we pause here for the day. The plan was for us to continue if we're not finishing today, tomorrow. So I need to get indication from members, because I think this is a point where we want to pause so that you go and recharge. I appreciate the kind of work you have done. And it's getting much better as we went along. But it's important work that can be delegated. It's got to be done by ourselves as members. So may I hear what members think? Because if you'll be silent, I will indicate on your behalf. Tomorrow at 10 is a plan for us to reconvene. And then we can go through the FSB, SARS, Kodan, CR17, and those general matters. Well, that's what is now outstanding for us to conclude. So it does mean that we do need another full day to go through that. Honorable Maneli.
No, thanks, Chair. I'm not sure what other members would say. I would have thought, Chair, that we're here. And we have no guarantees of tomorrow. We can only guarantee.
I agree with
that
you.
we're here.
Yes.
So I don't guarantee tomorrow, Chair. That's all.
So you suggest that what we have, let's proceed. Thank you, Honorable Maneli. Honorable Sukas.
I appreciate the sentiment of Honorable Maneli, but I differ on that, Chair. I firstly want to say that, as you are aware, we have a constituency program as well. So my suggestion, Chair, is that is for Monday for us to proceed. I think we've had a long delay, and for us coming back today, it took a few, yeah, onze seevoete gekry. You know, get our rhythm, I think, in terms of the process today. But I would really implore, Chair, that we proceed on Monday for the second day. And I can see your face, but I will not try and read your your face as you said. So I differ with Honorable Maneli. It is now 8 o'clock, Chair, and I do think that I think we must appreciate the pressure and the schedule of members. Thank you.
Thank you, Honorable Sukas. No, I take your point of the delay. So I was just curious, you want another delay? But that's on a lighter note. Honorable Lotridge.
Thank you, Chair. I would just like to know if you have a sense of how many items we still have to deal with, so that we can have an indication whether tomorrow is needed, next day is needed.
Yes.
Just for us. If we can finish it tonight, well, then we can.
Yep, just pause there so that we can explain what else we have so that it can determine tomorrow. I was just saying, and maybe Ms. Ibrahim can assist. We left with the Financial Services Board part of it, the CR17, the SARS got done, and then those general matters. But Advocate Mayosi and the first two that we've started with, in terms of their length and what we had to go through, was important that we did what we did, and it might help us with the next one that are coming. But I'll ask them to respond and then come back to you so that you can continue with your contribution.
Thank you, Chair. You're quite right, Chair. What remains now is the FSCA matter, which falls under incompetence, I think, charge 3.
Yes.
And then we move on to charge 4, starting with what has generally been described as the HR issues, where the allegations of harassment and so on against staff in general, but also in relation to certain named individuals in paragraph 10 of charge 4. After that, we'll then move to 11.1, which talks about the effective or failure to effectively manage internal capacity and management resources. After that, we'll then deal with the costs issue, fruitless and wasteful expenditure, which is alluded to in 11.2, paragraph 11.2 of the motion. In paragraph 11.3, the SARS unit matter comes in there. So we'll deal with that, SARS unit, GEMS, and other related issues. And then we go to 11.4, which is the CR17 Busasa. So that's what remains, and we'll basically deal with it in that order.
Okay. Honorable Lotrid.
Sorry, Chair. Yes. It is slightly difficult to put a time on that, and these are some important matters.
We
but
need
I am
a
just
day.
thinking, but
We
I'm
need a
not quite
day.
sure. Sorry,
We need a day.
another
full
day.
day.
Okay. No.
Yeah.
Okay, then we'll not be able to finish it this evening. So then you will have to schedule. I can also indicate that on Monday it would not be a very good day for most of our members, but it is in your hands. Thank you.
Okay. What are other members saying? Thank you, Honorable Lotrid. You have tomorrow, as you said, you don't have Honorable Maneri.
Thanks, Chair. We're trying to
environments.
To look at the management, the voice tweets, you must know that he's communicating the caucus. No, we're just saying, Chair, we're happy that you're not considering tomorrow. And that we can look at another day. Of course, a Tuesday maybe, because of what Honorable Lord would have voiced. And that would, even with other parties, the Monday.
Maybe as I go to Honorable Hermans, so the choosing of a day, and it starts with Honorable Sukas. We are operating within a particular timeline. So so that people don't stretch it. We have to conclude exactly as we did today what we must do in order for us to send out, because once we conclude, we're going to need to have that report cleaned, adopted formally, then it's as a draft sent for comment by the person who's a subject of this inquiry, and then it gets tabled to the NA. So I don't want members to stretch as if they have time in their hands. We do not have. We have a program, and we need to, as soon as possible, conclude so that we avoid the delays of Sukas. So I'm trying to hold it back from creating a further delay. Honorable Hermans and Mananiso.
Thank you very much, Chairperson. My surname is pronounced Hermans, not the Afrikaans way that you say it. I'm not Hermans, I'm Hermans. On a lighter note, it's been a long day. Chairperson.
Thank you for that.
Chairperson, tomorrow is, as Honorable Sukas has said, I've also have a program in my constituency tomorrow, so it will tomorrow will be difficult. I would have opted for Monday, but now we hear that there is a difficulty for members, honorable members of the DA. But the rest of the week, I have parliamentary responsibilities, but I'm confident that we can continue if the majority of members are present. Thank you, Chair.
Thank you, Honorable JH. As I quote Honorable Mananiso, you have Sunday and Monday. Honorable Lotrid said if it needs be, she'll be fine with any of those. So if it's not Saturday because you have programs, then we still have Sunday and Monday with us. We don't want to stretch this, and then it gets into other commitments. Honorable Mananiso.
Thank you, Chairperson. Okay, which means mine it's not relevant because I was with Honorable Maneli to say at least Tuesday, because we know some of us on Monday already we have commitment as we are celebrating the last day of Mandela Day. Thank you.
Thank you. And yes, former President Mandela would like you to conclude your parliamentary duty. Honorable Ngola.
No, thanks, Chair. Now that we've got a number of different suggestions, I want to come with a neutral suggestion that will help the progress. I want to propose, Chair, that we sacrifice church and dedicate Sunday, so that the actual drafting starts Monday morning to just work on the report, so that we don't find ourselves delaying ourselves whilst we've been complaining about delays. So I just wish to make that plea, Chair. Thank you very much.
Thank you, Honorable Ngola. There we have it, honorable members. It's either Sunday or Monday, but there's I don't know whether Sunday was part of your caucus, but Sunday is also brought to the picture. what is the take, members? You can't take long on this. It's important that we conclude this work.
Chairperson? Chair? Chair?
Mananis.
Yes, thank you, Chairperson. I think one agrees with Sunday so that we conclude the issue. Thank you.
Okay. Is that agreed by other members as well? Honorable Lotrit?
Yes, Chairperson, I think the less time we have between today and the next session is advisable. So I've checked with our members, it will be fine. Thank you.
Thank you. Sunday supported. Thank you. Honorable Sukas, you're the last one to support Sunday.
I am definitely not supporting Sunday, Chair, but I will have to stand with whatever the committee has decided.
Thank you, Honorable Sukas. Members, I just to my team, you're available for us to do this on Sunday. Thank you. So we agreed, therefore, colleagues, we are doing it on Sunday and we'll conclude it on Sunday. As Honorable Mola was saying, there has to be, once we do that, we need to allow, as we always do in committees, for the cleaning up of that report. The time for Sunday, what is it, 10 o'clock? Is 10 o'clock fine with everybody? Thank you. But being Sunday, it means we'll all be virtual. Is that in order, honorable members?
Then why don't we
those who are,
Order, Chair, in order.
those that are virtual cannot say anything because you are not here. I'm referring to the ones that are here at M46. You're already virtual, so we will join you on Sunday on virtual.
No, I want to propose 9, Chairperson.
You want at 9 o'clock, not 10 o'clock.
Yes, Chair.
Oh.
Let's get the work done.
Is that pushing it? Is that 9 okay? What are you saying?
9 is okay. It's okay, Chair. 9 o'clock.
Yes, Chair. 9 is fine.
Thank you. Thank you. We are therefore agreed on Sunday at 9 o'clock on the virtual platform. As Advocate Mayosi took us through, you will follow those. It also gives you an extra time to just, now that you see this exercise, you use tomorrow and so on to make sure that you sharpen yourself around that, so that by Sunday we become much more smoother than we were today. We want to appeal that you do that. This is your work. You've done this work. Sunday is about bringing it all together. It's really a difficult task that you have been doing, so we can't fail at the end. So thank you very much. The meeting is now adjourned. Thank you.
Thank you, Chairperson. Thank you.
Recording stopped.